Hey, you guys. Good morning. Good morning. I want to do a little roll call and see, does everybody know what happened on Friday? Where Lawn Crime, all the streams ended, and then court had to restart. The camera had to restart. Because I feel like a lot of people may have missed that. So just as a quick recap there, the camera feeds came back on Friday real late. Steele started to bring up how Melnick wanted to come into the courtroom himself. Steele said, I want a proffer, but Melnick said he wants to say things himself. And he's got a 2-hour subpoena. He's willing to come and talk. And Brian Steele doubled down and said that there was, in fact, a confession from Woody that he was the one that killed Donovan Thomas. So if you guys missed that, that was crazy, crazy, crazy stuff happening on Friday. We also had a new motion from Schardt, which we read on this channel, and we clipped it separately. But I think a lot of people just missed that. Because it really, the cameras shut off completely. And then boom, it was just back. And we kind of joke every day, like, should we skip away from the feed? Do we think they're going to come back? And we concluded we were good. We're like, all right, they're done. And then they sure were not done. So just wanted to make sure everyone was up to speed on that. We're going to be looking at possibly Melnick coming in and saying something today. We still have some outstanding motions. Of course, that now includes Max Schardt's renewed motion for a fair and constitutional trial, with one of the remedies being, if that's not possible at this point, mistrial. So, I don't know. What are your predictions, you guys? Hi to everyone that's here already. You guys are excited. You guys are ready. And then thank you so much. I had seen we had a new member. StreamYard didn't star the chat. I don't want to get her name wrong. So let me make sure I can find it. I believe it was Maricela. There we go. It was Maricela. Thank you so much for becoming a member. Use those Mario Kart emojis. And then, wow, thank you so much already, Stephen T. Satchel, for $64. The $64 question. Would a flawed or unartful indictment be error enough to declare a mistrial? Jeopardy attaches or no? Found this on Google. Let me see if I can click this so we can take a look at that. Now remember, Whitaker already denied the motion, or the plea in bar, the renewed plea in bar, and also denied the certificate of immediate review. But typically, with a motion like this, if the jury's already sat, as Brian Steele noted, jeopardy would already attach. So this is what you're referring to here. So from the U.S. Department of Justice, elements of the offense. And then do they mention jeopardy here? There we go. Cool. So the federal rules of criminal procedure require that, and actually, let me make this bigger. Hold on. I'm going to hide this so we can read it. And I think it was Wednesday, you guys, that, correct me if I'm wrong, but I think it was Wednesday, day 104, that Brian Steele was arguing about the flaws in the indictment. The federal rules of criminal procedure require that an indictment be a plain, concise, and definite written statement of the essential facts constituting the offense charged. An indictment need only contain those facts and elements of the alleged offense necessary to inform the accused of the charge, so that he or she may prepare a defense and invoke the double jeopardy clause when appropriate. Now, this is really, in Judge Whitaker's denial, she cited a new case in Georgia. So I don't think it would supersede this. If you ask me, I don't think it would supersede this. Where it said the elements should be understood, even if they're not explicitly stated in each count of the indictment. And really what we're talking about is mens rea. Was it intentional? Was it reckless? And that description, that specific element, was not explicitly stated on the counts that Brian Steele took issue with. And here we're looking right at this. Thank you so much to Stephen. I would think this would supersede some case that Whitaker's looking at that says, oh, it doesn't matter because it should be assumed by the reader that intent to join the gang, intent to participate in gang activity is implied. So, you might be right. It goes on to say, and I'm checking, we've got the screen, the court's not live yet. If an essential element of the offense is omitted from the indictment, it cannot, consistent with the principle underlying the Fifth Amendment requirement that prosecution for an infamous crime be instituted by a grand jury, be supplied by the prosecutor or by the courts. So you can't just go back and try to add it after the fact. It's got to be in the indictment at the time it's presented to the grand jury. To allow the prosecution or the court to make a subsequent guess as to what was in the minds of the grand jury, that's why. At the time they returned the indictment, would deprive the defendant of a basic protection, which the guarantee of the intervention of a grand jury was designed to secure. For a defendant could then be convicted on the basis of facts not found by, and perhaps not even presented to, the grand jury which indicted him. So, and they do go into some case law, but this is a really interesting question, you guys. And maybe I have the portal open. Let me see if I can get the denial really quick before this court goes live. That's the one for resealing filings. And no new filings this morning that I've seen so far, but we'll keep looking. That's the order to deny disqualifying Love and Hilton. Okay, so obviously a quick denial here, but this was on August 1st when Judge Whitaker denied Brian Steele, Jeffrey Williams' renewed plea in bar about these fatal flaws in the indictment. And Whitaker concluded that the court was bound by the controlling authority of Tate, Jesurum v. State, which is a 2023 case where cert was denied in February of this year. So really recent. It's not at the Supreme Court. It's only in a Georgia appeals court. So I don't really think that would... I think there's some room for interpretation here. And if Steele wants to pursue this, unfortunately, there's no certificate of immediate review. But on appeal or something, I mean, this could become an issue we see go back and forth. Great question. Look how much food for thought we got there. Thank you so much, Stephen. And then also want to say thank you to Diane. And yeah, that became a new member. And then you guys, a lot of mixed predictions. I don't know what to expect. I'm not sure it'll be enough to make her feel like she shouldn't move forward. A lot of people were talking about Melnick. I saw Melnick's name all over. We've got popcorn. I saw someone mention Law and Order. And then good morning. Look, you guys are so ready. I'm definitely excited. And as a side note, so you heard me say on Friday, look, I'll probably be in somebody's chat room on Wednesday, when right now it's expected that Kenneth Copeland, the jury is going to come back, and we're going to resume with testimony from Kenneth Copeland, some instructions. You know, who knows how that's actually going to go. Maybe we'll get a delay in that today. But as of right now, that's supposed to be a big day, and Nick Starro's going to be at the airport. He's traveling to the United States. So I'm going to be streaming Wednesday. I'm going to be streaming. And then once he lands, once he finds out that his hotel is good, Thursday, I'm going to be in his chat or something, going back to ordinary business. But just so you guys know. Conditionally accepted, says Whitaker sounds like a fair kangaroo. And hey, Angie, that's okay. We're looking at, you know, what at the top level, this criminal resource manual from the DOJ says about flaws in the indictment. So you missed that, but you haven't missed any court yet. Hiren thinks that Melnick's going to blow up today. Jason agrees. Can you imagine if she doesn't let him speak, but we can hear, like, someone in the background raising their voice in the courtroom because they want to be able to speak. And Vacation Granny, thank you so much for the sticker. Vacation sounds great right now. I want to go on a vacation. We have like such bad weather here. Everyone always wants to come to Florida, but this is not the time to be in Florida. It's so windy. We had like a tornado watch last night. And the weather's been fine. Like nothing's actually happened. But you know, I always think about when people think of vacation, I live in the place where people always want to go to vacation, but I want to go somewhere else. Good point, Michelle. Michelle says last interview Melnick did, he hadn't filed a bar complaint yet, but wonder if he has since. Especially after seeing that June 7th transcript, you guys. I mean, the June 7th transcript was just, it was really disparaging to Melnick. And you're seeing this implication that Judge Glanville and lawyers Love and Hilton are both tracking, looking at everything that's going on in the courtroom, and that they've been doing that since the very beginning, which maybe that means day one of trial. Maybe that means all the pre-trial, the 10 months it took them to seat the jury. But don't forget, they confiscated an attorney's laptop. Like, we just learned in Schardt's motion, it was new to me, I don't think I've heard about it anywhere else, but in Schardt's motion we hear that Judge Glanville tried to hold him in contempt because he was told by somebody that Max Schardt said this it looked like maybe he called it this some BS, that he cursed about the judge or the court. And Attorney Botts was sitting right next to him and said, I heard him say no such thing. Judge Glanville insisted there was video of it, even though there was no media pool in the courtroom that day. And Glanville wanted to hold him in contempt and was telling him, you might as well just admit to it because we have it on video. And Schardt said, how can you ask me to lie to the tribunal? If I didn't do that, you're asking me to lie to you to say that I did it. And there was no video. There was nothing. Like, just think about that. All the way back to the beginning of this trial. I think that was 2023 that Schardt said that happened. Like, just crazy. And then Garrett, good morning to Garrett. Garrett says, how does she think Brady violation now disappears? I don't know. My question for Judge Whitaker is, okay, you have the transcript now, so it's not Brady anymore. Okay, if we apply that logic, what if we have zero confidence that there hasn't been another meeting? And we're looking at the medal, so I'm going to switch back over here just in case it starts. Make myself little. But yeah, I don't know, because if there were other meetings, you can't just cure it by saying, oh, the defense already has a transcript before they're cross-examining the witness. Because if there was a ex parte for Tick that they didn't know about, what then? Oh, we'll give you the transcript now, and now you'll have the transcript. But that witness is already off the stand. We've already crossed them. And there's no opportunity there to cross-examine them on this ex parte that we were never disclosed. So, it's just, that excuse bothers me a little bit because it makes light of how important and how sacred, you know, Maryland v. Brady is. There's a reason, like, pretty much anyone who's watched one trial knows the term Brady and already has at least a vague idea of what Brady refers to. By the time you've watched one trial that's a mess like this, you understand what Brady is. And the judge is kind of laughing it off every time she mentions it. And I think she's pretty fair. I think she's really looking at case law. But I wince when she just brushes off Brady like that. We have some movement. Thank you so much to both Cheryl Graham and to Bianca for becoming a member. And then What, Why, and Who's, good to see you. I know, I was about to say good morning, but you've got to be like afternoon in your time zone towards my Australian holiday. I love that, but oh my gosh, isn't that like a 16-hour flight? I've got to practice becoming not a light sleeper so I can sleep on a flight to Australia. Okay, the sound's not on in the court. That's not me. So thank you so much, What, Whys, and Whos. There we
All
go.
right, I hope everybody had a pleasant, if busy weekend. I'm sure y'all all worked just like I did. I know we have Mr. Melnick outside and he wants to put some things on the record,
Here we go.
and we can do that first off. Is there anything anybody wants to address before that?
Your Honor, after or before Mr. Melnick addresses the court, if the court would be so kind as to just apprise the parties of what it is that we will need to, if anything, address
I mean,
as it relates to what he's putting on the record.
I don't really know. I think that he kind of mainly wants to make a record of what he perceives to have actually occurred. And I don't know that, as I think I mentioned on Friday, I'm not sure that it's particularly going to be relevant to any of the issues in the case, but I'm going to let him make a brief statement or proffer, and we'll go from there. And then the next issue after that I'd like for us to sort out is the representation made by Mr. Steele at the end of the day, Friday, that he has a good faith basis to believe that there may have been an unrecorded conversation at some point that included Ms. Hilton, Ms. Bumpus, and Mr. Copeland that may have resulted in some Brady material. So that'll be next up, and then we'll see after that. All right, so if somebody wants to let Mr. Melnick come on in.
Thank you so much, Dolly.
Yeah.
I would just object to Mr. Melnick coming in, offering anything that is not relevant to the trial itself, understanding what the court's ruled or decided.
Thank you. Yeah, thank you. Ooh.
Whisper, whisper. Is that Adam Abbate? Trying to recognize him from like the back of his head, but that looks like Adam Abate's hair. And Sylvia had said that Friday he was in the courtroom, at least at the end.
Court with 500 screens in front of us.
She got a tissue box. Is that tissue box always there? Is it just a new one? There we go. Look at Mr. Melnick looking all sharp. Yeah, that is Adam. That is Adam Abbate.
Mr. Melnick, if you want to come on up, and I understand that you want to make a proffer of what occurred, I guess, on June 6th and June 7th. Let me just say that, I think it goes without saying that people can perceive the same thing in different ways, depending upon the perspective they're standing at the time. And I am going to permit you to make a brief proffer of what you believe happened. I do not think, based on what I have reviewed, that you were laboring under any conflict of interest. I don't even know that at this point in time, any of that is particularly relevant, but I can understand you wanting to put something on the record. I would like for you to stick to the facts to the extent you can, keep emotion out of it. And go ahead.
So, Judge, basically what it comes down to is after receiving the transcripts from the two ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the district attorney's office, and then with Ms. Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Schardt and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue, because what I would need to produce from a documentary standpoint to rebut these allegations are privileged communications between myself and Mr. Copeland. But my presence, so starting with June the 6th, I sent an email to Ms. Hilton, Ms. Love, Mr. Steele, and Mr. Schardt stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th stating that Mr. Copeland was being given transactional immunity. At no point, and I think what really bothers me is that at no point did anybody from the DA's office before that time, within any relevant time frame, reach out to me and just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
With Mr. Copeland.
with Mr. Copeland that resolved in June of 2023. So
correct.
I know that as of that point, you were representing him.
Yes.
And then following the resolution of that case, he did not have any more pending charges.
He did
correct?
not, that's
Okay.
correct, yeah.
All right, so that was a year ago.
So at a minimum, I feel it was incumbent on the district attorney's office to reach out to me just to ask that question. Now, as far as what communications took place between the DA's office and Mr. Copeland, I don't know exactly. But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity, because it was the state's intended purpose to call him as a witness on June the 7th. And so I was here on June the 7th. I told the court what Mr. Copeland's intentions were. There was a lot of back and forth. Obviously, Mr. Copeland was taken into custody on June the 7th, and then everything that happened on June the 10th. I don't have to go over all that.
Yeah, I've read all of that.
Yes. So my purpose here today is to state on the record that absolutely, nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots, or anything along those lines with Mr. Steele or Mr. Schardt or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that.
Mhm.
It's not an issue at all to this court.
Okay.
All right, thank you.
All right. That's it.
That's it?
All right.
Love is an objection
Okay,
to
Mr.
it.
Steele, you had said to us on Friday afternoon that you had a good faith basis for believing that there may have been a conversation you believe during
Deal has to carry
The
it, you guys, because of
June
privilege.
10th ex parte in chambers meeting at some point when Judge Glanville was not in the room, but between Ms. Bumpus, who was acting as counsel for the day for Mr. Copeland, and Prosecutor Hilton. So can you give me what your basis is for that? Otherwise, we might just move on.
I also had a couple of questions, if it's okay,
All right.
for Mr. Melnick.
Oh, well, I think, may have already walked out. I didn't realize that. I thought this was kind of to let him have a chance to clear the record. What are your questions going to be?
Just about the representations made about an email with a BCC and it
Oh,
was
you can
sent
see Love's face on the
inadvertently.
computer.
I believe that he'll say that that's not accurate. And then we sent your honorable court on Friday all of the emails. If you put them in order.
Yeah,
it does not-
okay. I mean, I've seen it. I think that's fine if you want to ask him that and clarify it. I don't think that Ms. Love made a representation that that is in fact what happened. That was her theory because she couldn't figure out why Mr. Melnick was referring to her in the third person. But sure, you can ask him that.
She asserted it. It wasn't a theory.
Can I just ask you a couple more questions? And Your Honor, I'll move the admission of all those emails, and I have copies for them if that makes it easier, and we can mark them as an exhibit if that's what you want. They were already sent to your honorable court.
If you've got them now and can make them an exhibit, and I'm not sure exactly what courts, you would make them
Sure.
a defense exhibit.
Can I just step back for a second?
Sure.
And Your Honor, would the court be admitting those exhibits for any purpose as it relates to this trial?
No, not for the trial, just for whatever these ancillary proceedings are. I'm not sure what to call them, but motions. So it'll be, I guess, an exhibit to, we can call this a motions hearing. It's today, August 5th, 2024. Proffer by Mr. Melnick.
So, Mr. Melnick, have you looked at and reviewed all of the emails that you have given and the state has given on this topic?
Not-
Do you want me to be sworn? Do I need to be sworn for this? I don't believe I've been sworn.
Not for me. You're an officer of the court.
Yes, I have.
Hang on. Yes, Ms. Love.
You responded to what I was asking.
Okay.
I have.
Schardt
I
with
have
the
reviewed
play call in the ear.
I have to mark these.
Uh-huh.
You give this to the state.
Yep.
You give that to the
Yep.
state. I'm just putting them in
Sure.
date and time order.
Yep, I've reviewed them.
This is not up with that era.
And thank you so much. Army Nurse became a member. That's awesome. Thank you for the sticker, praying Grammy Pammy. And then Graham D. Get the defense to request the body cam footage, and if the security turned them off, prosecute them, and if the judge told them to turn it off, then hold him in contempt. I'm not sure if they would have had that running. Do the deputies wear body cams all the time? Let's ask the chat. So thank you for your super chat. Let's ask the chat. Do the deputies wear body cams? I feel like that's a silly question, but I don't know this court and okay, so they're supposed to.
Forward to, right. 7 for 11:56.
And then not in court, not in chambers. So we've got some yeses and some nos. Good morning, Julio Suave. Love your picture always, every time I see it. Hilton, I think her vacation started. She's gone this week. Okay. This might be the safest answer. Raphael says
No,
they wear
because
body
once you
cams.
judge
I don't think they're
I'm ready
continuously
whenever you are.
recording.
Okay, I thought you were not. All right, and thank you, Your Honor. Mr. Melnick, thank you for your time.
Sure.
What you said to this honorable court is that you represented Mr. Copeland in an unrelated case. Is that true?
That's correct.
All right. Was there any discussion with the Fulton County District Attorney's Office members that you represented Mr. Copeland for purposes of being a witness in this trial that's before the Honorable Judge Whitaker?
Yes.
Can you explain that to us? Honorable
It goes back to 2021. I met with Don Geary, who at the time was, I guess, in charge of the state's handling of this case. And he talked to me extensively about Mr. Copeland, Mr. Copeland's involvement with YSL, and the fact that the state wished to use him as a witness in this case.
And did you make it clear from your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker,
Yes.
as a witness or as a potential co-defendant?
Yes.
Okay. And that the Honorable Court knows, I believe, but to your knowledge, who is Don Geary in 2021?
What he introduced himself. I mean, I knew Don for a long time, but what he said, he was special counsel for the Fulton County District Attorney's Office. He was basically hired almost like in an of counsel position, as I understand it.
And was he affiliated on working this case that's before Judge Whitaker
Yes.
on trial?
We talked about this case specifically.
At any time, I'm sorry.
And nothing else.
At any time, did you or any member of the District Attorney's Office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Okay. Did you ever have conversations with Ms. Love, who is seated to your left,
Yes.
about representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
And was it clear from your standpoint, from your viewpoint, as the court said, people can observe things differently, but from your standpoint, was it clear that you made it known to the Fulton County District Attorney's Office that you were representing Mr. Copeland as a witness or potential witness in this trial?
Yes, it was.
All right. Did you do anything to separate yourself from that representation?
No.
All right. The Honorable Court stated a little while ago, and you left here so quickly, but that your representation ended of Mr. Copeland, I heard, in 2023 when you entered some sort of disposition. I don't remember what it was, before this Honorable Court. And when I say this Honorable Court, I'm talking about Judge Whitaker.
Sure. That's correct.
Did your representation end of Mr. Copeland as a witness in this case? Did
No.
you ever make that known to anybody?
No, I never did.
Did you actually do the opposite?
I was contacted by another member of the Fulton County District Attorney's Office in June of 2023.
And about
Yes,
what?
I'm sorry, about representing Mr. Copeland in this, as a witness in this case.
Were there any agreements between Mr. Copeland and yourself in the District Attorney's Office? Because you obviously got him not to be charged. That's a bad way of saying it, but you obviously did something, or someone did something that he's not charged in this case.
I would honestly say that may not have been due to anything that I did or said necessarily. That I think was an internal decision from the DA's office.
Okay. All right. Now, I'd like to show you what I marked, and I just want this for the record. And I marked it number 1, Mr. Williams. And can you announce it just so the court, and we're going to give all this to the court, what this
Get it
is,
on the
if you
record.
recognize it.
Sure.
And then go to number 2, 3. But for people looking on, just announce it by the title, if you don't mind. If you don't recognize it, please
Yeah.
say that as well.
Now, I recognize this. This is an email I sent to Ms. Love, Ms. Hilton from the DA's office, yourself and Mr. Schardt, dated June the 6th, 2024 at 4:31 p.m. You want me to read it, or?
Sure.
Says, good afternoon. All it has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office nor any law enforcement officer from this point forward. My client will assert his privilege under the
Wait, that's
I
way
am
too
going
fast for
fast,
the
I'm
court
sorry.
reporter to take down.
You with me? Law enforcement, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
Okay. On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use immunity, transactional immunity, any type of agreement?
There was no response from the district attorney's office to this email to me. So I was not aware of any immunity, any offer of immunity to Mr. Copeland at that time.
Did you personally know that if Mr. Copeland testified at this trial without some sort of protection, by protection I mean whatever type of immunity, that he could be making statements that would incriminate himself?
Yes.
No statute of limitations ran, he could be charged?
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm going to overrule that.
I can't say with absolute certainty that I investigated it to the point where I would know whether the statute of limitations would have run or not.
About federal crimes for gun offenses?
No, as far as I know, again, I didn't do extensive research into it, but it's my understanding that it would not have run in terms of the federal statute. And Mr. Copeland, of course, has been charged previously and convicted in U.S. District Court. So the feds, once the feds have their eyes on you, they have their eyes on you.
And how about as a co-defendant in this case being indicted later? And is statute of limitations barred to that?
I don't know.
Okay,
I don't know with absolute certainty.
Okay. Were you concerned that if he testified, when you wrote this email, the one you just announced as Mr. Williams #1, that he could be facing criminal liability?
I absolutely was.
All right. Is that the reason you wrote that email?
Among other things, but that is one reason why I wrote the email.
Was there anything in your mind at the time of sending it that was suspicious or clandestine or by CCing the Honorable Maxwell Schardt or myself on that email?
Not at all. I thought everybody had a right to know.
Okay. And everybody being?
Everybody from the prosecution and the defense team.
Okay. All right. Your Honor, I move for the admission of Mr. Williams #1 for purposes of this hearing.
Admitted.
Can I just get clarification as to which of the emails we don't have a number is Defendant Williams #1?
He read it.
Can you
Yeah.
clarify?
June 6, 2024, 4:31 p.m. to yourself, Ms. Hilton, Mr. Steele, Mr. Shaw.
Does it have the response at 4:57:05 from Ms. Hilton, or is it the one without response?
I don't remember seeing a response.
Okay.
So is there a response on there
There's not a response.
on Williams 1?
There will be, Your Honor.
Okay,
Not
so
on Mr.
that
Williams
has
one.
been, for purposes of the record, the one that does not have the response on it.
Okay. Okay, so here's the response.
But
Is it a part of Williams 1?
No, it's not.
Okay, so I assume Mr. Steele might ask you about the next one. Go ahead.
and that is, I'd like to show you what's in front of you, Mr. Williams, exhibit #2 for purposes of today's hearing, okay?
Mhm. Yes.
Tell us, take your time to look at it. Tell us if you can identify it, if it's true and accurate for what it appears.
I hope this is from Miss, I think exclusively from Miss Hilton to me.
But do you recognize it?
I do, I
Is
recognize
that
it.
accurate?
Yes, it is. Yeah.
Okay. Your Honor, I move for purposes of this hearing, Mr. Williams #2, after you identify it so everyone knows what you're looking for.
June 6, 2024, 4:57 p.m. I hope good as addressed to me. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then it's from Ms. Hilton.
And did you respond to that email? And if yes, is it on Mr. Williams #2? And what does it say in time and date? If you don't.
It is. I did respond. It's dated June 6th at 5:47 p.m. Again, with CCs to everybody in the case. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that you were told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love.
Slow down. Slow down.
I spoke with Ms. Love early in the process, around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
Okay. And the court already admitted number 2. If you could go to number 3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams, number 2.
It's admitted, and that one contains both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat, some withdrawing. Okay. Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it? And if yes, what is it?
It's a,
Your Honor, if we could just have what that is, and we don't have numbers on it, if I could just have in the court what it is that you're even tendering.
I don't know, I don't know how many things you got handed, but Mr. Melnick's about to describe it.
it's dated June 7th, 2024, 11:52 a.m. It's from me to Ms. Hilton and Ms. Love. The first sentence says, here is a communication between myself and Ms. Love, which pertains directly to the YSL case. And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Ms. Love, stating, good morning, Ms. Rosser. The state asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. And I'm sorry, that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case in 2023.
All right, and you're forwarding that in June of 2024 to say, see, you knew at some point I
Yes.
was representing him. Okay.
That's correct, Judge.
Is that document, is defendant Williams a 3-page document or just the one portion of the chain that you just read?
The chain.
So is this is a continuation of
Yes.
3? Okay. There's more to it, Ms. Love.
Is it a 3-page
It
document?
appears to be, I think it appears to be a 3-page document, yes.
Yes?
Save her,
Yes.
Adam.
Okay.
Do you need me to, I don't need to read all of this.
No, I don't think so.
We move for the admission of Mr. Williams, number 3, for purposes of today's hearing.
It's admitted.
Why did you, Mr. Melnick, why did you send this to the district attorney's office on June 7th, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Ms. Love?
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
Yes.
All right. Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this?
I do.
What is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Ms. Hilton and Ms. Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office company that answers my phone for me, where I got a message from Peter Hurzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Ms. Hilton and Ms. Love, demonstrating that they should have just communicated with me about Copeland before questioning him
And go ahead. I'm sorry.
and before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herzog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Hurzog is the assistant DA in the Fulton DA's office.
And
So DA reached
Mr.
out to
Williams'
Melnick.
report's marked as number 4 is sent for that message on June 27, 2023, about 3 months after the March 1, 2023
Yes,
correspondence with Ms. Love about Mr. Copeland.
that's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that what you're
Yes.
asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back to check the
If
date.
y'all have the case number, I can look it up and let you know the disposition date.
I don't have it.
Happy to do that. Nobody has it.
So in
and
other
It
words,
was
the
a 22
communication
SC case, but that's all I know.
probably wouldn't have been for that other
It's fine.
case.
I can probably pull it up some other way. Y'all go ahead.
Okay. And you forward this, you said why? This
To-
message.
To reiterate the fact that the Fulton DA's office knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Hurzog was never involved in the case before Judge Whitaker. I'd never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abbate. And the only reason Mr. Abbate was involved with it, that's Adam Abbate from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Ms. Love, because she.
And Ms. Bond order. Yes, right. And
Same
Ms. Love
reason.
with the bond order. That's correct.
Okay. Now, I'd like to show you Mr. Williams, number 5. Oh,
Can
Your
I-
Honor, I
can I-
move for the admission of Mr. Williams, number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
Close. Uh-oh.
Number 4, a one-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams, number 5. Tell us if you remember that, look at it.
I do.
Okay, and is it accurate?
It is.
Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
Stated June the 7th of 2024. It's to Ms. Love and Ms. Hilton from me. And it is in response to an email that I received. I'm sorry.
That's okay. You can look at the documents, multiple.
Yeah, okay. So this is a part of the same chain of documents where I was referencing the fact that Ms. Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March the 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And then so the last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Schart's client, neither of whom I've ever met or have any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Schardt do anything?
No.
Did anybody come to you, at you, about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville,
Yeah, I would
grant your
object to
client.
the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote or what I.
All right, well, I don't know yet what the end of the question is going to be, so I'll hold your objection until I hear the question.
And it's in the record. Already, Your Honor, I could get another copy though. Ms. Love wrote in that motion seeking use immunity under 25-5-507 for Mr. Copeland.
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission Williams 5?
I do. Yes.
All right, that's admitted.
Thank you, Your Honor.
And Williams 5 is what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are
questions.
you asking?
for
Hang
you.
on, hang on, Mr. Steele. What are you asking?
Just
What it is?
Which one is it? Yes.
It's
Just
the last
part
one
of
they
one page?
discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just, could the court ask for clarification, just one page or?
I don't know.
4 pages.
4 pages.
Mr. Melnick, were there any BCC? You know what a BCC is?
Yes.
Okay, I apologize.
Oh, blind
Yeah.
blind copies.
We're all old enough to know that that
Right.
means blind carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC don't know.
Yes, I did not blind
Mhm.
copy anybody on that last email.
So
I just
love's
sent it to
theory
Ms.
or
Love.
accusation
Any
wrong.
other-
I told him it's up.
I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
All right. I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right.
Hey,
I'll let
love.
Mr. Schardt go.
And those are the court's copies.
Okay.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
Okay, Schardt.
Um, As part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland. Yes, sir. Did you also make it known, did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation, to your knowledge, and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would have happened.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I will be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes,
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week leading up to June 7th of 2024?
Yes, let me ask in a more precise manner.
Mhm.
Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes,
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called me.
Could you say it again?
You called me.
You being
Yes.
Max Schardt?
Yes,
Okay. And I called you on the telephone?
yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question, please?
In your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's law school 101.
And is that what I did on Thursday, June 6, 2024?
Yes,
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yes.
throughout this entire period, correct?
Mhm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
to my knowledge, no.
Okay, after you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
I have nothing further. Thank
All
you.
right. Any other defense attorney with questions for Mr. Melnick?
Good supplement from Schardt.
All right, hearing no other. Go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, I'm just gonna be a little bit brief and I'm gonna clarify some things.
Clarify.
Is Defendants Williams exhibit. Yes, Mr. Hart.
Or speak just more loudly.
Fair.
Or come around and, yeah,
You know what? I'll take the stand.
okay.
He doesn't want to stand next to her.
You can leave them there.
Okay.
That's okay.
Does somebody have a copy of those exhibits for the court?
Judge, I'll give to the court the ones that he has admitted, and I'll just go ahead and use the ones that I have copies.
Okay, thank you. Just pull that mic down towards you and make sure the green is on. Mr. Melnick.
Oh,
Should be some button somewhere.
You see where it is? I don't actually see it. It sounds to me like it's on.
Sounds like it's on. All right, go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, in your honor, I'm going to use, unless the court instructs me otherwise, I'm going to use the copies that I was given, that I've marked as defendants the way that they've indicated they should be marked exhibits.
Okay.
Okay. Mr. Melnick, I'm showing you what is the copy of Defendant's Exhibit 1
Yes.
that was given to the state and to the court. Is this an exact copy of Defendant's Exhibit 1 that I'm showing you?
I believe so. I mean, I haven't printed them up. I don't know if there was another email that was.
Y'all are welcome to just use these if you want. That doesn't need to be an issue. I mean, they were handed to you, Ms. Love, by Mr. Steele, right?
Yes, Your Honor.
All right, then they ought to be exact copies.
May I refer to them?
Just a second. Mr. Harvey, yes, can you not hear? Oh, me? Okay, sorry. I was just saying, I'm sure that the copies are the same, unless, but if she wants to use the admitted copies, she can. I'll trade you. How about that?
Yes.
Just make sure you get the admitted copies to the court reporter when we're finished with this.
Yes.
Thank you.
So showing you what has been admitted as Defendant Williams Exhibit Number 1.
Yes.
Looking at Defendant Williams Exhibit Number 1, is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
Okay. Then I'm going to show you Defendant Your Honor, I just may need the portions that I gave to the court because I don't see.
All right, here you go.
Yep. Thank you. All right. All right. Showing you what I will mark as State's Exhibit 1, copy of Defendant Williams Exhibit 1, Melnick Proffer. And I was provided this by Mr. Williams, Your Honor.
By Mr. Steele.
Yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a one-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be, there may have been a prior email, but I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as Defendant's Exhibit Number Defendant Williams Exhibit number 2. Let's see if those two match. Give me 1 second, okay? Defendant Williams Exhibit 2.
So that was all she had about one?
So you'd agree with me that
So-
Defendant Williams Exhibit 2 is in fact the top portion of the email that I have labeled and tendered as State's Exhibit, or not yet tendered, but labeled as State's Exhibit 1.
Yes, that's correct.
Your Honor, the state tenders State's Exhibit 1 just as evidence.
All right.
So they're combining it into
Now-
one exhibit.
Thank you, Deb. So looking at Defendant Williams Exhibit 2 and State's Exhibit 1, are you able now to say with any more clarity that Defendant Williams Exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within Defendant Williams 2 and State's Exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up. I wasn't there in his office when he did that or whenever somebody in his office did that. You are correct that what has been marked here as Mr. Williams Exhibit number 2 is part of a chain of communications between myself, yourself, Ms. Hilton, Mr. Steele, and Mr. Schardt. Looks like there's a CC to Antonio Long as well. Yeah, so but these emails were sent after the State's Exhibit 1, which is also Mr. Williams Exhibit number 1. These emails date, so you can see here, Ms. Love, this is dated June 6, 2024, 5:47 p.m. Yeah, this is dated June 6, 2024, 4:31 p.m. Right. So this is just part of the same line of communications that we were having, where I said, Mr. Copeland doesn't want to plead, doesn't want to testify, wants to take the fifth. Ms. Hilton responds, and then I respond to her response. And in her response, this is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled Defendant Williams Exhibit 1, did you ever forward that separately to Mr. Steele or Mr. Schardt?
I think I just forwarded, I mean, I wouldn't have had to because they got the emails. Right,
Okay.
so they got this email initially.
All right, y'all, when y'all are saying this email, we have no idea
I got
what
you.
you mean. Can you refer to the exhibit numbers?
They got Mr. Williams' email number 1, exhibit number 1, which is the first email from June 6th at roughly 4:30 p.m. Then there was a response from Ms. Hilton, June 6th, 4:57 p.m.
And that's marked Williams 2.
Williams 2, thank you. And then I respond to that, June 6th, 5:47 p.m.
Okay, so
And that's also on Williams
2,
right?
yes.
Yeah, okay.
so as it pertains to my original question, Defendant Williams Exhibit 1 was never a communication that you sent separate from the emails that are contained in Defendant Williams 2 and State's Exhibit 1. Is that wrong or right?
That is wrong.
Okay, so you sent, without forwarding the rest of what is labeled as Defendant Williams 2 and State's Exhibit 1, you sent an email that contained only the document that is labeled Defendant's Exhibit 1 to Mr. Schardt, Mr. Steele, Ms. Hilton, and myself.
I sent it on June the 6th at 4:30.
Right. And do you also see June 6th at 4:31 p.m.? And when you say 4:30, you do mean 4:31 p.m.?
Yes.
Do you also see June 6th, 2024 at 4:31 p.m. on the email State's Exhibit 1?
Yes.
And in fact, the email State's Exhibit 1 is at the bottom, meaning it came before
Yes.
the emails that were Defendant Williams Exhibit 2.
That is correct.
Okay. And so given that State's Exhibit 1 looks as it does, are you saying that the email that is Defendant Williams 1 is the entirety and not a part of any other email chain that you
This,
sent?
this email was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams' exhibit number 1.
Okay.
Was the first email sent on June the 6th of 2024.
Okay.
That is the first email. Mr. Williams' exhibit number 2 is the continuation of that chain of emails in which Ms. Hilton responded to me, and then I responded to everybody else, including yourself.
Thank you for clearing that.
Mhm.
Your Honor, I'm going to give back to the court's copies of the emails.
Okay.
So we learned how replies work.
And I apologize, they're not.
That's fine.
You were asked, Mr. Melnick, about,
Oh,
you were asked by Mr. Schardt.
the
how
mics
did you
are
become
rejecting her.
aware that the state was talking to Mr. Copeland?
Okay, let's try to figure out where that squelch is coming from.
Might
and
be from
maybe-
me. I may have been too close.
Okay,
to the
where's
microphone.
state's one, Miss Love?
And Your Honor,
If
if the
you've
court
got-
didn't, I would ask him to.
Yeah, you did, it's submitted. Thank you.
Did we clear up the squelch? Is it gone? Okay.
It seems to be.
Is it the court's mic? Okay. I'll step away from it so that I'm not echoing.
Please.
Mr. Melnick, do you remember Mr. Schardt asking you, how did you become aware that the state was talking to Mr. Copeland?
Yes,
And did you understand that question to me in 2024?
leading up to June 7th of 2024, yes.
Did you answer how you became aware that the state was talking to Mr. Copeland?
I did,
How did you become aware?
because Mr. Schardt told me.
Okay. And when Mr. Schardt called you, was that the first time that you were aware that the state had been talking to Mr. Copeland?
Since, I mean, I was aware of an interview that took place with, I think it was investigator Viverito. I don't remember the date of that interview, but it was during a time when I was representing Mr. Copeland. But other than that particular communication, that was the first time I became aware of any direct communication between the district attorney's office and Mr. Copeland.
And when you speak of the interview by investigator Viverito, was
Mhm.
that while she was with the DA's office or while she was with the Atlanta Police Department?
I do not know.
And was that interview one that you have seen or have knowledge as a part of the discovery in this case or something different?
I have knowledge of it. I've never seen the interview. I know that it exists.
And was that interview a formal interview while he was in custody at the jail?
Yes, as I recall. I mean, I haven't seen the interview, but I believe he was in custody at the time.
And did you give permission for that interview? I'm gonna turn this off.
Just speak loudly.
Did you give permission for that interview, or did Mr. Copeland reach out to investigator Viverito to talk to her?
I have no idea. I did not give permission for that interview. I do not know if Copeland reached out to her or not.
And had you been paid by Mr. Copeland or retained by Mr. Copeland to represent him on criminal charges at that time?
Yes,
And was that prior to March of 2023 that this interview took place?
yes.
Do you recall at any time representing to any member of the district attorney's office in 2023 that Mr. Copeland had not paid you for your services?
No.
Do you recall telling a member of the district attorney's office that you were not representing Mr. Copeland on his criminal charges because he had not paid you? I'm just asking if you remember. If you don't, that's
I
fine.
don't.
Okay.
No, I represented him in his criminal charges to the end.
We understand.
Do we?
And when Mr. Schardt called you, what was it? What did he say to you exactly?
He said that Mr. Copeland was being called as a witness the next day, June the 7th of 2024.
So at what point how did he tell you that the state had been talking to you?
During the course of that conversation,
What did he tell you exactly?
He just said that the state's been speaking to Mr. Copeland.
How many times have you spoken with Kenneth Copeland between the time that Mr. Schardt called you and the time that you resolved his criminal matter before?
How many times did I speak with him between June of 23 and May of 20 or June of 24? I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes.
And during your communication with him, did he always have access to your phone?
Always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I don't feel comfortable.
I can stop and pull that question all the way back.
All right.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland?
I'm not going to talk about anything I said to Mr. Copeland,
I'm
period.
sorry,
I'm not going to talk about anything
that's fine.
that I said to Mr. Copeland.
Okay. Based on how you have already testified, is it safe to say Mr. Copeland didn't reach out to you and say to you?
I'm not going to talk about any communication I had with Mr. Copeland.
Do you have any idea why it would be Mr. Schardt who first alerted you that the state was talking to Mr. Copeland?
No.
And are you aware of any communications Mr. Copeland made to state as it pertains to your representation of him after his criminal case was resolved?
I'm not.
Do you recall, you indicated that you spoke with Mr. Abbate of the district attorney's office regarding Mr. Copeland as a witness in the case that we are in trial on now.
Yes.
Do you recall telling Mr. Abbate that you were not representing Mr. Copeland beyond the criminal case?
No.
Was the time or times that you spoke with Mr. Abbate in the context of resolving or getting a bond for Mr. Copeland's criminal charge?
It was primarily with regard to the bond and the underlying criminal charges. I don't believe Mr. Abbate has much, if any, involvement in this case.
What is your recollection of what it was that you said to Mr. Abbate or anyone else regarding your representation of Kenneth Copeland beyond his criminal charges?
I don't really recall having, other than the fact that, you know, he's talked to me and I've talked to the state, I don't recall having in-depth conversations about it. Y'all were still in the middle of jury selection. It wasn't much of an issue.
Understanding you don't recall having in-depth conversations about it, what is it that you recall telling Mr. Abbate or any other member of the state about your representation of Kenneth Copeland beyond his criminal charges?
I don't really have any independent recollection of anything specific.
How are you then able to say that you spoke with members of the state and told them that you represented Kenneth Copeland in his capacity as a witness in this trial?
Because I had specific conversations with Don Geary about this case and about Mr. Geary's desire to use Mr. Copeland as a witness.
Am I correct that that was pre-indictment?
Yes.
And am I correct that that was at a time when there was at least a prospect that Mr. Copeland would be a defendant and not only a witness?
That's correct.
So apart from the conversation you had with Don Geary pre-indictment, where there was a prospect that Mr. Copeland would be on the indictment, do you have any recollection of conversations that you had with members of the district attorney's office regarding your representation of Kenneth Copeland as a witness in the current case 22 SC 18357?
Ms. Love, we did not have substantive discussions about what his testimony would be, but everybody in your office knew that I was representing Kenneth Copeland.
With respect, I don't mean substantive. I am asking you simply, Do you recall what it was, if anything, you said to either Mr. Abbate or any other member of the district attorney's office regarding your representation of Kenneth Copeland as a witness only in the current case 22 SC 1835?
Just that I'm representing him.
And you recall specifically saying to some member of the DA's office, apart from the criminal charges that you helped resolve in 2023, you recall saying to a member of the district attorney's office, I'm representing Kenneth Copeland as a witness only in the YSL trial.
I said that to you, okay?
That is your memory.
Yes.
Where was this? Was it on the phone?
Yes.
Okay.
Oops.
And what was it? Was it before or after Mr. Copeland resolved his criminal charges?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did you say about your representation?
I said that I was representing him, and if you want to talk to him, talk to me.
And when you said you were representing him, isn't it true that you were talking about this criminal charge?
No, Miss Love, it's not true.
Did
And
you state that you were representing him beyond this criminal charge?
Had you finished your answer?
that's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the 22 SC 183572 case?
Yes.
Outside of the criminal charges?
Yes.
Oops.
And did I hear you say that it was your testimony that you never once indicated that Kenneth Copeland had not paid you and you weren't even representing him in the criminal case?
No.
So is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Copeland
About what?
about his criminal charges?
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
That wasn't the question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland, okay?
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client, okay?
And if you would mind answering whether or not you recall it.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway, so let's wrap things up.
Yes. When you spoke about Mr. Hurzog and you said he's never involved in the case, do you know what it was that he was talking about?
He was calling me about Mr. Copeland testifying in the YSL trial.
And you spoke with him
Yes,
and he said that?
yes.
And what did you tell him?
I told him that Mr. Copeland didn't want to testify.
Now, that was in March.
That was in June of 2023.
And did Mr. Hurzog ever say he was working on that trial?
That was my understanding of the purpose of his call to me.
Did he say he was working on it?
Yes.
You indicated, and Your Honor, I have about 5 more questions.
All right.
You indicated that upon questioning by Mr. Steele, that regarding the district attorney's office communication with Mr. Copeland was Mr. Copeland's criminal exposure and that the DA's office was seeking use immunity. And that you considered it ironic that a motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying
I
that?
do.
You never once asked the district attorney's office what protections the immunity afforded to Mr. Copeland.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms. Hilton in the presence of an investigator that you had never heard of OCGA 245-507?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him immunity.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally, in writing to the email that is labeled Defendant Williams Exhibit Number 5, you wrote, "My concern is for my client. Had I been involved, I would have demanded
He's gonna read
a
it.
much more specific immunity deal.
Mhm.
You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client."
Yes.
So what specifically did you intend to, you didn't include in here anything particular that you were to worry about with the immunity deal, but you were very specific about Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Now, are you asserting that he is in danger for any member of the state from testifying?
No.
And what specifically did you want, more specifically, in the, because you do understand it's not an immunity deal. We can't use anything he says in any way against him.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he had received that, what much more specific information did you want to see in the meeting?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity for anything he was asked about criminally, whether it was from the state or the defense?
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him to prosecute him regarding those matters? You didn't understand
It protects him from his testimony at trial being used against him, Ms.
that?
Love.
And anything derived from that
And anything
testimony?
derived from that
You're aware of
testimony.
Let's speak one at a time. Anything derived from that?
Testimony. Are you aware of that?
Yes, ma'am.
So given that Mr. Copeland could not be prosecuted for anything he testified about criminally, and the state could not use his testimony to go seek additional information or reasons to prosecute him,
But you already know it.
what is it that you would have been seeking to get?
So we are
Privilege.
getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all in the state.
Yes.
And could you tell us just why it is that you would have felt that that was
I think that's,
something that should have been avoided?
I'm not going to get
even
into
if it
that.
did not?
I'm not going to get into that, Ms. Love. I'm not going to get into that.
The judge should say something.
Yeah, I think that's all that I have to think.
All right, is there any
Holy
further
moly.
questioning? Okay, Mr. Melnick, this time you can actually go. Thank you for your time. All right.
What a
All
train
right,
wreck.
let's move on to the next issue. All right, we're done with this, right? Everybody satisfied?
The camera.
I was just proper on the record, and without calling unless the court finds it necessary, that the lawyer who was.
Okay, in just a second. Yes, sir?
I do not accept any proffer by Ms. Love. I've told the court that before, but that remains.
All right.
I'm rejecting it. If she
No,
wants to
I'm not.
testify, then that's fine.
Don't talk while somebody else is talking. Let him finish. Let me rule. Then you can go ahead. I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not. It's for the court to accept or not. Go ahead.
That Mr. Abbate, who was earlier president in court, was on the call that I think Mr. Melnick referenced that he had regarding, he said he was spoken to Mr. Abbate about Mr. Copeland and his representation of Mr. Copeland as a witness in this case. Mr. Abbate would testify that Mr. Melnick specifically and explicitly said that he didn't want to have anything to do with this YSL case, that he was not representing him in his capacity as a witness in this case, and that when he was dealt with the criminal charges, that was it. I believe that he made some reference to a used car salesman or something like that. I don't remember exactly, but if necessary, I will bring Mr. Abbate back at some point to testify.
All right, well, if I am presented with a motion that makes that testimony relevant, then we'll hear from him at that time. My point in all of this was just so that Mr. Melnick could feel like he'd cleared his name. All right. Okay, so anybody need a restroom break before we move to our next topic? All right, let's take 12 minutes and be back at 10:30.
And Your Honor, there's
Love said, please.
omitted parts of the transcript. I just want to let you know before we. move
Okay,
on.
here we go. When we get back, I
Omitted
guess.
parts of the transcript. Yeah, that's what the next topic's going to be. Yes.
That's going to be good. We got a little suspenseful 12-minute break, and we're going to talk about omitted missing parts of the transcript. So, break. Now, guys, a big part of what we were hearing this morning, if nothing else, it's for the record. It will be on the record. And a lot of you guys were noticing it in the chat, but it seems like either what Love was doing was because she was really reaching, or maybe she was trying to have something in the record that looked confusing or uncertain. But ultimately, what did we get out of that? I think she made it worse for herself. Because she ends up getting Melnick to say, on the record, and there's really no rebuttal to it, that I told you, Miss Love, I told you I was still representing Kenneth Copeland. You specifically, personally, knew. All of that questioning, and we get something out of it that looks even worse. We get even worse for Miss Hilton, Miss Love, the state. Yeah, Ian just said it too. She, meaning Love, buried herself in such a deep hole. She really made it worse. It would have been one thing if she went up and just tried to blather and just kind of muddy up the water. But I think she really made it worse. Linda says, great for a bar complaint, in my opinion. And hey to everybody that's just joining now. We just watched, Melnick. He took the stand. He was at the podium until Love got next to him at the podium, and he said, I'll get on the stand. He just beelines it, goes, sits down. Oh, that was funny. We had the judge twice There were a few times she made comments to the state, but there was twice where she really barked at Adriane Love. And that was, oh my God, that was good. That alone was worth it. And then Melnick comes back and says, well, that's law school 101. Saying that, you know, is it appropriate for us to try to be contacting a client if he may be a witness in a case? Love tried to object. And the judge was like, I hope every attorney in this room understands that that's acceptable. Oh my gosh. Yeah, okay. This is a better way to put it. So Ian says, not even, don't ring a bell and then try to unring it. Oh my gosh. Kels, thank you so much, by the way. You became a new subscriber and here to stay. I like your style. Thanks so much. You know, let us know what you're thinking as we go by these fun moments with Love. Judge Whitaker saying, hold on, don't go into privileged territory. Like, just dumb. And honestly, even if you know an attorney can't answer because of privilege, the questions she was asking, and of course this isn't in front of a jury, but the questions Love was asking that tiptoed or barged into privileged territory all kind of had the inference behind them that Kenneth Copeland may have done and or may have confessed to, or may have just said he did something, whether truthful or not, something much more egregious than would be protected by a 5-year look-back window in a statute of limitations. I don't even know why Love would want to tiptoe on that territory. Just crazy. But who knows? And then, okay, so I had started this comment earlier because we were debating about, you know, do these deputies in the courtroom, do they have body cams? Are they running? Would they be running in chambers? And a boldface whopper, one of my favorite names to see in the chat, they had body cam of one of the defendants getting searched, Lil Rad. So there you go. That would have been something in courtroom. Maybe it's something they turned on because they knew they were about to search him. But at least at some point, we know for sure they have some body cam footage in the courtroom because they searched one of the defendants. And then Legally Brown Girl for $1.99 says, may it please the super chat court. Thank you so much. Let us know. Are you in law school? Are you a lawyer? Do you just like law nerd stuff? Let us know because I'm looking at your username. And then Kel says if unprepared was a person. And it's so funny you said this at 9:48 a.m. But if you had said it at 10 or 10:10 or 10:15, I think it still all would have applied. Twins' dad says, it's funny how Love is acting like the defense and Melnick can't be trusted when she's the one who's been untruthful. Well, and that's why it was such like a pushback to be like, I told you directly, Love. So this 15 minutes of questioning, all based around, you know, Love is trying to create confusion about whether or not somebody at the district attorney's office should have known or should have reached out to Melnick. And then after all of it, Melnick's just like, I told people knew, it was on the record. People knew I was representing him. Yeah, there may have been a payment issue, but I still represented him through completion of the criminal action. And I still represented him after that. I have communication. My line of communication with Copeland has been open. There's never been any issues with our communication. And then Love goes, but did you tell anyone directly? And he goes, I told you. Like, come on. Come on, come on. Mahadi de Jesus, good to see you this morning. She is crowding Melnick. Guys, that part, I don't know what was worse. Watching her stand at the witness stand screaming right in Melnick's face, because it was really loud the way she was speaking. Or when she went over to the podium and the mic was screeching the whole time. Like, it just didn't get any better. And thanks, Kels, for becoming a member. You guys know when you're a member, you get the Mario Kart emojis. You can race amongst yourselves. Pierre, this is so funny when you sent it. That's her actual voice squeal. And then I bookmarked this because the chat has been killing it. Thank you guys so much for wishing Drea, who is a great and very much loved mod here, a happy birthday. She'll be celebrating her birthday this weekend. But in the chat, we're going to celebrate her all week. So thanks so much. I saw you guys. The balloon emojis, everything. Thank you for wishing her a happy birthday. And then Mahadi for the 5, thanks so much, says, Melnick just said it all. Your office knew Woody had counsel. And all of that, her point of questioning was to try to muddy that, and it just got worse. Pierre's giving a new name. Instead of CDDA Love, it's now CDDA Squeal. Sonia Ness. Exactly, Kat. Wasted all of that time trying to cover her lies. She never gives a yes or no answer when that's all that's needed. The point was made. They knew. I think she repeated that point over and over and over. Thank you so much for the 10. And then Dublin Mug. Okay, so I think we're getting clarification on the body cam. So thanks for the super chat. It wasn't in the courtroom. They body searched him in the back, and they basically ripped his clothes off searching for something. Was it in the courthouse, though? So, right, it was still in the courthouse, and it was one of the deputies that had their body cam on. So they weren't filming in the courtroom. But we did get some body cam deputy action outside of the courtroom, but within the courthouse. So it seems like there may be, you know, times they're supposed to switch it on or switch it off. I wonder if there's like, I could just read the written camera rules of this courtroom. Maybe I can Google it. Because we're all like, ooh, how does this work? Yeah, and that's a good point too. See, Travel says judge sees the motions coming tonight. We're going all day, chat. And you guys, just so you remember, I'm going to try splitting it into 2 parts. So a morning half and then an afternoon half when we come back from the... Judge Whitaker likes to take an hour and 20-minute lunch breaks. So I think she aims for an hour and a half, but she'll shave 10 minutes off because 10 minutes were used somewhere else. So I'm going to split it into 2 videos today. That way, if anyone wants to come back and look at a part, they're not navigating through like a 9-hour block. I can have my own little convenience comfort break, you know. And we're talking about Lil Rod being searched. That was Lil Rod. And then Yolanda says the best part was when Love went to the stand by Melnick. He said, Judge, I'll take the stand. That was so funny. It was almost like a cartoon skit, like a sitcom skit. Yeah, and I think Love was rattled too. I mean, she put a lot of focus. I mean, she spent a good 10 minutes just trying to make an issue about Exhibit 1 and Exhibit 2 by the defense not being combined. Like, she wanted the reply to be part of the same exhibit. And then the court and then Melnick had to school her on, do you see the date here? This one says June 6th at 4-something p.m. And then this one says June 7th at 11-something a.m. like we can distinguish why they're different. Oh, that was a time. Yeah, trick him with the seal. Anthony points out that Love gets faster and louder when she's rattled and annoyed. Guys, how different do you think this would have gone if this was a Glanville hearing? Yeah, Love is reaching. The camera's shaking, but I guess that might just be when the media pool sits down. Like, if they leave the room and then they come back in, maybe they, like, bump into the camera and that's why it shakes. My brain always wants to think they're about to start repositioning it to the bench. And don't forget, didn't we have, like, a big audio check Friday? I know it was for the headphones. They can hear the exhibits. Everybody in the courtroom can hear the exhibits as they're being played on the screen. But then we're struggling with the microphones today so badly. I guess really only Love. It didn't squeal. I didn't really hear it squeal when Melnick and Steele were at the podium. Simsima, who's got the keys to my Beamer? The 585. Shout out to Rochester. And then Mr. Held says, the camera usually gets turned on once they engage someone via detained or traffic stop. Yeah, so that's what I'm thinking, you know, maybe it works the same way with the deputies in the courtroom. As soon as anything of relevance happens, you know, they've got to flick that on. And it reminds me, you know, they're obviously aware of what they don't want to record because one of the deputies had gone around, apparently instructed by Judge Glanville, on the day of June 7th, to warn the media in the hallway, anybody in the hallway, don't record this. Reporter Chidi had written it in his Substack, or maybe he uses Medium. It's either Substack or Medium. But Reporter Chidi was like, look, this is weird. I have a Rule 22. I even tried to go to the judge about this to try to make a record of it, but a deputy came to me and said I couldn't record. I couldn't make recordings of Kenneth Copeland, this new witness, being taken away in handcuffs in the courtroom, in the courthouse. So the deputies are at least aware of what shouldn't be recorded. That's what I take away from that. And in that case, they said it was at the direction of Judge Glanville. So just keep that in mind when we have this conversation about, you know, deputies may have recorded something with the body cam, but there's times where they know to turn that thing off. It's probably off by default and then turned on, as Mr. Hels is getting at here. Yeah, like, that's right. Don't record this. Cool. Okay, so Jay Capozzi, good to see you. I saw you in the chat mention you had some, you know, because you're over in Miami and the water is making trees knock down from Storm Debbie. So hopefully you're good and don't have to deal with much cleanup. Miami can flood really bad. Some of the videos of Miami, like, people will be out at the club and then, like, their cars, they're like driving through. They got like low cars driving through floods. Couldn't be me. So hopefully you're doing well out there. But Jay Capoti says the cameras turn on automatically for different reasons, like when they draw their weapons or tasers, or they start running, and when audio gets loud, it all depends on, and I'm going to look for a second comment. But that's really cool. I didn't know that. And maybe that's some districts. Maybe some districts have the technology that does that. Maybe. Maybe it's not everywhere. And then Sabata, I think you said something that made me laugh. I forget what it was though, but I put it up while I didn't want to talk over anything. But here you're saying I work with sound. The frequencies Love projects with her voice are literally messing up the mic. If you shout, you often get feedback. It really is Love's voice killing the mic. It's science. The thing that we made a joke of in the chat is apparently science, you guys. Like, that's crazy. Okay, cool. Yeah, so as noted, some of them the body cams turn on if they draw weapons. That's really cool, really smart technology if you ask me. I guess the downside is you get those, if that's when it's turning on and there's a reliance on, oh, it'll turn on when necessary. Then we're relying on it turning on at a point where we might miss the you know, moments leading up to why I'm drawing my gun. So kind of a silver lining, kind of like got some downsides there, but cool to know that the technology exists at all. Because the reverse would be, if it's not turning on automatically, it might not get turned on at all. I've got a lot of thoughts on body cams though, because I think sometimes body cam, you think video footage should show us everything, and then video footage doesn't show us everything. So I don't know if like body cams always give us the accountability we think it will. But it would be interesting if there was more. I get why Chambers is a sacred place. But at the same time, issues like this kind of make you want a bit more transparency. That's what I'm thinking. And how interesting is this? Let's look at Black Butterfly's point here. What else would Brian have if he says it's not the full transcript? Brown has the recording, I bet. So speaking about Deputy Brown, who's apparently the deputy that initially told Brian Steele they were in this June 10th ex parte meeting. Now, think about the Max Schardt motion the renewed motion for a fair trial that we looked at on Friday. Think about that. In a footnote, he goes into detail about how Judge Glanville called him into chambers and said, I have this video of you. Someone overheard it. You know, my best guess is that he expected maybe a deputy standing behind it. When we get the camera panned to where the defense is and it turns to where Steele and Schardt are all sitting in the back, there's usually at least one deputy standing behind that final table. So something that crossed my mind is, well, what if Judge Glanville in this conversation with Max Schardt was referring to a deputy and trying to imply that one of the deputies may have recorded it. Schardt only challenges the idea that, you know, there was no video ever produced. I didn't say it. The media wasn't recording at that moment, that day. But what if Glanville in his head, because he's mentioned he's been tracking people from the start, what if he's had these deputies have their cameras on when they're near the defense table? What if they have audio? What if they actually have audio of this meeting? So I don't know how the deputy would have accessed the recording necessarily. I don't know if that's something they can just access on their own.
Okay.
And we're back, you guys.
Mr. Steele, move into our next topic.
I think,
Okay.
I do need to get. Could you please admit me to the Zoom?
Oh, I guess if Zoom's relevant, I better get on the Zoom also. So give me a second to do that also.
Weinstein with the power red tie.
I'm pretty Zoom illiterate, so I may need a little assistance.
How can anybody be Zoom illiterate in this day and age after
Well,
all of our COVID era Zooming?
I know enough to not turn myself into a cat.
Okay, if you can let me in, and I guess. Are we going to be hearing from somebody over Zoom?
I just have a brief TikTok that I need to play.
Really?
It's very brief.
Oh my God, is it Woody?
Okay.
Okay, your whole case is built on
Well, this
social
is
media
part of the
posts.
proffer, so it's your choice. I can do it or I cannot do it.
I
Your
have
Honor.
no idea what it's going to be.
I can tell you what it will be.
Why don't you tell me first?
Put it on the
This will
record.
be a TikTok of Mr. Copeland speaking to Ms. Bumpus, where
Okay.
Mr. Copeland acknowledges that what is in the transcript the transcript is not complete from the June the 10th meeting.
Did Mr. Copeland read the transcript?
I don't know what Mr. Copeland has
Okay.
read or not.
So
If you don't want to hear it, then I can just do my proffer, Your Honor.
I mean, if that's what it says, it shows Ms. Bumpus talking to Mr. Copeland.
Believe it or not, yes, Your Honor.
Okay, and Mr. Copeland says, whatever. I mean, I don't care. Play it.
You can take it for what it's worth, Your
Yeah,
Honor.
I'll just,
Let me just, if I can begin with my proffer, then I can play this,
Okay.
Your Honor. It is my understanding, based on my conversations with Ms. Bumpus, that while the transcript may be, let me be more specific, the transcript of the June the 10th, 2024 ex parte meeting, and I'm not going to list everybody that was in the meeting, but that transcript was complete in the sense Bill was in the room
mhm.
and the court reporter was in the room. I have no basis to believe that that transcript is incomplete for when Judge Glanville was in the room. But there was a portion of that morning, a significant portion of that morning, based on my understanding, where it was Ms. Hilton was in the room, Mr. Copeland was in the room, Ms. Bumpus was in the room.
And how is that your understanding? Because I don't see that from the transcript. And I know I actually said that at some point, but I went back and looked, and let me reference y'all to, let me find it. All right, so the beginning of the transcript, it is just other than, it is, if we all look at page 3, President Chambers were Judge Glanville, ADA Love, Attorney Bumpus, Court Reporter Weaver, and investigators Long and Hamilton. And then they have a conversation that goes through page 22. On page 23, the proceedings stood in recess from 9:34 to 10:03 because just before then, they had decided to get Mr. Copeland in and Miss Hilton in. So when they go back on the record at 10:03, this is reflected on page 23, it's Judge Glanville, ADA Hilton, Attorney Bumpus, Court Reporter Weaver, investigators Long, Hamilton, some deputies, and then at some point, Mr. Copeland expresses that he might want to call his sister, and on page 36, Mr. Copeland says, this is not the sister, can I speak with her for a second, meaning Miss Bumpus? And it shows that Judge Glanville, ADA Hilton, Court Reporter Weaver, and the 2 DA's office investigators leave chambers at 10:17, return at 10:33. Then Mr. Copeland has a question for the court. And then on page 46, a sheriff's office person comes in and tells Judge Glanville, we have a security issue. We need to stop for a minute. And it reflects that Judge Glanville and that officer, Lieutenant Dean, exit chambers at 10:45. Judge Glanville returned to chambers at 10:47. Okay, and then there's something about he might want to talk to his sister, and on page 52, they appear to maybe call his sister, and Ms. Hilton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. And the court says, hold on. And Judge Glanville exits chambers along with Miss Hilton, Investigator Long, Investigator Hamilton, and the court reporter. They all leave from 10:53 to 11:28. When they come back in, and this was where I got confused, the court says, okay, all right, Mr. Copeland, have you had an opportunity to talk with Miss Bumpus, your lawyer, and Miss Hilton, the state's counsel? Have you got any other questions? And I hadn't looked up to see who left before, so I thought maybe just the judge had left, but it appears that they had all left. So, I mean, I assume he meant, obviously we know Miss Hilton and Mr. Copeland had been talking prior to this. So I guess that's what he meant. But anyway, that's where I had gotten that. So where do you get your basis that they were in there at some point?
I get my information from Miss Bumpus. So
Okay.
perhaps, and I don't know specifically at what point. I don't know if Miss Hilton came back in the room prior to going back on the record. I don't know. But at some point, Miss Hilton, Mr. Copeland, and Miss Bumpus were in that room discussing things amongst themselves. And my understanding is that Mr. Copeland relayed information regarding the murder of Donovan Thomas and perhaps some other information that Miss Bumpus indicated would be Brady material. And so I just want to put that on the record that this happened.
Okay, so
Look at love.
you can't put that on the record
Well,
that it happened. You can put it on the record that Ms. Bumpus told you it
Well,
happened.
Ms.
Is that
Bumpus-
what you're saying?
Yes, Your Honor.
All right, I want to hear from Ms. Bumpus if that's the case.
Okay. And then would you like to, are you interested in
If you
seeing this
want me
TikTok?
to, that's fine.
Okay.
No, I'm not interested in seeing
But
it,
if-
but if you feel like it's relevant, I'll watch it.
Thank you.
May we approach briefly Mr. Kendrick?
Yes.
Dun dun dun. What do you think Love is saying or gonna say? And the deputy. The deputy might be noting that I think Kayla may have been there, and then she said she left the courtroom because she's sick. So she might be in the hallway and not in the courtroom itself. We'll have to see. Yeah, this is a very big can of worms. Oh, you guys are chatting fast. There you go. Love is flipping out inside. Yeah, Garrett, I can't wait to see these arguments, guys. I think we're going to get new motions today. If not, maybe tomorrow morning before court starts. Maybe we'll start early and look at them. But Garrett here still has case law that Brady issue still remains. And I'm sure he's going to hammer that home over and over. And then positive masculinity, thanks for the Australian 5, is, I think the A means Australian, is today the allocated day for the state to show all the reasons to justify a mistrial. I think today, I don't think they expected to still be talking about Melnick, the transcript, the ex parte, now Kenneth Copeland and Kayla Bumpus on social media. And they're getting ready, they're going to play this TikTok, I think, because they're putting in the... And Jeffrey Williams wants to hear it. He said, I'm going to watch this TikTok. That's a good new picture of them, too. And hit the thumbs up. That was them saying hit the thumbs up on this video, you guys. That's definitely what they were saying. See? You guys caught it. I don't think Kayla's on vacation. I think Hilton's on vacation. That would be so funny if it was the Hellcat video. Like, come on. It's gonna be the video of them having the conversation. Oh, this is to hear the sidebar. Okay, that's true. Dang, that's a long time. That was like a minute and a half, 2 minutes just to start the sidebar then. Is Steele writing with a Sharpie marker? Can you guys tell? That looks like a Sharpie marker. Let me put this down. I'm blocking it and asking you guys. Or is that just like a weird looking pen? Right? It's definitely a Sharpie. That doesn't bleed through the paper? Is he using like fancy cardstock to write his notes? Oh, so it's a pen version of a Sharpie maybe. Okay, I'm losing the comments because everyone's saying Sharpie. Yeah, but I feel like even with the fine tip, they still kind of bleed through regular paper. Okay, now I've got to try a Sharpie pen. I'm using a clicky pen. The judge would yell at me. Yeah, I do really like Sharpies. I just, I usually write with them on thicker paper. Oh yeah, so this week, I think it was this weekend, maybe it was Friday, but I think it was either yesterday or Saturday. YSL Mondo was like, what's going on with Copeland? You're the one that spoke with the police, and you're the reason these guys are locked up, and here you are out here. And I think it was kind of a statement mostly towards Woody, but it was also kind of a general observation that, like, people are also platforming him after he's the one that got us all here. So, and that's food for thought too. I don't think anything's absolutely, I don't have a conclusion one way or the other in the absolute. Heck yeah, hit that button, hit that like button, you guys. Do you think the guys are all happy to have something to listen to, or are annoyed because it's like love that they're listening to? DJ, they ain't writing on normal paper. That's another type of tax bracket writing here. Yeah, they get the card stock. The paper cut papers. The poor court clerk. I'd feel so awkward if I just had to stand there like do 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 do. Um well, it was Love that wanted to approach. It may have been relating to this TikTok. It may be relating to wanting to hear from Kayla. Because remember, the judge said she wanted to hear from Kayla. Right? Get in there, Kayla. I think it's probably Love just trying to figure out what she does or doesn't want. Because in a way, if they let the TikTok in, then maybe the judge doesn't want to call Kayla. No, I don't think they're playing it. I made that mistake saying something about, oh, they're going to play the TikTok video earlier. But it was just, it took them a minute, 2 minutes to even start the sidebar. Nice potato, by the way. I never noticed you had a heart-shaped potato as your picture. It could be they're discussing something that they don't want the media pool to pick up. I don't know what specifically. But we're gonna get some indication, some context based on what happens next. We're gonna hear like what questions are allowed, what happens. We'll get a clue. Oh, it could be a butt potato. It looked like a heart though. uh, no, everything that was said on the record today is on the record for the trial. Well, she did call it an ancillary issue, but this is still the case it relates to. But she was saying earlier we had exhibits, and Love wanted the clarification that the exhibits, the email exhibits, wouldn't be published in the actual case, the actual trial. Remember what they said, what Judge Whitaker said at the beginning of the day? Like, how different people interpret things differently. I'm like, the potato looks like a heart. Yeah, and that's the other context too, you guys. When Fani was a defense attorney. She represented YSL Mondo. So that's some context, some surrounding context here. And Mondo wasn't part of this indictment, this YSL indictment. Yeah, and it's possible they're watching it on a phone. Does he take a device back? Let's see. Fill us in. I want to know.
We've got a resolution, and that is that we're going to take 2 minutes or so. Mr. Weinstein is going to go refresh his recollection by watching the TikTok himself, and then he represents that there are really only about 10 seconds that are relevant. It is one question by Ms. Bumpus and one gesture and short answer by Mr. Copeland. He's going to make himself a written record of what that actually says, and he's going to proffer that. So we'll take a quick break and allow him to do that. Then he can come back and put a more detailed, specific proffer on the record, and we'll go from there. All right, so we're in recess again.
So we're gonna get the question. I think the question was there anything missing from the transcript? And Woody's like, or was it complete? And Woody's like, he does like a very obvious head shake no. And I guess this is going to be about a two-minute recess. I don't think it'll take long. Okay, so Christian says that it's a heart potato grown by my friend. That's awesome. I tried to grow potatoes. They were just small. They stopped growing. They were really little, and they were all just round and boring. And then the words were, you know it ain't. Does anyone know where that TikTok is coming from? Because I know the stream was long. I don't know where to just quickly jump to the clip. But we'll find out. We'll find out because Weinstein's gonna get it right. Maybe it was twice then, because I remember a YouTube video and I was assuming it was clipped and maybe it was just simulcasted. Maybe it was broadcast live to YouTube and TikTok. And because of everything that happened with Kayla's YouTube channel, Doug is referencing the TikTok version. Yeah, there's meat on the bone. And in any case, not for nothing, but this is all stuff that if the trial continues, question Copeland on it too. I don't know if it's up on YouTube anymore. Okay, wait. A YouTube short, is it on Kayla's channel? Okay, let me go to Kayla's channel. Yeah, whose channel has the short? Because I don't think she has that live still live. I don't think she re-uploaded it. Okay, perfect. We're going to Thugger Daily, who's way better at these video clips all the time. So first and foremost, Thugger Daily's Twitter, just drop that in the chat. Okay.
Woody, is the transcript complete? You say no?
You know that.
So guys, I just want to say that even though Woody fired me, as you all know, I still have to protect his interest. And I want to say we will not be talking about the case. He cannot answer anything. Woody, is the transcript complete? You say no?
You know that.
And to me, it sounds like he says, you know that, not you know it ain't, but he's still shaking his head no, like it's not complete. So same meaning, a reasonable person would infer he's saying it's not complete, right? Would anybody in the chat interpreting this as Woody saying, yeah, it is complete? It's clear to me that he's saying it's not complete. So let me retweet this. We'll get back over to the court. We're still looking at the seal. Shout out to Thugger Daily. Really good always with like the relevant clips, the throwbacks. But yeah, the original live stream, it's not still on YouTube. It hasn't been re-uploaded. Yeah, so and that's what I remember was watching it live. Maybe she'll re-upload it today. But let's see. And thank you so much, Miss AB. Good to see you. Good morning, I'm late. Who did Mr. Williams' hair over the weekend? Is he getting personally groomed in jail? Just wondering. I don't know, but it looks like tight, it looks clean. So whoever did it did a good job. And I like the hoodie with the name. Like, it's just making me think, because if you guys missed it, he's wearing a sweatshirt that says Jeffrey. And I just kind of like it because we had Love and the judge last week referred to him as Thug. So it's like kind of like an implicit reminder, like, you know, don't prejudice me by calling me my artist name. Here's my name in case you forgot. My legal name for the sake of this case. And then Marlena Mack, the realtor, thank you so much for showing some support. Yeah, so who retwisted his hair in jail? Okay, it might have been the link. Yeah, okay, guys, so I think only mods can paste URLs. When someone else tries to chat a URL, YouTube just gets rid of it because I don't think they want URLs. Like, you know, people can post funky stuff if you let everybody post links. So just a heads up to everybody, if you try to send a link, it won't work. But I'll put my email in the chat, which I need to check. But if you ever need to send something, send it there and then just put in the chat that you sent me something that needs attention like immediately, and we can take a look at it. I wonder if Doug's having, I mean, he must have it handy. Hopefully someone's like, Booker Daily just tweeted it, in case he needs an actual quick way to access it. Thugger Daily becomes an exhibit in the chat, in the trial. Yeah, right? Like, I saw someone say, the chat moves quick sometimes, but I saw someone say, how long does he need to watch this clip? He's writing down a summary. Yeah, I'm sure Whitaker's not loving that this is taking so long. Remember, she wants to bring the jury back Wednesday. And that's true. Cuff Boys did clip that too. Robert, good to see you. Robert points out that the Georgia Seal has 2 columns labeled wisdom and moderation. Not terms I would associate with this trial. Yeah. No. That's a good point, MT. He could be talking to Kayla. Because I do think Kayla was there. I think Kayla just stepped out of the courtroom itself. Yes, the Honorable Thugger Daily. I gotta get it right. F-bomb says this is a Glanville 2 minutes. I'm not sure. I am not sure about Kayla. Because earlier in the chat, she said that she left because she wasn't feeling good. So I'm not sure if that means she left the courtroom, if she left the courthouse, if she left the state and went back to Texas. I don't know. We'll find out. Yep. Yep, Ken Thompson, thanks for the 5. Notice how mystified the judge was when she heard Kayla was on social media with her client talking about the case. Yep. And then, like, 2 sentences or so after that, she was saying she wanted to hear from Kayla. And I think we kind of all want to hear from Kayla. Right? Especially about this specific issue. Yeah, and that. Where Kayla, we know you're tracking her moves. And I wonder if some questioning could get into that because Kayla has said she's felt like, you know, Hilton has said something about what she was in the courtroom doing to Miss Love because Miss Love wouldn't have known something otherwise. And that possibly deputies have been saying stuff. So maybe Kayla could give some additional context on that we've been watching and tracking comment from that June 7th transcript. Yeah, get her on Zoom. Yeah, and wasn't her client anymore after that day she was fired. She was fired. And I think the other thing is whether they can get this in or not. If Woody takes a stand again, they could ask Woody some interesting questions, and I don't know what I think Whitaker would keep out or stop them from asking. And that's a good point. So Ken Thompson, I can see a very real potential of this TikTok fact pattern being included in future attorney ethics training in Georgia. And this is a New Hampshire attorney here. And on one hand, you know, and she's not currently representing Woody, but still she said she's looking out for his best interests. You know, this TikTok stuff could come in and work very well for the defense. Obviously, Doug Weinstein thinks it's important for his client's defense for this to be allowed in. I'm sure the other co-defendants agree. But on the flip side, the same thing could get your client in hot water. The same thing could get an attorney in hot water. You know, Judge Whitaker ruled correctly, I think, in denying the state's request to bar extrajudicial statements by the defense counsel to the media. She's like, no, this is nobody crossed the line. So I'm denying this request to restrict. But if someone gets on TikTok and starts giving case details, then that's a separate issue. And we're so used to hopping on, it's we're kind of normalizing it that maybe we need to put a bumper on it. So great point. Great food for thought. When I do this attorney panel on pronunciations, I would love to bring this up as a food for thought question. So thank you, Ken. And I don't know if we're coming back in. And then King Divine, thanks so much, says, people not realizing Miss Hilton said commit to murder in the transcript. Why would she say that if nobody committed to murder? And I agree. She knew that's what the reference was by
Thank you
Woody.
for giving me time to refresh my poor memory, Your Honor. So there is actually originally a YouTube video that I viewed on TikTok. And it's an interaction between Kayla Bumpus, Mr. Copeland's attorney, and Mr. Copeland.
Okay.
And there's just is this feedback a problem? Okay.
Not right now, it's not.
Okay. So anyway, I viewed this interaction. I'll go ahead and proffer to the court the exchange that I witnessed. Ms. Bumpus says, Woody, is the transcript complete? Mr. Copeland then vigorously shakes his head back and forth, indicating no. Then Kayla Bumpus says, you say no? And then Woody responds with, you know that. So that's the interaction that takes place. Your Honor, as I think maybe you indicated, and certainly as the state indicated, perhaps the better source of this is Ms. Bumpus herself. She's here. I'd like to call her to the stand and we can hear her testimony about what took place on June the 10th, 2024, during the course of that ex parte that was not recorded in the transcript, not because of anything nefarious, but it would provide, I think, better insights into our position that there was Brady material June the 10th that was not captured in the transcript and not provided to us.
All right, let's hear it. Ms. Bumpus coming up, and Ms. Bumpus
Here we
is
go.
basically,
Kayla's
I think,
there.
been in court all morning. Is that right? Okay, coming up and take the stand.
Sure.
What a
Ms.
Monday.
Bumpus, would you please stand and raise your right hand? Do you swear the testimony that you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes,
Okay, please be seated. Would you please state your name for the record?
Kayla Bumpus.
And what is your relationship with respect to Mr. Copeland?
I previously represented him on criminal cases, but for purposes of this case, I was a stand-in attorney.
And what was your intent in representing Mr. Copeland?
To make sure that his rights were protected and to make sure that Jonathan Melnick was good to go.
All right, let's focus on the discrete issue that is before the court, okay?
Certainly. You were present in the June 10th, 2024 ex parte meeting, is that correct?
Yes,
Have you read the transcript to the ex parte meeting?
yes.
Um,
I'm not sure if that is already an exhibit in this case, Your Honor.
It is, it's a part of the record as a
Okay.
transcript.
Okay,
It's been filed
All right.
in Odyssey into the case.
Okay.
So I don't think it needs to be an exhibit unless you want to make it exhibit for the purposes of this hearing, but it's in the record.
okay. I'll just be referring to that transcript. So have you read the transcript from the June 10th ex parte meeting?
Yes,
And does that reflect everything that occurred the morning of June the 10th during the course of your meeting? I believe that was in chambers. Is that correct? That was compound.
That
Was
was
that
a
meeting in-
compound
that was
question.
compound. Was
Let's
that meeting
redo
in
that one.
chambers? Where did that meeting take place?
in chambers.
In chambers. And was the ex parte transcript that you read a complete recording of absolutely everything that took place in chambers that morning?
No,
Could you please tell me generally, when was there a time during the course of that ex parte meeting when y'all went off of the transcript?
Clarify what you mean by that, when y'all went off.
Was
of-
there a break in the proceedings at some point on the morning of June the 10th?
multiple.
Multiple breaks.
Yes,
And during one of those breaks, did you have occasion to speak to Mr. Copeland with someone else, with someone from the states, the state present in the room?
yes,
And when you had that conversation, that was off the record. That was without the transcript being transcribed.
Yes.
Let's clarify who is in the room at
Yes.
this point in time.
Okay. Who is in the room? And again, let me just make clear on this. I only want you to speak about conversations that you had with Mr. Copeland that are not privileged, where, for example, someone from the state was in the room. Do you understand?
It matters someone's in the room. Yep.
Okay. When there was a portion of that meeting that was not recorded on transcript, who was in the room?
Myself, Mr. Copeland, and Simone Hilton.
Ooh.
If anyone.
I don't know all the deputies.
But were there deputies in the room as well?
Yes.
Do you remember how many?
Four.
So not privileged.
Okay. Anyone else other than the deputies and the three people you just named?
Wow.
Investigator Hamilton and maybe another investigator from the state.
Okay. Approximately how long was that?
Hang on a second. Was the court reporter in the room?
I don't know. I don't recall. I can't remember.
And at what point during the meeting did this allegedly occur?
Towards the end.
If you had a copy of the transcript in front of you, could you show me where? Like, if
I
you,
can get close, Judge.
okay. Do you have a copy for her?
I don't have, does anyone have a copy? I do not have a copy
Mine just
printed out.
disappeared. I don't know where mine went.
Max, do you have one?
I don't mind passing up, but it does have notes.
Maybe not. Let's get a
Okay.
clean copy.
Okay.
What had just occurred and then what
Yep.
occurred following it? What had just occurred prior to?
What had just occurred was we had been meeting for a really long time and I needed to go to the bathroom because I was stressed out. And
Okay.
when I went outside in the hallway, Simone was outside in the hallway. So I guess she didn't want to be in the room with Mr. Copeland while I stepped out. That's all I can think of. So she was outside. She met me in the hallway and she said,
Okay, hang on before you get into what anybody said. So y'all are in chambers, like paint the picture for me. You're in chambers and then, and what happens for you to then leave chambers to go to the restroom?
I needed a break.
Okay, and so you leave chambers
Yes.
and Miss Hilton leaves chambers.
I don't know when she left because when I left, she was still in there. But when I came from the bathroom, she was in the hallway.
Okay, when you left chambers to go to the restroom, who was in chambers at the time that you left?
Mr. Copeland, the deputies that were with him, about four, Miss Hilton, the investigators from the DA's office, the judge, and the court reporter.
Okay, so you took a bathroom break.
Yes.
And as far as you know, you left and then you have no idea when or if anybody else left. But when you came back, Miss Hilton was in the hallway.
Yes.
All right, well then that's not the part we're talking about.
No. Well, I think it leads up to the part we're talking about, and that interaction with Ms. Hilton may
Okay.
be relevant to where we're about
Relevant
to go.
context.
Could you please describe the exchange you had with Ms. Hilton in the hallway?
So she asked me, I think I get what you're saying. I think I get what you guys are trying to say. And if he's trying to do what I think he's trying to do, then that's not going to work. And I said, well, I don't know what you're referring to, but I guess we can come back in and you could talk to him about it.
Okay, and so when you said you can come back in the room and talk with him about it, was there any further exchange in the hallway?
No,
What happened after that?
we go back in the chambers,
Excuse me, we being you and Ms. Hilton.
me and Miss Hilton.
You go back into the chambers, and then would you say again who was in the chambers when you went back in?
Well, Mr. Copeland had then went to the restroom, so it was just me and Miss Hilton in chambers, and then they bring him back in. And
Did
then-
you and Miss, excuse me, I don't mean to cut you off if you hadn't finished.
No, then the same other people.
Okay, when you and Ms. Hilton were in the chambers prior to Mr. Copeland returning, did you and Ms. Hilton have any further conversation in the chambers?
No,
Okay, when Mr. Copeland.
Hang on. So you and Ms. Hilton go back into chambers. Do you go back? I mean, chambers is, there's an anteroom where the judicial assistant sits. There's a staff attorney's office. There's the judge's office. Where are y'all? The judge's office?
Yes.
Okay, and when you and Ms. Hilton go back to the judge's office, there's nobody else there but the two of you?
and probably the investigators from the state.
You don't remember?
Well, the deputies had to take Mr. Copeland.
Okay,
Yeah.
so Mr. Copeland was gone.
Yeah, he was in.
Was the court reporter there?
Yeah, she was there.
Was the judge there? If you remember.
I don't remember if he was in there.
Okay, so you and Ms. Hilton have a private conversation in chambers?
No, we don't talk.
Okay, y'all just walk back in and then what happens?
And then everybody comes back in.
Okay, who is everybody?
The judge, Mr. Copeland, the 4 deputies, the 2 investigators from the state.
Okay, we're just going to take it slowly, step by step, okay?
Okay.
All right. So those individuals return. Does Judge Glanville return to the chambers?
Yes,
Is the court reporter in the chambers?
yes.
Okay. When all of these people are in the chambers, what happens next? A step at a time.
Simone starts talking to Mr. Copeland about what we talked about in the hallway.
What specifically did Ms. Hilton tell Mr. Copeland about what happened in the hallway?
I don't remember what she said at the beginning, because then she says, wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hilton.
Okay, ask the judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay,
And so at this point, you're saying that the judge is out, you, Ms. Hilton, Mr. Copeland, 4 sheriff's deputies and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
okay. Next step. What happens next?
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay, what specifically did Ms. Hilton say about purging himself?
About purging himself once he began to testify that he would purge himself of him being arrested.
Okay, what about perjury did she tell to him? Did Ms. Hilton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Ms. Hilton tell Mr. Copeland was the one thing he knew, she
All
knew?
right, let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So when you say that, what did Ms. Hilton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And when Ms. Hilton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was explaining to Mr. Copeland about independent evidence, because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that Infiniti, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So do I understand your testimony to be that Ms. Hilton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the Infiniti, because I didn't catch all of that. What did Mr. Copeland say about the Infiniti?
You just say, I know something about the Infiniti that y'all don't know.
And how did Ms. Hilton respond to that?
No, I don't remember, but basically she just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the Infiniti?
I think that, I mean, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't going to go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more. I don't know. At this point, we've been in there for 2 hours. And they gave me a second to talk to Mr. Copeland, and then that was the end.
Okay. Who gave you a second to talk to Mr. Copeland?
I guess Simone.
Did Simone Hilton remain in the room while you spoke to Mr. Copeland?
Yes, but she couldn't hear what we were saying.
And why do you believe she couldn't hear what you were saying?
She couldn't hear, I know, because we were whispering in we scooted away from her and we just kind of whispered in each other's ear.
Okay. Is there anything else that happened during the course of this meeting where Judge Glanville was not in the room that you haven't told us this morning?
I'm not 100% sure, but I know there's one time where Adriane says something about Judge Closure.
Where, I'm sorry, who?
Adriane Love.
Okay, let's
I thought that
stop
was
just a
Hilton.
second, okay? Because I want to make sure we clarify this. I believe your testimony earlier was that Ms. Love was not in the room, at least during this portion of that meeting. Is that correct?
That's correct.
Are you referring to another portion of the meeting that happened that morning?
I don't remember if he stepped out or not. I just remember at one point she said, Judge, close your ears.
I don't remember if who said,
Okay, let's go back.
yeah, that's
Okay,
very
here,
unclear.
We're going to go back and try to clarify.
Let me.
Yeah,
All right. So at the beginning of the meeting, it is Judge Glanville, Miss Love, and you,
Yes, Judge.
the court reporter, and then whomever the deputies are. Mr. Copeland is not there. Miss Hilton is not there. Is that correct?
No deputies.
Okay.
They don't come until Mr. Copeland comes.
Okay. So then it is just the judge, Miss Hilton, and you, and the court reporter, correct?
And the investigators.
The DA investigators.
Yes,
Okay. And so is it that portion of the transcript that you're moving to now?
Yes.
Okay. All right.
and what did Ms. Love say?
I just remember her saying something about Judge, close your ears. And I can't remember if he steps out then for a second or not, but that would be the only other time I remember him stepping out.
What did Ms. Love say after Ms. Love said, Judge, close your ears?
I don't remember.
You don't remember? Okay. So we've discussed that one portion of the morning where the judge was not in the chambers. Was there another time that morning, other than that one time we've been discussing, was there another time that morning where the judge was not in the chambers, but there was a conversation among you, Mr. Copeland, and someone from the prosecutor's team?
No.
Okay, that's the only time.
Yes.
Okay, I don't have any further questions.
All right. Does any other defense attorney have questions for Ms. Bumpus?
I remember being Hilton and it was in the transcript at the cover your ears.
And we have a copy of the transcript now if anybody needs it. A clean copy. Yeah. It's sitting right up here.
Oh, I'm sorry.
Kayla has said she's nervous in general. She said she was nervous with the Rule 22 stuff too. But I'd be nervous. They're kind of big questions.
Go ahead, Mr. Steele.
Thank you.
Look at him.
Good morning.
He's waited for this for 2 months.
Counselor, was there a time in your presence that you heard someone give a direction for the sheriff deputies to shut off their body worn cameras?
Absolutely.
Do you know who gave that direction?
Deputy Brown.
And do you know at what period of time or what point in time that occurred? Were you
Oh my.
alone with your client? Was it throughout the whole time? Were you with Miss Hilton? What was going on when you heard that?
That was the first thing he said when the deputies brought Mr. Copeland in.
So as far as you know, I'm not saying the sheriff deputies filed that order, but they were ordered to turn off all body worn cameras as far as you were concerned.
Yes.
And this conversation that you just relayed to us with Ms. Hilton, you and Mr. Copeland, your client, was that a calm conversation? Was it heated? How would you describe?
We had been in there for 2 hours. It was a high level of emotional tension, if that's a thing.
Okay, were people getting louder than we're speaking now?
Yes.
And who was
Adriane's
that
always
person or
loud.
people?
Simone.
Okay. And when you were talking about Mr. Copeland not being permitted to take responsibility for the killing of Mr. Thomas, you know what I'm referring to?
Yes.
Did Mr. Copeland in any way take responsibility for that killing that day to Ms. Hilton?
Pretty much, he just said, you don't know what I did or didn't do.
Okay. And that was said to the prosecutor about the killing of Donovan Thomas?
Yes.
Do you know if you saw Ms. Hilton taking any notes or recording the meeting, or any of the people with her recording this meeting or taking notes?
I'm not aware.
It says, and the court just gave a transcript, I don't know where it is, but you can look at it. No one's trying to trick you. It says on page 40, towards the bottom, it's the Honorable
Yes.
Judge.
It's fine.
If you need to look at it, if you don't need to look at it, that's fine. Just let the record reflect. It should be on page 40. If you need it, it's June 10th. It should be 2024 ex parte conference that you were part of. And Judge Glanville says something to the effect, I'm not looking at, this is not a quote, but it appears to be to Mr. Copeland. Do you remember when Mr. Love told you that as long as you don't tell a bold-faced whopper, something like that? Do you see that?
Yes.
Can you just, so the court, unless the court has it in front of her, what line
I've
that
got
is?
it in front of me.
Do you know what line that is? Or it begins on?
12.
Okay.
Well, 9, but 12 specifically, which it's referencing to.
I couldn't hear the last part.
9 is when he starts talking, but 12 is when he gets into that part.
He being Judge Glanville.
Yes.
Okay. And what information do you have that Ms. Love spoke with Mr. Copeland about the bald face whopper?
What do you mean?
I'm sorry, can you ask that again? Well,
Yeah.
apparently Ms. Bumpus didn't understand it any better than I did.
Yes. Do you
About the
have any
bold-faced whopper?
information to educate us on when Ms. Love spoke with Mr. Copeland about you can't make a bald face, whatever it says, whopper?
Hang on just a second. Yes, Ms. Love.
My objection is that the question itself assumes a fact that has not been established.
Sustained.
Read what it says if you don't mind, since it's.
Tell me
in
what
evidence.
page we're on again.
Court,
Okay. Thank you.
the court, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just the truth as you know it. And let her worry about, I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your First Amendment privilege because you've been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
That part you said about, you remember earlier this morning, Ms. Love telling you about the bold-faced whopper. That's what I'm focused on. Can you tell us, were you present when Ms. Love spoke with Mr.
Objection,
Copeland that
Your Honor.
morning?
What's your basis?
Again, assuming facts that have not been established. The question, I believe, was, were you present when Ms. Love spoke with Mr. Copeland?
Okay, so I think that's based on the fact that what was just read out was read out. So I don't know that Judge Landville's statement establishes that, but that's why he's asking it. So I'm going to permit him to ask that, and she can, keeping in mind that that doesn't establish that it occurred. Ask it as a more conditional question, I guess.
Do you have any information how that came about, if it occurred at all?
So the meeting was really long and a lot happened. I can't remember if Ms. Love was ever in the room at the same time as Mr. Copeland. So I don't remember them being in the room together. And if they were, they did not have any communication.
Okay. All right. Do you remember in that transcript, I have to get you the page if you don't remember, Judge Glanville handing something to you for Mr. Copeland?
Absolutely.
Can you tell this court what that was?
Which time?
Every time. So go one at a time.
So the first time, I believe he handed me a copy of the immunity order.
Okay.
And the second time, he handed me 2 statutes, one on perjury, and I think the other either on impeachment or, yeah, I think that's what it was.
Okay. Any questions, written out questions you remember being handed to you or Mr. Copeland? District Attorney's questions, was that given to Mr. Copeland?
No,
Okay, you remember that discussion?
no.
All right. I don't have any other questions. Thank you. Thank you,
All
Your
right.
Honor.
Any other defense attorney have questions for Ms. Bumpus? Okay.
Good morning, Ms. Bumpus.
Good morning.
Counselor, I want to take you back to that Monday, June 10th, 2024. When you arrived for court that day, you were arriving to represent Mr. Copeland, correct?
Yes,
As a witness.
yes.
Okay. And where did you go when you entered the courthouse?
I came right here.
To this courtroom 1C?
Yes,
Okay. Did you ever request an ex parte meeting with the judge?
no,
To your knowledge, did Mr. Copeland ever request an ex parte meeting with the judge?
no.
Okay. How did this meeting come about?
I was down here and when I got here, the courtroom was closed. There was no one here. And so I contacted Mr. Chamberlain and he came down. He told me to call him when I got in the courthouse. So I called him when I got in the courthouse and I was right here. And he came down and got me, took me upstairs.
Okay. Were you ever told why you were going upstairs?
I was never told why I was going upstairs, but once I got upstairs, I thought I was upstairs because that was the only place I could talk to Mr. Copeland.
Okay. At what point did you realize that you were being made part of an ex parte meeting?
When Brian got up there and said it.
When what? I'm sorry,
Brian,
who's Brian?
Attorney Steele,
Okay.
got up, and that was the first time I really realized that anything had happened because I had been sitting there and I did not realize what was happening.
Where are you? I thought you had just been brought upstairs to Judge Glanville's chambers.
But it was never a time where they said, oh, we're about to meet. They literally just start talking. So
Mr. Steele's there?
no, the first time I realized what had happened was when Mr. Steele made his motion in court.
Okay, so you were in chambers with Judge Glanville and Miss Hilton. And Miss Love, correct?
What I'm saying is,
You answered the question that I am asking you. You were in chambers with Miss Hilton and the judge. I'm sorry. There are two different parts to this ex parte. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
yes,
Okay. And you were aware prior to that morning that this case was being tried, correct?
yes,
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
yes,
And that Judge Glanville was the presiding judge at the time.
yes,
And that there were defense attorneys on the other side of the case, right?
yes.
Okay. And so when you went into the meeting, you could see that there were no defense attorneys present, right?
No, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked you. You could see at that point in time that there were no defense attorneys present in the chambers, correct?
Yes,
Okay, so at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
what I'm saying is,
Ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Okay, so at the point when people started talking, let's call it a meeting at that point in time. Okay.
Okay.
And so you knew that the defense attorneys weren't there then, right?
Yes.
Okay. And so you knew it was an ex parte,
Thank you, Republic.
if you knew the term ex parte.
Yes. I know.
Okay, go ahead.
And in the meeting, who initiated the conversation about the purpose of the meeting? Was it you?
No.
Okay, who was it?
All right, let me ask y'all a question. I can read what's in the transcript. So unless there's, something that we're saying occurred before, the court reporter said, okay, I'm ready whenever y'all are. I don't need an exposition of who said what. I can see it, okay?
Okay. I have no further questions.
All right,
Okay, the mic doesn't like Schardt either.
Ms. Matthews.
Oh, Keratin Matthews. Okay.
Ms. Bumpus, good morning.
Good morning.
Just a few questions for you. At any time during the meeting that took place between the court, the prosecutor, yourself, Mr. Copeland, were you ever told by the court not to disclose any of the contents of the meeting?
All right, we are not going to replow the issue of Mr. Steele being held in contempt. That is moot. So to the extent that this is going to that, move on.
Okay, that's where I was going.
All right.
Thank you. No question.
Anybody else? From the defense team side. Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few.
A few.
Thank you. Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No.
Okay. Do you recall telling Mr. Steele or Mr. Schardt or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
Can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall testifying that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
Okay. And did Judge Glanville give to you a copy of the immunity statute?
And say, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
Okay. Do you recall what you were asked do you recall testifying that Judge Glanville gave you both a perjury statute, copy of that, and a copy of the immunity statute?
Yes.
Okay. Do you recall what question you were answering when you made those statements?
The question that I was answering was, did Judge Glanville give me something to hand me a statute or hand me anything in a meeting?
And you don't recall him asking whether Judge Glanville handed Mr. Copeland anything?
Objection as to the answer.
Yes, thank you.
I mean, I'm not sure we've got a clear answer on it, but does it matter?
If she, there's a reason that I'm asking the
All
question.
right, well, go ahead. You can ask it again because I don't think anybody's clear on it yet.
Do you recall being asked today whether Judge Glanville ever handed Mr. Copeland anything?
I believe that I just stated that he handed me two things.
Ms. Bumpus, I don't think she's asking you about what happened. I think she's for some reason asking you about the question
For
that
some
was
reason.
asked to you on direct.
Do you recall being asked if Judge Glanville gave Mr. Copeland anything?
I don't recall.
Okay. At the time that you were called to the meeting, you already knew that Mr. Copeland had been granted immunity, correct?
Incorrect.
Okay. At the time that you assumed representation of Mr. Copeland, you were aware that he had been arrested though, right? You knew that Mr. Copeland had been arrested?
No.
Okay. At the time that Mr. Melnick spoke with you about standing in his stead on that Monday morning, did you learn during that conversation with Mr. Melnick that Mr. Copeland had been arrested?
No.
At what point did you learn that Mr. Copeland had been arrested?
After he had been arrested?
Was that before or after the Monday morning meeting?
Objection, Your Honor. You asked us to just focus on the content of that meeting. You asked me to not.
And now it's
get
outside the
far
scope.
from that, and we're far from that.
Your Honor, may I-
Yeah, what does this have to do with whether or not some off-the-record discussion that Ms. Hilton was privy to occurred?
Your Honor, the reason I was asking about the giving to Ms. Bumpus the statutes is that my understanding is that at the time that she was called to represent Mr. Copeland, she was not familiar with certain statutes.
Okay, well, maybe, maybe not, but that's not relevant to what we're trying to figure out here.
And so to the extent that she was asked by the defense whether Judge Glanville gave to Mr. Copeland anything, and she then responded, he gave it to me.
All right,
She's
I
saying it's
don't-
not
I don't
intimidating
recall-
Copeland.
I'm sorry, go ahead.
It was just to educate
Go ahead.
Kayla.
I was establishing the reason he would have given her that, and I was establishing further.
It's
the
a
extent
decent
of the
argument.
Questions that I had for her dealt with her understanding of her
I don't know if it's relevant.
responsibilities. And then finally, I was going to ask her, she'd already testified to my memory that she doesn't recall this counselor ever being in the room with Mr. Copeland, and if there was no communication.
Okay,
So I was going to.
that part seems relevant. You can ask about that.
Miss Bumpus. Do you have any memory of Ms. Hilton and me being in the room while you were in the room with Mr. Copeland?
I have some memory of all of us being in the room for a very brief moment of time.
When you say all of us, who is all of us?
You just asked me, do I have any memory of you, Ms. Hilton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No.
And when you say you remember that I came back, where is it that you're remembering that I came back to?
Either, I don't remember. Maybe it's when Ms. Hilton came back. But at one point, all three of us were in the room.
Who's all three of us?
Me, Ms. Hilton, and Ms. Love.
In chambers.
In chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember.
Well, I mean, it's kind of important. We're relying on your memory for certain things, so. Were there deputies in the room then?
What I'm saying is if Mr. Copeland was ever in the room with Adriane Love, then it wasn't a long, extended amount of time, and I don't think there was any communication. I remember that Simone left, and it was just me, Adriane Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hilton, and you were in chambers?
There was a point in time where Miss Love and Miss Hilton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hilton was doing all of the talking. I honestly believe it was when Miss Hilton left at the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Antechambers, like outside of chambers, but inside of the door.
Yes.
Who is all of us?
Simone Hilton, Adriane Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the judicial assistant, sits.
Yes,
At
Judge.
first, okay, we'll call that the antechambers, ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adriane Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adriane Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
I thank you. Ms. Bumpus, there were investigators present or no? When you, me, Judge, the court reporter first went back?
I can't remember.
Do you recall a comment from either the court reporter or the judge just joking about the fact that I'm not allowed to go anywhere without the investigator?
No.
And when you say that we went into the chambers, you, me, the court reporter, Judge Glanville, was Judge Glanville's deputy there?
Yes. I guess if he's a deputy, I don't know.
Which person was there for Judge Glanville? Which sheriff's office personnel, do you remember?
No.
And where was that person situated when you, me, Judge Glanville, the court reporter went into chambers?
I have no idea.
That person was in chambers with the 4 of us, 5 of us?
I don't remember. At some points, I don't remember about when he was walking in and out.
Okay. And by that, by he, you mean a sheriff's office personnel?
If he's a sheriff, I don't know what he is.
Do you remember, do you have any memory of the investigator being present with me while I was in there?
I don't remember. I know there were investigators there. I don't remember if they came in chambers when you came in or after Ms. Hilton came in.
And seeing the transcript, does it do anything to refresh your memory about who all was there?
No.
Okay. And when you testified earlier that at some point after I left the first time, that Simone, me, and you ended up in a room together in chambers. Do you recall testifying that way to the court just earlier today?
Yes, at one point, me, you, and Simone were in chambers together. Like I said, it was a brief moment, and I don't remember you saying anything.
But that was, are you saying that now that was after I left the first time?
I really don't remember.
Okay. So your memory, you know that at some point you, me, and Simone are in chambers together. You cannot recall whether after I left the first time I ever came back.
I cannot recall.
Okay. And when you said, let me ask you just this pointed question. Did Kenneth Copeland ever say, I killed Nut while Simone Hilton, to Simone Hilton while you were in there?
Can you ask the question again?
Did Kenneth Copeland ever say to Simone Hilton, I killed Nut?
No.
Did Kenneth Copeland ever say to Simone Hilton, I killed Donovan Thomas?
No.
Did Kenneth Copeland ever say that he killed anybody to Simone Hilton?
No.
Did he say any of those 3 things in Simone Hilton's presence and hearing, to your knowledge?
Can I answer that with a non-yes or no question, Judge?
With a what?
With an explanation, because he didn't say yes, or he did not say I killed, but he said, you cannot tell me what I did or did not do.
Okay. That's the extent that he said?
Yes.
Okay.
When you spoke about someone asking the sheriff to turn off their body cameras, was that Ms. Hilton? Did you say Ms. Hilton told the sheriffs to turn off their body cameras? Did I hear that wrong?
That's not what
You
she
heard that
said.
absolutely wrong.
Please tell me. It was.
I clearly said Deputy Brown.
Thank you. Thank you.
You're welcome.
Do you recall what was being talked about when Deputy Brown told the sheriff's deputies to turn off their body cameras?
Nothing. That was the first thing that he said when he walked in the room.
And at that point was Ms. Hilton, you, Mr. Copeland, judge, court reporter, and DA's office investigators all present in the room?
I don't remember who was in the room. It may have just been me.
So it may have just been you when Deputy Brown said to the sheriff's deputies, turn off your cameras?
I don't remember exactly who was sitting in the courtroom.
But that's
I mean,
in the chambers, but that's possible?
It is possible.
It's possible it might have been when you and Mr. Copeland were just in there together?
It wasn't.
Well, Mr. Copeland had to have been in there, right? Because you said the deputies didn't show up until Mr. Copeland arrived.
No, what I'm saying, Judge, is that was the order as he walked in.
Right, but what did you say might have just happened when it was just you?
Nothing. I was saying I may have been the only one sitting there. I can't remember, but there wasn't like, oh, step out. It's as soon as they walked in, this is what was said as Mr. Copeland was walking in.
And was there any, did you request at that point that they brought him in to have a private meeting with your client at the time?
At that moment, I hadn't requested anything.
Is it safe to say you don't know why they were told to turn off the body worn camera?
That is correct.
Okay. Did you ever hear anyone from the state ask the deputies to have those body worn cameras turned off?
No.
You testified earlier that Mr. Copeland said something akin to, I can claim all of this. Did I hear you right?
Yes.
Okay. And who was he talking to? And
Simone.
okay. And did you know, or did he ever make clear what all of this was that he was talking about?
I believe he was referring to everything that,
Wait, that's not the question. It wasn't what do you think he meant? It was, did he ever make clear?
he said everything in this case.
He said the words, everything in this case?
I don't know if those were his words verbatim, but that's what he said.
Was the court reporter there when that happened?
I don't know. This was an off the record conversation.
Okay, so it was so when what about his words? What words did he say that makes you now say that's what he said if you don't remember exactly how he put it?
I said I don't remember his words verbatim,
Right.
but I was there and he said, I can claim all of this. I can take all of this. That's what we were talking about. We were talking about this case.
Okay. Is what you just testified to the extent of the words that Mr. Copeland spoke regarding claiming something?
Can you repeat the question?
Yes, ma'am. It's what you just testified about, the extent of the words Mr. Copeland spoke about claiming something.
I don't want to say that is a complete lead to the extent because he said it over and over. He said it various ways. He changed the way he said it.
Do you recall what specifically was being discussed at each of the points that he said that? Specifically.
Overruled.
Specifically, not generally, not broadly, specifically what was being discussed at each of the points where he said, I can claim all of this.
The whole conversation was about Donovan Thomas's unaliving.
Are you familiar with any of the shootings that occurred after Donovan Thomas was killed?
No.
Okay. Are you aware or are you familiar with any allegations about any retaliatory events that occurred that the state considers a part of the Donovan Thomas shooting?
No.
At what point, what was being asked of Mr. Copeland when he made the statement that you testified, it's not just about me knowing that, it's about who was in the Infiniti? At what was being asked of him when he said something like that?
Nothing was being asked of him.
Okay. Did he just sort of blurt it out on his own?
Yes.
Okay.
And what he said was, I know something about that Infiniti that y'all don't know. And it got something to do with somebody who's not even on the case.
Okay. Did he ever make clear what it was that he knew to Ms. Hilton in your presence?
He wasn't given the opportunity to.
But what do you mean?
She continued to talk about what she was talking about.
Okay. Did she ever tell him, don't talk to me about that?
No.
Did you ever hear him sort of interrupt her at any other time, at any time?
The whole conversation was them interrupting each other.
Okay. So did he ever interrupt her to give her more information or to tell her what it was about the Infiniti that he knew?
No.
When you said, Adriane said, "Judge, close your ears," did you mean to say Adriane said, "Judge, close your ears"?
You?
Yeah.
Yeah, you.
Okay. At what point are you alleging, are you saying, does your memory tell you that I told the judge to close his ears?
I don't really remember exactly what was saying.
Yeah, this
I
was
don't
to
know if it was
Hilton, I
you
think.
and Simone in there, but something about we were having a conversation. Me, you, and Miss Hilton were having a conversation about I don't remember
I
what
can
we were
share my
talking
screen, but I
about.
can't
And you
do
said
the.
it, and then you said, "Judge, close your ears."
And what did I say after I said, "Judge, close your ears"?
I don't remember.
All right, so then it's now your recollection that there was a point in time when you, Miss Love, Miss Hilton, and the judge were in there and Miss Love was talking.
Judge, I've said that she never talked while Mr. Copeland was in the room.
Okay, and you don't even remember really whether she was in there or not when Mr. Copeland was in the room?
If she was,
She
it was
Miss
very,
Love.
it was very brief, but no.
Okay, but you said before, I thought, that there was maybe a 2-minute time when you, Miss Hilton, and Miss Love were in a room together.
Yes, that's what I'm referring to.
Okay, so that was in front of also Judge Glanville? Because you just said it was, so I'm
Well,
trying to get clarity.
Here's the clarity. He wasn't at the table with us as normal. He was turned around on his computer, but still inside of his office.
Okay. So when did this occur during, so we have the beginning of the ex parte being Miss Love, all of y'all are standing outside in the ante room and Miss Love says, "Judge, can we talk to you for a minute," or something to that effect. And then who all gets up and goes into Judge Glanville's chambers?
Simone has left to go to do something at that point. So it's just me and Adriane Love.
Okay, and who else?
And the court reporter. And she says maybe her investigator. I can't remember.
Okay, and so the three of you talk for some amount of time,
Yes.
the three of you being Miss Bumpus, you, Miss Love, and Judge Glanville?
Yes.
All right, and then tell me when that changes and it becomes more or fewer of you in that room.
The first person to join us is Simone when she comes back from court.
Okay, and is that at the same time that or essentially the same time that Mr. Copeland also joins you?
Maybe within a minute or so. They don't come
Okay.
in like at the exact
Okay, so they come in essentially together. And where's Miss Love at that point?
She leaves when Miss Hilton comes, but she does stay for, like I said, there's a brief conversation with me, Miss Hilton, and the judge.
And the judge?
Well, in the judge's chambers, the judge is
Okay,
not.
with you, Miss Hilton, Miss Love, but it's not a part of the proceedings yet because the judge didn't even pay attention. He's over there working on his computer.
Yes.
What do y'all say at that point in time?
I don't remember what the conversation was.
Anything of substance?
It was about maybe plea deals. I remember she said to me.
She who?
Adriane Love. I remember
Okay.
she says, which I can't forget this, is I don't know who's worse, you or Jacoby.
What?
That was the thing. That was the nature of the conversation.
Say that again.
She said, she tells me she doesn't know who's worse, me or Jacoby.
Me or Jacoby?
Yeah.
Jacoby Hudson?
Yes.
What does that have to do with anything?
I don't know.
It has nothing to do with this case.
No, that's what we're talking about. You asked me what we were talking about.
Okay, so something that had nothing to do with this case.
And then something comes up about, I don't know if it's plea deals. I don't know. It was something about this case where she says, "Judge, close your ears."
Okay. So this is before y'all kind of gone back on the record. The judge isn't paying attention anyway. He's in the room, but he's over at his computer. Y'all are over at his conference table. Is that what your recollection is?
Yes.
Y'all are talking about entirely other things. And then
I wouldn't say entirely other things, but we're not talking about the Mr. Copeland.
or the case. If you're talking about Jacoby Hudson, you're not talking about the
No,
case.
we're talking about the case. She's talking about, I guess she's talking about the reference to me hugging people. I don't know, but we were talking about the case.
Okay, anyway, and then at some point, Miss Love, to your recollection, says, Judge, close your ears because she wants to talk to you about a plea deal.
I don't know exactly I don't remember exactly what she was talking about, but it was something pertaining to the case. And
Okay, but
she
you
doesn't
don't,
want to talk to me about a plea deal because I'm not a defense.
right, that
attorney.
wouldn't have made any sense.
But she was discussing something pertaining to the case. And she says, ooh, Judge, close your ears.
And how long does that conversation go on?
Yeah, and where is
Like
it?
That's the 2 minutes I'm talking about.
Okay, and then what happens to Miss Love?
She leaves
She leaves. And then when do y'all go back on the record?
immediately.
Okay,
Well, no, I talked to Mr. Copeland for a second.
okay, privately or,
Privately.
okay. And then y'all go back on the record. And then does the record reflect everything the record reflects accurately? Other than whenever this conversation between you, Ms. Hilton, and Mr. Copeland allegedly occurred?
Yes,
Okay. Do you have a copy of the transcript in front of you at this point?
yes, Judge.
Can you kind of point out where this conversation allegedly occurs?
It's somewhere around page 40.
Okay.
Between 39 and 40.
Okay.
Your Honor, could I just get, if it's between 39 and 40, are there any specific lines?
Well, it was like off the record, so I wouldn't know exactly which line it starts back at.
Okay, but you had represented previously that Judge Glanville was not in the room at that point in time.
Yes, he was asked to leave.
Okay. So him being asked to leave isn't reflected. Is that
So
right?
separate time
Let's
then,
see.
because there was a short time he stepped out.
Do you remember who asked him to leave?
Miss Hilton.
Okay. And that's not on the record either?
No,
And you can't remember whether the court reporter stayed or left?
I can't remember whether she stayed or left, but she definitely stopped taking down.
Okay. All right. And when did you, sorry, Miss Love, go ahead. You know what? Go ahead. I'll save my questions.
Your Honor, I honestly defer to the court. Please continue. I have no.
All right. So after this conversation concludes, then what happens? And by this conversation, I mean the conversation you referenced that is not reflected in the record, but that takes place between you, Mr. Copeland, and Ms. Hilton. What happens after that? But if it's not in the record, it's not going to be in the record. So you just tell me from your recollection, what happens after that?
That's probably towards the last 5 minutes of this meeting.
Okay.
And so we go back on the record and
So the conversation finishes. How does everybody get back in the room? And how is it that y'all go back on the record? Give me the details of that.
she just, we just finished the off the record conversation and just Simone just says everybody can come back in. And then okay, wait, Judge, I'm sorry.
Mhm.
It's actually,
Your Honor, does the court mind if I sit?
Go ahead.
I would say that the conversation actually happened around page 46, 45.
45, okay. And is that conversation in fact reflected on the record?
No, but I don't know.
I mean, because, so how are you sorting out, oh, it's around 45 that it occurs?
Because I try to get the conversation on the record.
What did you say? To get the conversation, or to try to get the conversation on the record?
I say,
I'd like to hear it from your recollection without reference to the transcript
okay.
first, okay?
I'm trying to make sure. So I just.
So Ms. Hilton says, Judge, can you leave? And at that point, do you say anything? Like, no, Judge, stay, or anything like that?
No, she already told me in the hallway that she was gonna ask the judge to leave and have a
Okay.
conversation with him.
Okay. So show me where in the transcript y'all come back from the restroom break.
Well, you want me to, you asked me to.
Now I do want you to look
Okay,
at the
okay.
transcript, yes.
I agree. I think she's really sharp, positive masculinity. The judge is the best lawyer in the room. She is really, really sharp.
The security issue. Okay, I'm sorry. You asked what, okay, I think we came back.
No,
around-
Yeah, the restroom break, show me the restroom break.
See, if that's not in here where me getting up, I don't know how to find that.
Okay, so the restroom break y'all take, but it isn't reflected.
Yes,
Okay. Is the restroom break after Mr. Copeland's with y'all?
yes,
Okay. All right. And it's immediately after this restroom break that you and Ms. Hilton and Mr. Copeland have the private conversation?
yes, sure. And Judge, you asked me a question earlier that I didn't get to answer.
Okay, what's that?
You asked me, can I, without looking at the transcript, tell you how I tried to get it back on the record?
Yes. Can you give me a second before you answer? Because I'm looking for something in particular. All right, so y'all take a restroom break. You see Miss Hilton in the hall, y'all walk back in. Mr. Copeland's gone because he's taking a restroom break at that point. The court reporter is there. Mr. Copeland comes back, the judge comes back. And that's when Miss Hilton says, oh, wait, Judge, go back out?
Yes.
Okay. All right, now what were you gonna answer?
You asked me how did I get it back on the record?
Yeah.
So after the conversation, I say pretty much, I want to get what she just told him about what he cannot go to jail for.
Okay.
Because the whole point of the off the record conversation is he's trying to figure out, can he go to jail for lying?
Mm-hmm.
And so I'm trying to get back on the record that she says that she's not going to prosecute him for anything other than one thing.
Okay. Okay, and so y'all have had, the three of you have had this conversation. Judge is gone. You can't remember whether the court reporter's there or not, but then what happens?
That's what I'm saying. That's on
So
page.
then you say, I'd like to get this on the record, or,
No, we go back on the record.
okay, so how does that occur?
No, she just says, let's go back on the record. Simone.
So Ms. Hilton says, let's go back on the record.
Yes.
So you don't say, I want to get this on the record.
No, I just do my best to get it on the record when we go back on record. It's in the.
Oh, I see what you mean. You're doing, you say, you don't mean, I'm really trying to get this on record. You mean Miss Hilton says, all right, let's go back on the record. And then you try to like give a rendition of what occurred.
Yes,
Okay. And that is reflected where?
on page 48.
On page 48.
Well, between 47 and 48.
Okay. All right. And does page 47 and 48 reflect the off-the-record conversation that allegedly occurred between you, Miss Hilton, and Mr. Copeland?
Hey, E. Capone.
There's a part where I say, so he can go to jail for anything but what?
Yeah, and how do you resolve this?
Okay,
If stuff's not on the record, how does Whitaker find out why or what is supposed to be on the record?
and okay, page 51 specifically, I'm asking, I tell him he has to make a decision. And I ask, so if he starts testifying today, is he going home today? And then I say, but if he says he don't recall to everything, he'll be okay.
Okay.
'Cause
Okay. So, at that point, between, whatever you said, 47 and 51, y'all are back on the record, right?
yes, Judge.
Nobody's like declining to take down what you're saying.
No, Judge.
Okay. So anytime during that point in time, do you say, let the record reflect that Miss Hilton, Mr. Copeland, and I had an off-the-record conversation, and I'd like to put on the record what was said during that conversation?
No.
Okay.
And also on page 51, I say, I think, are you saying you want to get up there on the stand and say something?
Uh-huh.
And then it's no response, because he just looks at me.
Okay. All right. So does 47 through whenever that last page number was, does that accurately
This was a big
reflect
thing to get confused.
whatever was said during the alleged off-the-record conversation?
It doesn't accurately reflect, but it does. I do try to mention what we talked about, but it doesn't accurately reflect everything that we discussed.
All right. So was there something else that you discussed that you should have said, oh, and by the way, this also happened that you didn't say?
I'm confused, Judge. What do you mean that who didn't say? That
You.
Simone didn't say?
No, anybody during the alleged off-the-record conversation, when you're making this record, after y'all go back on the record, you said it still wasn't accurate. And you also said you weren't stopped from saying anything during that part. So what is it that you should have said that you didn't say?
Exactly, Ian.
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay, all right. All right, so when is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date, but somewhere.
Sometime in late June?
Yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you are an attorney licensed and barred to practice in Georgia, right?
Yes.
Okay. And as such, you have a duty of candor to the court?
Yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all of that happened, it's been on recess for so long.
So you've been in court when we've been in session for the last week or two, right?
Yes.
Okay. So I was presiding at that point in time, right?
Yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney, I believe that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay.
The transcript has
All right,
Hilton saying,
so
close your ears.
What is your answer then to my question?
Can you ask me again? I'm sorry.
Did you ever at any point in time bring to my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay, why is that?
Well, because of what I kind of just said, I don't
Okay.
believe that it was incomplete per se,
Okay.
minus the off-the-record conversation, but there are a lot of off-the-record conversations that are had that are not included in transcripts, and that's
True.
not unusual to me.
Okay, all right, so you don't actually believe it's inaccurate then?
No, I just think it's missing the off-the-record I'm not
Okay.
missing, I just think that the defense did not have knowledge of the off-the-record conversation.
Okay.
Not that it's missing from the transcript per se.
Okay. Because it was officially off the record, is that what you mean?
Yes, Judge.
Okay. And did you
Thank you,
ever,
King Divine.
if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay, so at some point you brought it to the defense attorney's attention? Is that how you decided to deal with it?
I had a conversation with the defense attorney. I don't want to say I brought it to them, but we just had a conversation
Okay.
about what happened.
All right, Ms. Love, do you have other questions for Ms. Bumpus?
Ms. Bumpus, did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hilton on June 10th?
That I had with Ms. Hilton and Mr. Copeland? Yes.
When did you tell them?
The same day.
Did you tell them everything you remembered about it?
I told them everything I remembered.
And do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour?
Was court in recess or was court in session when you told them?
Court was in recess.
Between the time that the conversation between you, Ms. Hilton, and Mr. Copeland ended, and the time that you told defense attorneys all of the details you could remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in session between the time that you finished your conversation with Ms. Hilton and Mr. Copeland and the time you told defense? What happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had the conversation with defense? Just in that moment, from chambers to conversation with defense?
Oh, no.
Court had not resumed?
No.
And when you said earlier,
I mean, because remember, we came straight down here and sat down and immediately started, so I didn't speak to anyone.
and when you were speaking earlier about when after Mr. Copeland came in and you said you weren't sure whether I was in the room? Did the portion about Judge Close Your Ears occur before or after Mr. Copeland came into the room?
For sure before.
Okay. And at that point, was the court reporter taking down anything?
No.
And at that point,
I think she was the mole for the details.
did the court give any indication, did the judge give any indication that he was paying attention to it, whatever it was?
I can't answer that.
Did he give
Thank you,
any-
Miss Abby.
Did you see any indication that he was paying attention?
I can't answer that.
Yeah, you can.
I don't know. I wasn't paying attention to him.
So no, as far as you know, he gave no indication. She's asking from your personal observation. Answer it as to that. That's what she's asking you.
I would have to say no, but I would also say I wasn't looking at him at all.
Do you remember Ms. Hilton at some point talking about the judge closing his ears at any time?
I don't remember.
And we're looking at the transcript at all, refresh your memory.
I'm sure.
Okay. Would you take a look on page 26, line 5 of the transcript? And since it's a part of the record, read from line 2 to the end of line. Let me just ask you this. Do you see where Ms. Hilton says, Judge, you might want to close your ears?
Yes.
Did you hear that phrase or something like that said more than once in that meeting?
Yeah, and before Simone got there, I know exactly what I'm talking about. So are you in here at this point?
So my only question is, did you hear that phrase more than once in the meeting?
I can't remember if it's that exact phrase, but I heard you say something to that extent, and I heard her say that.
Okay. Were you the first person, to your knowledge, that brought to defense's attention that there was in fact a meeting in chambers?
No.
Who, do you know, do you have personal knowledge of who that person was?
No.
How then do you know that you were not the first person who brought that to their attention?
Because they asked me about the meeting.
Did they give any commentary to you that led you to believe that they knew what was said in the meeting?
Yes.
What did they tell you?
Is it true that?
Sure.
Perfect timing, Miss B. I think they're about to get into this. So she clarified what was said. Gotcha.
Yes,
Thank you.
sustain. Can you be specific?
Who specifically came up to you and asked you about the meeting in chambers?
There were multiple attorneys that specifically talked to me at one time.
Would you please apprise the court of the names of those multiple attorneys?
Excuse me, objection, Your Honor. We're still far afield again of the limited subject matter that you asked me to stick to.
Your Honor, as it pertains to Brady or whatever information, I think it's quite relevant. Who knew what and when, as it relates to what was said during the meeting?
Okay, well.
But she can't divulge
I don't
privilege
know if
stuff
it's
to the other
relevant
attorneys.
Who revealed it, who revealed that a meeting occurred. Ms. Bumpus has said that essentially, if I understand you correctly, that at some point during the day immediately following the meeting, the day of the meeting, you had a conversation with some defense attorney or defense attorneys, and we can sort out who, where you relayed to them everything you knew and everything you recalled about what went on in the meeting, including the off the record conversations, right?
Yes.
Okay. You can figure out who that is now.
Thank you. Who was it? Name the attorneys that you referred to just a moment ago.
Just a moment ago with the question she asked me, Judge Whitaker?
With the one I asked.
I mean, it's the same topic, right?
Okay, ask the question again.
Which attorneys by name first came up to you and asked you about the meeting?
See, Judge, that's two different questions.
Then answer the question Ms. Love asked you.
I don't recall, but I think Judge Glanville did judicial notice of me on camera. I don't recall.
No, my only question to you is who first came up to you and asked you about the meeting?
I don't recall everybody who was there.
Who do you recall?
I recall Attorney Steele and Attorney Adams. And I can't remember who was the other person.
Do you remember how many?
How many
Lawyers were there when Mr. Steele and Mr. Adams came up to you an hour after the meeting and asked you about it? How many lawyers were there?
3, I think,
Okay. Do you recall seeing Mr. Schardt? Just throwing out names.
at some point.
Okay. So Mr. Schardt, Mr. Steele, and Mr. Adams, within an hour, is that accurate, of the meeting, came to you and talked to you about what happened in the meeting?
I would say yes.
Okay. Other than Mr. Schardt, anybody else you remember?
No.
And when they spoke with you, regardless of how they got it, did they share with you any details from the meeting?
Yes.
And what details did they give to you that they already had before you started talking?
Objection, this is not.
Sustained.
Okay. Last couple of questions, Judge. Ms. Bumpus, when you agreed to represent Mr. Copeland, did you, during the course of the meeting that you had in chambers, did you ask questions of the prosecutors or the judge about what the immunity statute meant or anything like that?
Yes, I asked a lot of questions because I didn't realize until the end of the meeting what was actually going on. That information wasn't given to me.
That's all.
All right, so Ms. Bumpus, you knew to show up for court that Monday because Mr. Melnick had asked you to be stand-in counsel for Mr. Copeland, right?
Yes, Judge.
Okay. Are you representing that Mr. Melnick simply said that and nothing else? He didn't give you any background about what you were walking into?
Well, what I'm representing is I was given specific instructions, and those instructions were, I'm standing in for him. If Mr. Copeland chooses to plead the fifth, which I anticipate he will do, then you won't have to do anything else. If he chooses to testify, we have agreed that he's discharging me.
Okay.
And I made that very
That's
clear
important.
to everybody multiple times that morning that that's what I was here to do.
Okay, but you had no idea that there was an immunity order in place?
No.
Okay. All right. Does anybody from the defense side have follow-up questions for Ms. Bumpus?
I have just a few, Your Honor.
Okay.
In your cross-examination, you said, quote, "She says she is not going to prosecute him for anything other than that one thing," unquote. What is that one thing?
I can't answer that. I can only assume it would be the unaliving of Donovan Thomas, but those are the words that she chose to use.
When you're saying unaliving of Donovan Thomas, what are you referring to?
I guess
YouTube
him being
friendly.
killed.
During cross-examination, Ms. Love asked you about some alleged retaliatory acts. Were those being discussed when Mr. Copeland repeatedly said, "I can claim all of this, I can take all of this"?
Nothing was being discussed.
What do you mean nothing was being discussed when Mr. Copeland said, "I can claim all of this, I can take all of this"?
He said that on his own, and that's kind of how the conversation started.
What was the subject matter being referred to when he said, "I can claim all of this, I can take all of this"?
Donovan Thomas's murder.
Okay. I have no further questions.
Anybody else?
Pretty big. That's the important part.
Well, Mr. Steele's making his way up, just so I am clear
Of
on
course.
this. You're saying that or are you saying that in the off-the-record conversation that you, Mr. Copeland, and Ms. Hilton had, that Ms. Hilton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she
Boom.
would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay, all right.
Still
So I
important.
guess more of a highly possible situation.
That would be the one thing that
There
could
you go,
get
you
him
guys.
in criminal
Yes, Judge.
perjury type trouble.
Outside that
Okay, thank you.
statute.
Go ahead, Mr.
There you
Steele.
go.
Thank you, Your Honor. I just wanted to do timing or sequencing you were asked about. When you left Judge Glanville's chambers after the entire, not bathroom breaks, after Mr. Copeland was removed from the chambers, et cetera, where did you go, if you remember?
I came and sat right there in the courtroom.
At that point, had you spoken with anybody to alert anyone that there was an ex parte meeting?
No,
Where did next time you saw Mr. Copeland was when? When you left the ex parte meeting, came into the courtroom,
up here. He was up here.
testifying where you're sitting?
Yes,
Okay. And then did the jury come in?
yes,
And did Mr. Copeland testify before the jury?
yes.
At any time during that moment when Mr. Copeland's testifying in front of the jury, did you tell anybody about this ex parte meeting that you attended
No,
or the contents?
no,
Okay. Do you remember there being a break at any point for lunch?
yes,
Is that the first time that you were approached?
yes,
Ex parte meeting?
yes,
True?
yes,
Did anybody, and that's after you were under no restraint, you told the truth?
yes,
And that was to myself and the other people you told?
yes,
True?
yes.
Thank you. Thank you, Your Honor.
All right. Mr. Schardt?
Can I ask one more question?
Sure.
After the lunch break, do you remember when I raised it before Judge Glanville?
Yes,
Did I do it right away after we spoke?
yes,
First time the court reconvened?
yes.
Thank you.
All right, and Mr. Schardt, come on up. And speaking of a lunch break, we're way past time for hours, so let's plan to do lunch right after we wrap up this witness.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes,
Okay, did you hear the Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
no,
Did you hear anyone from the state tell the defense on the record that an ex parte meeting had occurred?
no,
Was there any discussion about the substance of said meeting?
no.
Okay, thank you.
Anybody else? All right, thank you, Ms. Bumpus. You are excused. Let's take our lunch break.
Wow, wow,
Let's
wow,
come
wow,
back.
wow.
It's 20 till 1 right now. Let's come back at 2.
And thank you so much, you guys. I didn't want to overtalk
Just
people.
for my knowledge, does anybody on the defense team have any other witnesses as to this issue?
Not from Mr. Pender.
All right. Is the state going to have anybody?
If the court could just, I'm sorry for being obtuse, which exact issue is it that we are addressing? I know it's the June 10th, but what exactly are we addressing? So I can have.
I mean, the defense maintains that there was an unrecorded portion of this ex parte where Brady information was revealed to Ms. Hilton that Ms. Hilton did not then share. So that's our topic.
Whew.
Sure.
It's going to be interesting after lunch. It's going to be interesting after lunch. So thank you so much for the $5 for the protein bar. I'm ready. I'm starving right now. Thank you, King Divine. The point was that possible confession, and I'm glad we got that wrapped up at the end there. Thal, I had put this up on the screen. Thank you so much. Cat's making the mic squeal. I'm new to streaming. I'm trying to scare you guys. King Divine for 5 says, Bumpus, Love, Hilton was all friends, but Love and Hilton was trying to take advantage of Bumpus, and Bumpus didn't realize till it was too late. Yeah, I think that's a really good point. Plus, she got thrown into it. And you guys have touched on that in this chat. You guys were calling that out, that she got thrown into that meeting, and her testimony kind of reminded us of that at the very end there. B. Irving says, note to self, B. Irving is not hiring Bumpus to represent them. Thank you for the super chat. Dublin Mug, I wonder what this judge had put into her rulings this weekend, and if she's planning to change any of them because of today. This trial is broken. Does anyone think this trial is less broken today? Put a 2 in the chat if you think this trial is less broken. Put a 1 if you think it's more broken, and a 0 if you think there's no change. Thank you so much, Dublin Mug. We're going to look at the chat responses. Garrett, this made me laugh during the stream. Kayla pulled the grenade pin but forgot to throw it. She found the grenade at the end a little bit. That's really what we needed. Admirable says, "How I pinned this. How is she supposed to remember what's not in the transcript? I can't even remember what I had last week." And I think that's a fair thing to remember. This happens with witness testimony kind of all the time. One of the leading causes for false convictions is unreliable witness testimony. It's something to consider. Positive masculinity, thank you. I had referenced this midway. I think it's worth saying again that the judge is a really sharp lawyer. And then E. Capone, great to see you. Hello, my fellow justice junkie. Scales of justice in the chat. And King Divine is reminding us that Kayla Bumpus's point is that some of the stuff is not on the record. Meanwhile, Judge Whitaker is confused. Why it's not on the record? And how do we reconcile it? How do we reconcile it? And obviously we can't refresh Kayla Bumpus's recollection like you typically see with witnesses because it wouldn't be in the transcript anyway. So how do you even refresh her recollection? And Shaybeard, I appreciate you. This close your ears comment, I went and looked. It's transcribed as if Hilton said it. But at the same time, to me, does it matter if Hilton said it or if Love said it? Love got personally offended by the accusation, tried to weaponize that it was incorrectly remembered, and it could hurt our trust in Kayla's recall if she's getting that wrong. But it is technically transcribed to Hilton. Maybe this transcriptionist got it wrong. I don't know. Maybe there's a second time it was said and it's not on the record. But how do we know? There's no audio recording of the meeting because apparently Deputy Brown told people to turn off the recordings, the body cam. So there's it's problematic even if Kayla Bumpus recalled it wrong or not. And then Tavishia says, this is like watching my favorite team being down 50 points in a playoff game and I have $1 million on them. Oh no, with the Drake bets. American football is starting this week, you guys. Who's your team? I'm a Vikings fan because when I was a kid, I liked the fans in the audience. But thank you so much for the super chat and for a chance to talk about American football, Tavishia. King Divine says, Judge is saying Bumpus wasn't a good advocate. She was sharp and kind of rough, biting with Kayla Bumpus. Just flat out. I mean, it was palpable. And then Miss AB, thank you. I pulled this up during the chat, but yeah, so Deputy Brown may have mentioned they're all in this ex parte meeting, but Kayla has said on YouTube and now on the stand that she was the one that told the details of the meeting. And then clarifying what it was that she specifically said. Appreciate you so much. Good to see you live. Sarah JB, sorry, I tried to read your chat during all of that, but didn't want to overtalk people. But here's something to think about too. I feel so bad for Kayla Bumpus here. She's getting the riot act and sounds like she's gonna cry. I would not want to be in that position. I just wouldn't want to be. Positive masculinity, thanks so much, says, Whitaker said, it is on the record that there is going to be a meeting, so you were notified. Now it's a crime to say that there was a meeting. Yeah, it's kind of like what actually makes it a problem by these standards. And Miss AB, I wanted to read this. It's like so long it was covering the transcript, the captions. This is absolutely crazy. The meeting should have never happened to begin with. Woody should not have been forced to testify. They only wanted to play these past video interviews. Exactly. That's why they already wanted to have the idea at the forefront that they were going to impeach him. Because then they could try to introduce this stuff, these videos, to impeach him. This is ugly. I totally agree. Mahadi de Jesus, good to see you. Miss Love did her tactics, her shouting, her half-truths, cloudiness, questioning. What do you guys think in the chat? Do you think this is better or worse that Hilton is here or gone today? I'd be relieved if I was Hilton. I think it's coincident. I think it's a coincidence. I think she should have planned her vacation a little bit better. But maybe she planned it like 3-4 months ago. It's hypocritical because they came at Melnick for his vacation and tried to act like he did it on purpose. So I feel like we should accuse them of doing it on purpose, just to be fair. But I think she's probably lucky and relieved that she's not there. James Dean, thanks so much for the 2. Great job breaking down motions and other info. I'm sure we'll get some motions today. Kushizuku, I think there's more ex parte meetings. Have 2 more been revealed? Let me know, because we can look at those if there's knowledge that 2 more in addition to June 7th and 10th came out. But I'm sure there's more the defense doesn't know about. And then Big Tit, I love saying your name on chat. I have the excuse. Did the off-the-record convo contain Brady, or I'm confused? I think it contained Brady. What do you guys think in the chat? I guess it's kind of up to the judge, but preponderance standard. It doesn't need to be proven that something was said off the record. And I think Kayla's testimony is enough for a preponderance standard. And that's true, Ken Thompson. Thank you so much. And reminder that what Ken Thompson says is not legal advice in these super chats. But Ken Thompson says, can't have body cam on in case it catches attorney privilege. James Waller says the level of unprofessionalism is staggering. And then Lottie B, good to see you. Unreasonable to expect Kayla to remember details. She was ambushed with that meeting and she was probably disoriented. And then she was missing some of the context going into it. She just knew it was going to be some intense trying to compel someone to testify who's planning to plead the fifth. Which is, you know, kind of tense to start with if you ask me. You're going into it tense. So I see a lot of people saying that the Giants, Saints, you guys dropping your American football teams. I got to clarify because I know some people would think football means soccer, football. And then, guys, I got to take a comfort break myself, get some lunch. I think we're caught up to speed with the chats. And Justice Fly sent one for just pure love here, just $1.99. Thank you so much. But I do want to take a good, like, 15, 20 minutes to get something to eat. I do have a protein bar, but I want food, water. And then we'll come back. I'll leave the stream on in case the court comes back in while I'm gone. And see you guys in about 20 minutes. All right? We'll be back. Appreciate you guys. And hold on, I'm popping back in, because remember, Kayla probably didn't want to say what may have really been said by Woody. It was her client for at least a day. She shouldn't divulge that. And, you know, she says she's still trying to look out for his interests. She said that in that YouTube clip we looked at. So, good note to close out on here for our comfort break. I'm just gonna finish eating and then I'll be back. I need 5 minutes. I'm starving. I'm back, you guys. I had in my porch, my window, the screen like came out. There's like a little rubber seal that keeps the screen in place. The screen was like flopping in and out from all this wind. So that was not a good time. That was not fun. But I am back. I ate my lunch. Let me know what you guys had for lunch or dinner. And then Army Nurse here, getting back to these super chats that I missed. Hilton was in the court when the judge asked if anyone knew if anyone was going to be out of court, and then she didn't say anything. That's interesting. I really think she's a bit of a hypocrite for leaving when Copeland's supposed to come back on the stand. Like, for Melnick, it's different. Melnick would have only been there to represent a client that's a witness. But Hilton should be aware that, you know, this could be crucial testimony for a witness on the stand. I don't know. Thank you. It's good to see you, Army Nurse. David, thanks for the 199. Thinks the judge will keep pushing. And I kind of think so too, although I don't know what's going to happen when we come back from this lunch break. She said the topic of conversation is going to be about everything we've just learned. And then Terrell, I had bookmarked this because it reiterated what David was saying. Terrell also thinks that the judge already knows what she's going to do. And then Cash, I had pulled this up for page 46, line 17 of 6 through 10 of the transcript. Thanks for bringing that up. I had brought it up on the screen. And it was that weird moment where for 2 minutes, Judge Glanville steps out. And again, that is 46 pages into the transcript. So I'm going to share this link. So that's a searchable transcript link. Cash Money Cass is going back and looking at the receipts. But there it is. And then Jar, or Yar, as Nick Starro says it, raided over from Nick. I think I was actually out in my porch fixing my window screen when this happened, so I missed it when you came in. Sorry I missed the Vikings raid. But always so good to see the Vikings flood the chat. As you guys learned today, I am a American football Vikings fan, Minnesota Vikings. For no reason other than that they look cool in the stands. I liked them a lot as a kid. And I didn't get to see Nick pop in here. I know Nick is getting ready to fly to the United States, but if he's in here and I missed him, hey to Nick Starro. And then this is Nick's channel, by the way. So most of you know Nick by now, but if you don't, he's been covering testimony, gavel to gavel of this whole trial. And then I saw a lot of comments, a lot of thoughts. I know Kayla was live. A lot of people like, you know, she might wish she was never in this situation, or she should have been more prepared, or, hey guys, remember, she didn't plan to be in an ex parte meeting. She didn't know that that's what was going to be going on. And when she found out, you know, she said what she remembered, but maybe it's not worth blaming her to not remember every detail back and forth. So I think you guys had a wide range of opinions I saw coming in and coming out when I was at my computer eating my food in the silence behind the closed door over here. And this is it right here, guys. Do you think it's Kayla's fight? Everything aside, just this question only, box in on it. Is this Kayla's fight? What do you guys think? We're coming back from wrapping up from the lunch break. I believe she said 2, right? She wanted to come back at 2. So we've got like 12 minutes, and this is really the big question. We had Melnick testify, and it's almost like that was a little bit forgotten. That was a little bit forgotten. And no, I saw the chat. I love Bruce Rivers. Does he go on other shows? I love Bruce Rivers. I live in Florida. That's why I have like the Debbie rain right now. The wind and rain. And yeah, mostly not her fight. It was 2 months ago. Jay Capo says Kayla did a good job for the position she was put in. And she also has to look out for Woody because they are more than just attorney-client, and she can't throw him under the bus. Yeah, not her fight, not her fight, not her fight. And did she say she didn't know what an ex parte meeting was? Because I think Judge Whitaker looked at that like she needed to define ex parte for her. But I think Kayla was trying to get at, I was shocked that that's what was happening. I didn't realize it was something that wasn't disclosed to the defense until Brian Steele made an inquiry about it. So I was a bit, it could kind of go either way, depending on how you interpret Kayla's reaction. But I personally interpreted it as, I didn't realize they were doing this ex parte and the defense didn't know. But I hear you. And the judge had the same concern. Badger says yes and no. There you go. And then no one told her she would be called. Not her fight. It's not her fight. She has cases. Yeah, you guys, I mean, this is pretty uniform down here. Ghost with a maybe. I think I'm glad she jumped in the fight. And here we have, this is interesting because of the assertions from Love and Hilton about Melnick. Really Love's assertion about Melnick injecting himself into the case when Copeland wasn't apparently talking to him. But here Dwayne says she, as in Kayla, possibly injected herself. Not Kayla's fight. Taylor Dutton says she should have been prepared. Sharonica says it's not her fight and she did the right thing. Coco says, and I saw Judge Glanville auctioning out double dates with the lovely Coco. No, she's basically a whistleblower. People just like drama instead of focusing on facts. Florida homies, that's what's up. Yeah, Looney Boy says if I was Kayla, I'd be getting pissed. I'd be pissed for getting roped into this clown show. Yeah. And yeah, so they did all these lies, but what about the phrase, I don't recall? And what's interesting is, how do you guys feel about any witness using the phrase, I don't recall, after seeing Simone Hilton say, just say I don't recall, because then we can't get you for perjury. So you kind of had Hilton coaching people to use that phrase. And now a witness is using that phrase, I guess maybe against the state, maybe just to not disclose something, or maybe because she didn't really recall. But the state kind of instructed a witness to do the exact same thing, no matter what that I recall actually meant. Isn't that interesting? Kushizuku, thanks for the $9.99. Having knowledge that Woody was pleading the fifth, and them trying to throw it on Melnick exposed the ex parte. The Brady evidence was Woody saying he was pleading the fifth, even with having immunity. Yeah, and I think that was important. Hearing that part where Kayla said, look, Melnick said I think he's still going to plead the fifth. And if that's what happens, we need to be discharged. We can't represent him as a client. Because it's, it'd be a violation of your candor to the tribunal to represent someone knowing that they're going to plead the fifth on the stand. But yeah, then they don't disclose this to the defense at that point in time. The defense wasn't disclosed any of this. Just crazy, crazy stuff to think about the timeline. Kayla got some important stuff out there. It may have taken about 45 minutes to do it. But she did get this out here that Melnick told her, hey, I need you to go in there, stand in for me. Because this witness might plead the fifth, and if he's going to do that, we need to discharge ourselves. Oh, so you're in Florida too. Wait, where'd it go? I just saw, this chat is moving fast. There we go. So you're in Florida, you can't let the dogs out. Yeah, it's crazy outside. I'm on the other side, but the wind is really bad. The wind gusts are really bad. We had down the street, there's news reports that like the fire trucks and ambulance, like you hear the sirens, they were zooming down the road, and I looked online and like some mobile homes or RVs were tipped over and lightning struck it and opened up a gas line. It didn't ignite the gas line, but that's why I heard emergency vehicles going by like crazy because the wind is so bad, even here on the East Coast. And yeah, Classy Beats, good to see you. Great reminder. She said she didn't know it was a meeting. And that she didn't know that they were having an ex parte. Great point to Kat that if anything, as far as Kenneth Copeland, this is Melnick's fight in the long run. And now maybe a battle between him and Love, like permanently. And yeah, again, it all comes down to her trying to say, I was blindsided, like I didn't get what this was. in whole. I may have seen pieces of it. Something didn't feel right. It felt tense in the room. I understood that something about pleading the fifth was happening, but it unfolded really fast. Lots of movement in this room. And then when the meeting's over, I go back into the courtroom and I see Brian Steele trying to make this inquiry. And then I'm like, oh, that was an ex parte that the defense didn't know about. Oh boy. And Garrett asks with the 5, thanks so much, says, Steele made a huge point with the timeline. Woody took the stand before lunch while Hilton withheld the Brady. Yep. And I'd argue there's still some things that weren't disclosed. Those conversations that Hilton was present for, if that stuff happened, it should have been disclosed. Whitaker can't ignore that. I really think this is huge. I do think it's huge. I don't know what I think Judge Whitaker's going to decide. But I think there's enough on the record for a preponderance of the evidence standard. Not just through Kayla, but kind of through Melnick too. That there were some things off the record that the state still has not disclosed and that are not disclosable just because we said, oh, we released the transcript, so no more Brady. Because that's what Whitaker's been saying. You guys have the Brady. What's the issue? What's still left to be disclosed? Well, we found out now, from about a witness and a half, if we include Melnick, that there was a little bit more context. It's not in the transcript. It's a great point. Honestly, at the end of the day, you guys, this infuriated me a bit more that this ex parte even happened. That's kind of where I'm coming out of it from. It really doesn't matter to me what Melnick or Kayla or anyone really said. What matters to me is that there's still stuff that can't be verified because they tried to make it happen behind closed doors. We have no confidence in it. Who has confidence in this? And then Rob, there we go. We get a full-on yes. So Rob the traitor says she, meaning Kayla, made it her fight when she was on YouTube talking about it. I agree. She did say she didn't want to step on his interests. But Doug wanted to bring in that TikTok. More could possibly be suggested to come in if necessary. You know what I mean? I still don't personally think it's Kayla's fight to fight this. But the binoculars came into her direction. And you guys, we do have, there we go. JL is kind of middle line here. Kayla was just inconsistent. Is a transcript complete or not? I don't get it. I think her stance, and she said this on YouTube, but I think the transcript is complete in that it captured things that were on the record. But there were moments that we were off the record that wouldn't have been captured. And they might not have been captured because we were off the record. So she's essentially saying everything wasn't captured, but I don't know if it was supposed to be. If that makes sense. And then Kelly Doyen, thanks for the 199, says praying for truth, nothing but truth and justice. And that would give us confidence in the system. And I always love your glamour shot, Kelly. I love the glamour shot. Thank you so much. And then Phil Pashting, or maybe it's Pasting. Pashting says, is it still considered Brady evidence since it was said in an off-the-record conversation? It should be because the state was present for it. The state was aware of it. If the state's in the awareness of it, and it's something that is considered Brady, the state's aware of it, they should be disclosing it to the defense. Point blank, period. It'd be different if it was just Copeland and Kayla. But it seems like it was Hilton, Copeland, and Kayla when certain things were said that the defense to this date still had not been disclosed unless we count disclosure from Kayla Bumpus. Which you heard Love try to make that argument. Oh, you guys were in the hallway, so clearly this information was disclosed on June 10th. Because you were in the hallway telling which attorneys? Keith Adams, Brian Steele, and maybe Brian Schardt. So, in effect, Love was trying to make the argument, if these things were said, it's not a Brady issue because Kayla disclosed it. The defense was aware. I don't think that's a good argument from Love, but she did try to make it. She did try to table it. I don't know if you guys caught that line of questioning, but that's what Love's angle was. Yeah. Okay, it looked like we were a bit behind on the timeline, but we should be up to speed, and they're still not live. Well, we'll just do this. Okay, just wanted to double check because I didn't know what was going on, but we have some movement. We're coming back. We are live. And David, it's just when I see them moving the camera, it shakes a little. That's how I get the clue that they're coming back. All right, we're back. And I'll check it out. We might talk about this during a break then. We'll recap what Kayla said, but apparently she didn't know she was being brought back in today.
No, he's not.
All right, well, in the meantime, one thing we can do that is not anything of substance that is important is I want everybody to speak into your mic and let's make sure each of them works all not at the same time, one
Oh
at
my
a time.
gosh, a mic check.
And if there are any that don't work, I'm going to try to see if we
DJ
can get a
Whitaker.
hold of one that does. So can we start with the state?
Yes, Sean.
All right, and I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more.
Good afternoon.
All right. Yeah, you're just gonna have to get it closer.
User
to
error, I think, on my part.
User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Schardt.
Testing, Your Honor.
Great. And then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross-check mics off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the Infiniti and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes,
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. Yeah, I do believe that there was more that she said that was disclosed other than just the Infiniti.
Okay, what else?
Specifically, when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. With that,
Yeah.
that actually came through more clearly than I think anything else, Your Honor.
Okay,
Yeah.
so,
May I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay,
I
it
apologize.
happened.
I
Oh, your
silenced it.
computer? Okay.
I silenced it.
All right, thank you. So, Ms. Love,
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information. My understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they have, obviously, they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland.
the alleged off-the-record meeting.
The alleged
Mhm.
off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again, and the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this would also be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too, but a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about. This hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the
witness up.
unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor, can I make a statement before or while Investigator Long is taking
Yes.
the witness stand? I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts, knew already about the ex parte meeting and what occurred and the contents therein, and that is just false. That is just false. That was not testified to by Ms. Bumpus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well? And that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpus, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Spoke. Miss Love is who I meant, but I think because Investigator Long has taken the stand, my mind may have been been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abbate, my ruling with regard to that was that's not even relevant until such point as there might be some other defense motion filed, at which point Ms. Love can call Mr. Abbate. So, okay, so call Investigator Long. Thank you.
Here we go.
Raise your right hand. You swear firm testimony you give the truth, the whole truth, nothing but the truth. First name for question.
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's going to be testifying as an expert, so let's just, cut to the chase.
Tell us for the YouTubers.
He's going to be testifying as an expert right now.
We want to know.
Fact witness.
Yes.
Okay.
Yes.
So maybe we don't need to go through all of his background. All right.
Just, good afternoon, Deputy Chief Long. Would you tell the court for the record where it is?
This might be
you
the one
work?
that dropped
I
off the
work for
thumb
the Fulton
drive
County
to
District Attorney's
steal.
Office,
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As the
Yes.
investigator? And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in line and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
He's going to want to say that he was there and
Are
didn't
you all
hear this
required
stuff.
to remain with us at all times?
But
during those types
Love and Hilton weren't
Yes.
together all the time. So
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies. And with Kenna Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there
remember, he's
ever
had
a
practice
time that
testifying.
you all went off the record at either attorney's request, that is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you being you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room,
Okay,
except for Mr. Copeland and the deputies.
okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No,
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, I can claim all of this?
no,
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Thank you, Cassandra. This is one of those cases.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No,
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you
And remember,
were
you guys,
in chambers.
he's testified
with Ms.
before, so
Bumpus,
he's going to be
Mr. Copeland and Ms. Hilton.
calm
Can
and
you tell the
collected here.
court the topics that you discussed, that not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
the topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
He looking in one direction the whole time he talking.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton...
All right, hey, back up. So is it your testimony that there was one brief off-the-record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for
I don't think Love liked that
restroom.
answer.
Okay.
She said,
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before.
yeah, he's
Ms.
going to
Weaver
get torn
began
up
to
on
record
cross. Wait.
everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to
No, she
get
was not in there.
clarification. So this was after a bathroom break.
Right.
They can't call
Ms.
Weaver
Hilton
as
and
a
Ms.
witness.
Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in.
Okay.
And then Ms. Hilton did ask, she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements or inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay.
But she said she knew everything.
So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Sure did.
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line 11.
Line 11 is I can purge and get out of jail.
I'm sorry, line 19. If you'll just take a look at it, is that an instance that? Is
Line 19 is Hilton saying that's different.
To the type of the conversation that took place off the record that you were just describing for the court. And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton
What a weak
says
argument.
yes. And Ms. Hilton in line
You want to say we
24,
talked about
page
something
50
similar.
says it's not what
So it
you're
doesn't matter what we
saying.
talked about off the
No.
record.
What you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection, leading.
There we go.
Sustained.
It
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments, any comments that were the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, leading.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't going to take credit or say he did something he didn't do.
The state told him they weren't going to question him about anything. So why would he say that? Why would Woody say that?
In response to a question about the murder of Donovan Thomas.
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
The state told him they wouldn't question him about things he may or may not have done.
Making comments about Donovan Thomas that Mr. Copeland didn't made any comments about.
Other than if he got on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made. And then he said he wasn't going to get on the stand to do that.
Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray Infiniti that the state, about having information about the Infiniti that the state doesn't know?
He never said anything about an Infiniti to me or Miss Simone, Miss Hilton.
or you didn't hear it?
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to want to know if you ever endeavored to find out what he may have said to her privately.
No.
You guys get what I'm saying though, right? He's trying to clean up what could have been said off the record that wasn't captured. Oh, he said he wasn't going to get up there and lie about anything, which doesn't match what Kenneth Copeland got up and said on the stand.
Go ahead.
Would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate an investigation. And I would assign one of those lieutenants to assist.
Well, you couldn't. He had use immunity. You couldn't. He had use immunity.
Of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
leaving the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of the off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the Infiniti, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
Hilton's a necessary witness. And she's on vacation. Hilton is a necessary witness.
My absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right. Thank you. Anybody from the defense?
Here we go,
side
defense.
Have questions for Investigator Wong?
Who said they were playing rock, paper, scissors?
Miss Love, do you need a cough drop? Because I actually have some if you need one. Okay.
They ask her if she needs a cough drop. That's nice, but it's also funny.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off the record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I have it mixed up, was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off the record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay, and that was before what we're deeming the off the record conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Oops.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right,
Yeah.
thank you.
We can look at Miss Love.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain.
I mean, that's in the
difference
transcript.
between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
Exactly this.
what do you
Thank you,
mean what she said?
Marlena.
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yes. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this is me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would seek perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hilton's mouth.
Yes.
Okay, so Ms. Hilton specifically during the off the record portion referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas that case into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up Donovan Thomas murder.
Right.
He doesn't want to answer.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Why would she do that? Why would she know?
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
Who else would have said it?
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
It's the same thing.
I have no further questions. Thank you.
Thank you.
Wow.
Anybody else?
I think he was contradicted. I think Schardt got what he needed. Because it seems like he suddenly wasn't saying that they never talked about Donovan
How are you,
Thomas.
sir?
Now
How you doing,
he
Mr. Steele?
didn't want to answer
How
that
you
question.
I'm doing fine. Blessed and highly favored.
Can I answer you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, relevance.
Sustained.
What,
I want to know.
At what point were you initially told that you're going to this ex parte meeting?
Objection, relevance.
I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hilton, I believe. Yeah, because of course we had to
Thank you,
escort him
Penny.
over to the judge chambers.
And did you escort, when you say them, who did you escort to this? Say one more time.
Ms. Hilton.
And was Adriane Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you, Your Honor.
You're welcome. Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Or Steele's back.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, did anyone tell me not to say anything?
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews. While Mr. Matthews is making his way over, what is your recollection as to sort of
Judge has her own questions.
when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No,
Did you make any written notes of any of the meeting yourself?
no,
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying.
Yep, he was.
Before this honorable court, correct?
that's correct.
Okay. Did you know this morning before court?
So why
that
were you here?
You might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualify?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything for we charge, but
But
she
you can't, if
did,
not with use
mention the
immunity, that
fact
doesn't make
of,
sense.
I can only speculate, I was use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mhm.
Thank you.
Any more questions from the
Anything
judge
else
herself?
from the defense? All right, is the transcript before the witness at this point? I don't know where it went to.
Oh, so she has questions. She
Yes,
has
Your
questions.
Okay. Can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41?
Okay, so this is Hilton saying, I know he's lying. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it, Copeland, but it's up to the judge to do that. Hilton, no, it's up to the state to bring charges. The court, I don't have anything to do with that. Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia.
Okay.
Copeland, can I talk to my family and I will make my decision right after I hang up the phone? And then Kayla says, he's saying he hasn't been able to speak to anybody. Hilton, his sister just called us. Copeland, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. Hilton, we have no knowledge. We did not know that you. And then Kayla says, he hasn't been able to do anything, speak to anyone. Copeland, the jail system down, but y'all still putting people in. Hilton, that part I don't know. I know we have been in communication with your sister, and I don't know if she's asking him to read all this. Because she just said page 41 through 42. So he might be trying to read and come up with something to say, or he's just not reading very quickly. But the use immunity thing drives me nuts because when we read the transcript, the first time the June 10th transcript came out, we were saying, like, can you even trust this DA? Can you even trust this DA to say, hey, we're not going to use anything you say as a lead?
Characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements.
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay, and does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in.
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Great question.
Give me just a second. Let me look a little past just to make sure.
No, refresh your. That's a weird thing to refresh your recollection on. I don't know. You're not refreshing your recollection. You're looking for an answer. If you ask me.
It happened after.
Okay.
Does he mean the transcript happened after or the bathroom happened after?
The transcript, do you think you might be able to figure out about when that break and off the record conversation happened?
I will take a look.
And I mean, you may or may not be able to, but if you can, let me know. If
How did you just remember it happened after while looking through specific pages? Wouldn't you have seen the page where you remembered it happened on? And that's what made you go, oh yeah, it was after. But now you still don't know when it was after. This is to me, guys, this doesn't pass the smell test. Like, you don't have to agree with me. This is my opinion. And Hilton's on vacation, you guys.
Your Honor, I believe. Page 52.
Do you know what you believe? Page 52?
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you.
Ooh.
Why can't we look at the camera
ahead, I'm
footage
sorry.
in the hallway?
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see.
This is handing the document. Glanville hands a document to Kayla Bumpus and exits chambers
I think
with
somewhere
Simone
around
Hilton.
there,
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Clopen, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, because
So it's right before that the off-the-record
Yes.
conversation occurred? Okay, thank you.
So Long wouldn't have been there.
All
It's
right.
noted
Any other
that Long.
questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. Ms. Love, anything?
Yes, Your Honor, thank you. Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hilton?
Yeah, Ms. Hilton. Yeah.
Was there any time you are aware of that Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right, investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not
Okay.
at this time.
All right, any rebuttal evidence from anybody on the defense side of the room?
So you want to call Hilton?
All right. Anything y'all want to suggest that this actually means?
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get the site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that Your Honor and the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct,
Okay.
or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
I don't know. What are you guys thinking? Because she's leaning in a little bit. I think y'all get caught up on super chats, you guys. I just didn't want to overtalk. I know there was some dead air with Detective Long, but I think his
So,
silence was also
I
important.
filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judge's chambers to have a discussion. And there were at least 2 discussions that took place. I'm assuming that there was a third discussion, which may have strictly involved the grant of
Scheduling maybe, but
immunity.
All right, well,
definitely a third.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So,
Right.
I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte. But these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under the exception to begin with. Provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it. And then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in
That
this
bad,
case
that was
where
wrong.
the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
All right. I would prefer that since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent
I understand.
anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? I've got it somewhere.
Okay, yeah, I've got it right here, Your Honor, from Ms. Persfield's email to us.
I've got it. If you've got it at hand, go ahead, but if you don't, I've got it now.
Okay, I'm trying to find out exactly, try to figure out where it was. Okay, paragraph 11,
ahead.
I'm sorry.
Paragraph 11. Mhm.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I've provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a
Correct.
couple of days
About
ago.
goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right,
that deals.
can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it for
asked,
now. I have it.
you asked where we are right now, and that's from my perspective, that's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, Your Honor.
All right.
Thank you.
Okay. And if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abbate might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate.
This is going back to
I don't mean this
Melnick
very
saying
instant,
he's not
'cause
paying
I'm gonna
me.
hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Schardt. I emailed it earlier today to your honorable court's coworker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3, 745 Southeast 2D 299, 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court, and
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And you've inherited a case that has a lot of history and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So
Good job.
That's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement. I don't know if you've read it. So
I read your motion and I looked at the portions that you were talking about.
hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the fourth time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory, but it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Schart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing. whatever it is that had been talked about before. That's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to. And I am considering that right now. So rest
Show
assured
love.
that
Put
I
love on
am
the screen.
aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out.
Yes,
Thank you.
thank you.
Appreciate it.
All right, so, we're going to leave the screen on because they come back randomly. Last Friday, they came all the way back. Guys, that was a big little turn. She says she takes Brady very seriously, looks right at the prosecution. She thinks everybody should take it seriously. Said the prosecution should. We can read into that as she's considering that. Oh, are we just wobbling the camera? This is why I leave it on, you guys. Thanks, chat, by the way, when we had refreshed the feed. You guys had let me know that, when it refreshed, the captions were blocked and we got to move them again. So thank you for those, those observations. Don't ever be too shy to point out that the captions are blocked. I want people to be able to read what's going on, even though the captions are kind of wrong sometimes. They're still helpful rather than just not having them at all. But wow. Wow. I want to play one clip, and I'm going to link to it as well. This is from I'm Not a Lawyer, But. And she's been on this channel. A lot of you guys know her. She does great content on this trial and more. So this is to her Twitter if you don't follow her over there. But I want to show you this clip that she recalled this weekend. She had said today's YSL hearing, and again, this is on the 2nd, so Friday, made me remember this awkward exchange when Hilton asked DK about robberies he's committed, and when the judge said don't answer that, Hilton mentioned use immunity, but in the weirdest way. So think about this in terms of them saying there weren't other meetings that Detective Long was present for. And he apparently wasn't present for June 7th. Make this bigger. Here we go.
Now, you talked about the fact that you would rob people. When did you start robbing people? At what age?
I can't remember what age I was.
Have you been caught for every robbery you've done?
Don't answer that. Rephrase that.
Your Honor, we would be given any type of use immunity. If
I'm sorry?
anything would be past the statute of limitation, and we would be given a use immunity.
I don't care. Just don't, he's not gonna answer that question.
Okay.
You can rephrase the question, but he's not gonna answer that question.
So what do you guys think about that in retrospect, looking at that now? So this was a great capture. If you're on X, you probably saw her say it. I don't know if she did a video talking about this. I know she did a recap of Friday, but I think it was only on X she had done this recall. Great thing to remember. So I dropped her YouTube in the chat and her X post. So make sure you're following her. Great channel all around. But what do you think of this in retrospect? With Hilton saying, oh, he would be given use immunity. The judge doesn't want this to be talked about in open court. Seems to be trying to pump the brake. And we have them acting like we've disclosed when Detective Long was saying he wasn't present for other ex partes. And when the judge was like, all right, well, we probably cured that on Friday because the state said that was it, that there were no other meetings. Love was shaking her head. But what about stuff like this? What about these other witnesses where we have this interesting stuff that seems to be the same type of thing? What do you guys think? So great find by I'm Not a Lawyer, but also known as Mel. Keep this up here so I don't miss anything. And then, let's see. I do see a little bit of movement there. But I think I was here. So, Kushi, so sorry guys, I don't like to block. I don't want to talk over the court. So the super chats got built up. I tried to pull some up on the screen that were relevant. But I didn't want to talk over anybody, and they were all talking all day today. No breaks. So Kushi had said, having knowledge that Woody was pleading the fifth, and them trying to throw it on Melnick exposed the ex parte. The Brady evidence was Woody saying he was pleading the fifth, even with having immunity. Exactly. And Schardt's recent argument, you had commented this earlier, but Schardt just brought up that argument again. The right to be present at a critical stage. Well, providing a transcript after the fact, and taking it at face value that transcript reflects everything that should be reflected, doesn't undo the right for a defendant to be present at a critical stage of the trial, right? So this is a great comment, even though you left it earlier. It ties in really great with Schardt underscoring right to be present during a critical stage. So thank you for your super chat. Sorry it took so long to get to. Garrett, I tried to get this during the timeline. Steele made a huge point with the timeline. Woody took the stand before lunch, while Hilton withheld this Brady. Whitaker can't ignore this. Mistrial with prejudice. And again, separate from the Brady issue, right to be present. A transcript can't cure that. Providing a transcript after the fact can't cure that. I don't know, do you guys think she's leaning into this, Judge Whitaker? And then Rob, I think I pulled this up, it was short, but, you know, we're talking about, is this Kayla's fight to fight? Rob had said, well, she made it her fight when she was on YouTube talking about it. And, you know, I don't personally think it's her fight. And Rob, are you still in the chat, Rob? You don't need to super chat it, but are you still in the chat? What do you think about Detective Long and his testimony that he just gave us? What do you think about that? And then Marb the producer, maybe it's Marby. So Marb the producer or Marby. Kayla could have done better on the stand, but regardless, prepared or not, she talks about this case hours on the day this case made her popular. So I'm not mad at her, just thought she could have done better with her responses. She did say she was nervous, and I think we all wanted her to do better with certain responses because we want to hear the answers that our ears are already opened for. So, but valid point, you know, I saw a lot of people in the chat sharing their personal stories where either they or someone else they knew has been on the witness stand before, and how it could be nerve-wracking. And maybe they didn't expect to kind of be in that position. And I do think one thing to consider is Detective Long has given testimony before. It's kind of like part of the job, you know? So he's had more practice giving testimony than Kayla would. Kayla might have experience on the floor dealing with someone else that's on the witness stand, but being in that position on your own might be a little bit different. But yeah, so someone doing better with the responses obviously could have tightened up, could have been less confusing. The judge asked a lot of questions about, can you just clarify for me? Can you clarify this timeline? This is still confusing. Hold on. Before we get into that, can you clarify when this happened? So I think you're right that the judge was looking for this. These pointed responses about when and maybe what was happening when. So thank you so much for your super chat. Bama Girl says, will they go after Woody if there's a mistrial? So that's the interesting question, because with use immunity, if you read it and take it at face value, if you trust it, with use immunity, the state is not supposed to use anything that Woody gives as testimony as a lead to go and sniff out something that they can prosecute him for. They're not supposed to use it to follow a pathway that leads them to the end of the trail, the destination. But what if they get a lead from his testimony, go and search for everything they need, and then just try to say, well, it wasn't his testimony that led us there, it was something else that led us there. So the use immunity is kind of only as good as you trust it. Plus, it doesn't prevent you from being prosecuted from something that someone besides the state of Georgia would want to prosecute you on. So just think about that. And it certainly doesn't protect you from any retaliation outside of the courtroom. So use immunity isn't complete protection by any means. And even what use immunity does protect you from, you can only trust that as far as you can trust the prosecutors to keep their word. Use immunity, can I use this as a lead? Something that you testify. I can't use that as a lead to go and find something and do some digging to find something to prosecute you for. And I think going back, that goes back to the question, when Long was on the stand, he was trying to say that this private conversation off the record, well, they weren't asking him specifically, they weren't specifically talking about the Donovan Thomas murder. He kind of contradicts that and doesn't want to answer that later. But the first time he's talking about it, he's like, well, Hilton was speaking generally that, you know, we're not going to use anything against you. But my question was, what prompted that conversation? Because in the transcripts, we can see on the record that Hilton already says to Woody, or says to Judge Glanville that we've explained to Woody. She said this on June 7th also. We're not going to ask you these questions. Which is why their big fear was that the defense is going to hammer you about these same things that we're not going to question you on. So if Hilton was already explaining that to Glanville and saying that she explained that to Woody, and we see her on June 10th explain that to Woody in the transcript, Detective Long's characterization of the general conversation that might have happened off the record doesn't make sense. Doesn't make sense. Why would Woody be expressing concern about something the prosecution's going to ask them if beforehand in the same transcript, prosecution says they're not going to ask them anything, ask Woody anything? I think he was trying to fill in blanks, didn't have the information, but tried to act like he did. But will they go after Woody if there's a mistrial? Technically, they shouldn't go after him for anything in his testimony if they gave him this use immunity deal, but do you trust the state? That's the question. Do you trust them to follow their word on that? And then Garrett S. is just like the Baldwin case, DA does not decide Brady. Great point. You know, if there's something that should be disclosed to the defense, maybe the defense will use it one way, maybe they won't use it at all, but it still should be their choice as to how they're going to use it. Do we want to poke holes in this witness's credibility because of something that was disclosed, Brady evidence that's disclosed to us, or should have been disclosed? The state can't just decide, oh, well, they're not going to use that in their case, or it's not relevant, we don't think it's relevant, so we don't need to disclose it or tell the defense. So, and that's why, you know, you guys have been riled up in the chat about it. I've been riled up on screen. I got mad a few things during the stream today. And Judge Whitaker seems to be saying, look, Brady's important. We can't just say it's not. So thank you so much, Garrett. Ms. Kim said, why did Kayla tell us that the guard disclosed the meeting to the defense attorney? So Deputy Brown told Brian Steele that they were having an ex parte meeting, but the details were disclosed by Kayla Bumpus. So kind of both the same thing, but one disclosed the existence of the meeting, the other disclosed more substance of the meeting. So thank you for the super chat and great clarification, because I think that's something that's confusing a lot of people as well. So it's a great opportunity to repeat it out loud. Cassandra Durkin, thanks for the 10, says, isn't this the same as Russ? So similar to the comment from Garrett, it's not up to Love to decide what evidence the defense uses. Exactly that. And I think I pulled this up on screen. I was like pointing to it, but they were talking. But it's one of those things where the state is trying to do everything to run this case like they control all the stops. And that's not the way trials are supposed to be run. But they're doing it anyway. And I'm curious to see what the judge, if anything, she does about it. Because as far as Schardt's concerned, or it was Steele that said it, by doing nothing, you're essentially ratifying the behavior. And that's not good. And Amanon, I don't know if that means New Mexico while we're talking about the Rush trial, but thanks so much for the super chat. You say, why would it matter if Love was in the room? If Copeland was there? Well, what I think what matters is you have Long trying to be your witness, but Long wasn't present for everything. We know that there were moments where Hilton may have been going towards the restroom. Did Long follow her all the way to the bathroom door? Where did this conversation outside happen? If you were, Love kind of worded the questions kind of unclear at first, but if you and Love, if Hilton and Love were not in the room the entire time, Love can't know everything. And if Detective Long wasn't near Hilton, at least close enough to hear some of this conversation, guess what the question is? Is Hilton not now a necessary witness? Who can fill in those blanks? We've already called Kayla. And I'm sure the state sees Kayla as an adverse party, as an adverse witness. You can either call Copeland or you can call Hilton. So who's left? Who's left? And then, yes, so Andrew Hansen, that's crazy. So Trump is apparently talking about YSL, I'm sure. Let me pull the link to it. Because I think AL in the chat had said that Thugger Daily had clipped it. So I'm gonna link. Oh, it's Philip Lewis. So that's a way to get eyes on this trial. So I'm gonna link to it. Joseph Bapp retweeted Philip Lewis tweeting the clip of Donald Trump. I don't know if this is like a channel that would copyright strike me, but it's in the chat if you guys want to check that out. But I imagine he's talking about Fulton County and what's going on in Fulton County. Thanks for becoming a member, D Love, and keep it simple. Paralegal Institute, he done effed up now. Yeah, so Long contradicted himself. I don't think there's any, I think you can be objective about that at this point. He contradicted himself. He contradicted stuff that's on the record in the transcript. So, and then Penny G, the third ex parte and hiding it. Mistrial now. Lottie B, thanks so much for the reminder, you guys. Hit that thumbs up button. It's free 99. I appreciate your super chat. And then Marlena, this is the exact contradiction. We pulled this up while we were live, but I still can't believe it. Part of what he's saying didn't happen was transcribed. So now if you're calling this witness, Love called this witness, and now something that they say, if you take it at face value, it would necessarily mean that the transcript is incorrect. So Love calls a witness, the state calls a witness that is saying the transcript, the very thing that Whitaker wants more than anything else to be able to rely on as the best evidence of something. The state calls a witness that says something contradictory to what's in the transcript. So either the state's witness isn't credible, or you take the state's witness as being credible, and now you have to question the transcript. Bad move, not a great outcome for the state calling Long to the stand. Yeah, there you go. Terrible witness. Thanks so much, Penny G, for the underscoring. Cash Money Cass says, smell, source, motive, evidence, logic, let out. Is this a smell test? We actually have an acronym for it. So the smell test is source, motive, evidence, logic, let out. Matt K seems, yeah. Guys, put a 1 in the chat if you think Judge Whitaker's over this. Matt K, thanks for the 5, says, this judge seems like she's over all of these people and this case. I do think she actually listened to Schardt. I know the chat was like, oh, he's speaking slowly. And I know at one point she's like, some of this stuff is in your motion, but what about the Brady stuff? Because I'm not done considering that yet. She was like, I don't want to rehash the other stuff. I've read that. But what about this part? I got that impression a little bit. Even though the chat was bored with Schardt's slower speaking, I don't think Whitaker was tuning that out. Don't think so. But yeah, put a 1 in the chat if you think she's tired of it. And then Blue Sky says, can you say what the Brady off-record comments? Or can you say were there? Oh, so this actually might relate to 2 factors, right? So you sent this while Long was on the stand if you're watching in real time. So was Long even in earshot to actually have heard what was being said off the record? But to the flip side, people were expecting Kayla to say, look, this is exactly what was said off record. But Kayla might have some caution and some pause about what she wants to come out and volunteer, because on one hand, she was technically representing a client in the time frame of this June 10th ex parte meeting. right? So if people weren't present, if there's a bunch of people in the room, privilege might not apply. But if there's something that may have been said and nobody heard it, maybe she's not sure, maybe she doesn't want to say in case she trips that up. But yeah, I think there were a few times where the judge and Kayla seemed to catch like this might be
Witnesses for the
privileged
state.
territory.
Ready? All right, let's.
We're getting Adam Abbate.
On the stand.
Your Honor, State Counsel Adam Abbate.
All right.
Oh, Abbate.
I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining, we're not used to being the witness. And the direct finish, and I got up to leave, just like all of the lay witnesses who have no clue, and then I felt like an idiot, but oh well, maybe Mr. Abbate won't do that. We'll see.
Maybe that was some humility for Kayla right there. Empathy maybe is the right word.
You're coming up to the witness stand.
He put the glasses on. Swear him in.
Like Mr. Melnick, I'm an officer of the court. He didn't have to swear himself in, but whatever.
All right, let's.
Like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Wow.
Thank you. Good afternoon, Chief Deputy Abbate. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the Chief Deputy of the Major Crimes Division.
All right, and February the.
It's Abbate, and I said Chief Deputy of the Major Crimes Division.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on the Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to, yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think maybe 134. It was his possession of a firearm by a convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
Right. And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183-572?
No, not to my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183-572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order, did it reference some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffrey Williams.
All right. Did the bond order, well, Your Honor, I'd ask the court to take judicial notice of the bond order, which is in this case
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182-134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom. Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker, and the conditions that would be included in it.
Was there any part of that conversation that referenced Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically, and the reference is that Mr. Melnick was all hot about the fact that I was on the call representing as a representative pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks as it related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
And when you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, I guess, negotiate and agree upon bond conditions for. That I think it's 22 SC 182, I think it's 134, and the charges were possession of a firearm by a convicted felon, and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 183572?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess is the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with the ankle monitor?
His location at all times, I suppose.
And are you familiar with
Did we skip the question?
Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I try to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness?
I'm going to sit like him.
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
Special delivery.
And showing what our market states is it too, Your Honor, I don't know if the court had already.
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melnick about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 23rd, excuse me, February 24th of 2023. This is, this is stamped for March 3rd. So there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. I was right.
Avoiding Melnick doesn't sound great for the state.
So this would have been the product of that conversation.
Okay, thank you. All right, that's all that I have with this witness, Your Honor, for right now.
All right, any questions by any of the defense attorneys for this witness? Nope, nope. Ms. Weinstein, Mr. Matthews?
No, Your Honor.
Mr. Harvey, who I can't really see over there in the corner.
I mean, I don't really
See
know what
even
they'd ask
there.
him, though, to be fair. Like,
Is Mr. Harvey over there?
what did he add?
Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State calls Attorney Peter Hurzog.
Okay.
Is this someone from the state? And Stephen, I don't know who has the charge to report Brady violations. I'm surprised we haven't heard that someone has gone to the bar about some of this.
It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I'll have him sworn in.
All right, yes, please swear him.
They're going to make him be sworn in, not the others. Thank you, Stephen.
Raise your right hand. Swear firm testimony you give the truth, you tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat. State your first and last name for the court.
Peter, Peter, Hurzog, Hertzog.
Okay, this is the emails. This is about
TZOG.
some emails sent to his Melnick's admin team.
Would you please, just for the record, state for the court where it is that you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption unit?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2020?
Yeah, I think it was March. I've been here about a year and a half.
Have you ever worked in any unit besides the anti-corruption unit?
I did a short stint where I screen cases and then I cover a court part for a complex, but I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth Pope?
Yes, I believe so.
At any time during those conversations, did you ever in any way seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hilton?
No, not to my recollection. No,
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
no, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think.
Does
we've
that
had
mean much?
contact.
People apparently avoid her.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Love's argument is that
Was the case that you spoke with Mr. Melnick about a case that was in your unit?
Yes, ma'am.
Paul Hurzog's communications don't mean that Love knew that Melnick was representing Copeland. That's the point of this argument.
Anybody in the DA's office to have any communication with Mr. Melnick regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL case?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Your Honor, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court reporter.
I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor.
It could help her say she didn't knowingly do
And I'm going to
this.
show you ask you to take a look at the bottom portion of defendant Williams number 4.
But she has experience, so I don't think that's enough.
And ask you if you recognize or if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you'd like, I can go into more detail.
Yes, please.
So we were investigating as part of anti-corruption. We were investigating.
Without getting into the details of any anti-corruption case
Okay.
at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter. And I don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was Mr. When you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak with Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing, I wrote a check mark, and I'm gonna have to get that off before.
Okay, probably have some white on it. That would work. Is that okay with everybody if on states 4, Ms. Love White felt the check mark she inadvertently wrote on state score, which is why I don't like to ever handle the evidence because I'm constantly taking notes and then I end up writing on the evidence. Is that okay? All right. Thank you.
With the court's permission, I'll do that after Mr. Schardt has had an opportunity.
Go ahead, Mr. Schardt.
Good afternoon.
Good afternoon.
So from what I understand, March 2023, you are working for the DA's office in the anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm not building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he is a witness.
Yes, he would have been a witness.
And he's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witnesses.
Sustained.
What kind of case is this?
Objection as to the.
Well, can we just leave that it's an anti-corruption type case?
I ask, was Mr. Copeland the alleged victim?
No.
So he's a witness.
Well, it's,
Your Honor.
Yes. Do we need a bench conference? Okay.
Oh boy. Yeah, I mean, he confirmed that Melnick was attorney of record less than a year ago. Or maybe about, well, we're in August, so about a year ago. And then going back to the clip we watched with DK that I'm Not a Lawyer But had pulled, Garrett said, what the heck? So DK had use immunity. Did the defense know? So in that clip, it sounded like Hilton said we're going to give him, we will give him use immunity. And it was mumbled. So I'm sure that might have been disclosed, but the question is, were there other meetings with DK that the defense may not have heard about, been told about, that the state did not disclose to the defense? It's eerily similar, that type of questioning and how Glanville didn't want it to keep going. Hilton saying, oh, we'll give him immunity if he can't testify to certain things. Because what does that mean? We want him to be able to testify to certain things. Eerily similar. Miss AB with the great recall here. Remember all the pushback to even get a copy of the transcripts. That in itself took forever. Yep, so we're barely even getting the transcript turned over. In fact, we probably got it turned over just as a CYA move to cover your butt. And still, that doesn't fix the problem of someone having the right to be present at a critical stage of their own trial when they're the defendant. So thank you so much, Miss AB. Shout out to you. You're always supporting this channel, and I appreciate that a lot. And Atkins is running up to the stand with a phone. Maybe we're looking for emails or a text. Innocent bystander with the 50. Thank you so much. Innocent bystander says, does the State Bar of Georgia have the ability to investigate the potential unethical behavior by the state, or do formal charges by the defense have to be brought to the bar for them to act? See, and that's what I'm not exactly clear on. A bar complaint, someone's client could go file a bar complaint against them. A bar complaint could come from a member of the public. But whether or not the bar actually takes them seriously could be a different question. So I don't know if the State Bar of Georgia would just have this sua sponte is the term I'm thinking of their own accord, without being prompted, ability to go in and investigate on their own. However, in Fulton County, there's recently been established, and there's a bunch of orders trying to block it.
The earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Schardt relaying the substance of the bench conference, or if each of you wants to try to come up and gather around, or
tech problems.
Since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently you need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. But one of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, then you can let me know and I can say, well, here's my take on what happened. Okay, so Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right, how about you, Mr. Huey? All right, thank you. Mr. Williams? Okay. Who else do we have? Mr. Stillwell, you okay with that? All right, and then Mr. Ryan, you okay with that? All right, thank you. Appreciate it.
Weinstein just gets up there and puts his hands on his hips. All right, so the court is muted. So back to Innocent Bystander channel. I pulled up your channel and you have 4,000 subscribers, but I don't see content. So I asked that question in the chat. Do you use another platform? Because Innocent Bystander channel sounds interesting. And I see that you had subscribers, so maybe you do lives and then you don't let them live up as replays. But let me know what you do as your channel. But yeah, so before they started talking, I was mentioning that similar to the Judicial Commission's Qualifications Commission, in Georgia, they've recently established one that looks at prosecutors. But there's been a lot of pushback that's kind of in the open, although it's been established. There's a lot of action trying to block them from being able to do anything. And Whitaker was actually one of the judges that disagreed with different DAs. I think it was 5 different DAs from the state of Georgia that tried to oppose this formation of this Prosecutors Qualifications Commission. Whitaker said, why are you against them forming this? Maybe it's something worth looking at in another video. I wouldn't be surprised if somebody else has done a video looking at it already. I've read the articles. But probably worth talking about. Maybe I'll do a separate standalone video this weekend on it. But I think they would have the power, at least until challenged while there's pushback against their entire formation, to possibly do their own investigation and put a report together, just like the Judicial Qualifications Commission does. So that might be the better answer than the bar. But I wouldn't be surprised if we see bar complaints filed maybe by Mr. Melnick against some of the lawyers on the state. And it looks like we're receding a little bit. I think Weinstein may have seen that, but I'll double check and tag him in that for sure. Thanks, Blue-Eyed Hillbilly. Hey, that DK post is just like walk down memory lane, deja vu. And Erica Roberts, look at page 51, line 17. So let me pull that up. And they might start talking. It looks like they're getting ready to talk again. So I'll bookmark this. We'll come back to this. And I'm surprised they're still quiet. It's not me. There we go.
And do any of the defendants have any questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Hurzog,
Spin your mic towards you.
The anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on?
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail. Mr.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel
Okay.
on any case or was recently represented by counsel.
Law School
Okay,
101.
so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation, in the
I
limited
understand.
scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
That was a great
Does anybody else
question.
have questions for Mr.
State's own
Hurzog?
witness.
All right.
Oh, I contact the
No.
attorney because it's ethical to do that instead of talking to the witness directly.
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. With the court, Mr. Williams has no objection. And if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but yeah, that's valid. Let's find that out. So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still.
How are you?
Good, how are you?
I'll let you know. Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
They're making him an expert witness.
Is the question whether I feel comfortable?
Yeah, do you understand Brady and its progeny, what it includes?
Yes.
Okay. And I didn't mean that to be insulting at all. Just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland. Was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay, and I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before the Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay, all right, thank you, Your Honor.
Okay. All right, anybody else? Mr. Williams? Okay, anybody? All right. Any redirect by the state? No, Your Honor. All right, thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
I was Can the court allow, Mr. Atkins to go outside and check?
Sure. While we're waiting on finding that out, y'all were, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting.
Because we didn't get anything else done today. Do you think she planned to
Nothing.
spend today this way?
Huh?
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within.
Didn't we know that?
134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on
29.
June 29th, 2023, and I'll take judicial
Whitaker
notice
mentioned this
of
earlier.
that.
Who knows? I don't know, guys. I don't have an explanation. But I remember that, so maybe Love was distracted when she said it. Because I know when I'm flustered, I might not remember everything happening around me.
All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay,
sorry, he said 40 minutes, he corrected.
okay.
And so, rather than.
So they want to call Abigail Potter.
We're gonna do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other, thing that I was looking at was I'm obtaining a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently
He not going to show up?
in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served him, since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the, on June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that
Critical
claim.
stage.
Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not
+1
being
for sure.
standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay, and Your Honor, as I obtained for the court that those final two pieces of information.
Okay.
I'd ask for the court's brief indulgence while I get the certificate of service and the date that he was served.
Okay.
That because it was filed on.
All right. I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on. Okay, that's what we're getting today.
Okay. It's, and that's in which case? This
22.
YSL case?
Yes.
Okay. So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay. Without
The exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she gonna be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Okay.
I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm gonna.
All right. Would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
She is. She's
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Melnick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Adkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Your Honor, I will speak with Mr. Schardt.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday, before we had all of our more explosive motions put before the court, that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe two items that you thought you could work out everything, and there were two items that were still kind of in dispute.
Might have been Hilton.
That may have been Ms. Hilton.
It might have been. I don't know.
Who's gone?
Just to get him.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
This is a great summary of the day, Sapphire.
Step outside the courtroom for a brief 5 or 7 minutes.
To line up Miss Potter.
To line up Miss Potter, to.
They're gonna Zoom her
and to
now.
speak with another member of our office.
Okay, so we will take another break and be back whenever you let a deputy know that you're ready. Okay, which hopefully won't be more than 10 minutes. All right.
Hearing brief 5 to 7 just stressed me out. But Sapphire Ridge News, good to see you. This is a great summary of the day. We got back from lunch, and Love keeps calling witnesses that prove Melnick was Copeland's attorney and is Copeland's attorney. So that's where we've been at since like 2 o'clock Eastern. And then Erica Roberts, that transcript that Erica was referencing, I had pulled that up and then the court came back. But that was a recall over to Mr. Copeland. I did these crimes. I'm telling you that. And then Hilton saying, okay, I don't know what you're talking about, but... And then Kayla says, are you saying you want to get up there on the stand and say something? And then Kayla doesn't, and then Kenneth Copeland doesn't respond. Kayla says, did we find out if he could talk to his family? No. And then there's a pause. So, there you go. They talk about, Hilton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. So, I don't know. I think the ultimate conclusion is nobody can be entirely aware of what was captured on the record and what wasn't captured on the record, and thus we don't know what was actually said or what wasn't said within earshot of the state. Especially you have Long tripping himself up about, oh, I didn't hear anything about the Infiniti, but then he apparently did. I just think there's no answer. And guys, we just heard Whitaker about 4 or 5 minutes ago say, well, I think there's cause. I think there's standing for the defense to be concerned that the defendants weren't present during what could be a critical stage of the trial. I still have to make a determination as to whether or not I think these ex parte meetings were a critical stage of the trial. But that problem hasn't been fixed. Meaning, the transcript releasing it doesn't fix that problem. That's a big +1 for Schardt to have underscored that today. And she was tuned in, she leaned in when he was making that argument. But yeah, the transcript's not going to tell us everything we need to know. It's just not. Shea Beard, thanks so much for the 10, says, initially, Ms. Love alerted the court she was seeking a, quote, remedy in the law that she loved so much for what she'd observed. What was the remedy? Coercion of the witness? That's not law. Yeah, so what was that weekend homework from that June 7th transcript? What was the weekend homework? That we've got to find some remedy because, I love this law so much. This law that, Judge Whitaker has to give us reminders and nudge us on things that are kind of law school 101. What is this thing in the law that Love loves so much? And when did she bring that thing to the attention of Judge Glanville? Because we don't have that in the start of the June 10th transcript either. What was it? Where is it? Great question, and thanks for the 10. Sheeny Beanie, this made me laugh. And guys, you are welcome to talk about clothing. Be careful about personal insights, especially with curse words, though, because YouTube, first of all, the YouTube AI will go crazy and think this whole video is about something that it's not. But the curse words, I do think YouTube frowns on that. But this made me laugh so hard. Chief Deputy Sassy Pants, Sheeny Beanie, I laughed so hard when you submitted this comment. What was going on when Adam Abbate, or Abbate? I forget how to pronounce. I think it's Abbate. Adam Abbate took the stand. He was about to be sworn in, and he's like, why are you swearing me in? I'm also an officer of the court. Just like Melnick. Melnick's also an officer of the court, and you didn't swear him in. So why do I need to be sworn in? All right, whatever. So I understand the sass, but it was hilarious that right there, when you get up right there, I think if the jury was in the room, maybe that wouldn't have gone down that way. But with the jury being gone, you know, let the sass come out. Like, why are you insisting I be sworn in when I'm an officer of the court who has a duty to tell the truth to the tribunal? And you didn't ask the same for Melnick, who I'm about to get on the stand and tell you how hot he was. So, thank you so much. JL says, can Melnick represent Woody after this happens? So I think the issue with Melnick continuing to represent Woody, and we heard Kayla underscore this, that was a really important thing that Kayla underscored. Melnick said, look, I need you to stand in. There might be an issue of this witness trying to plead the fifth when he gets on the stand. And if that's the case, then we need to be discharged. We can't represent him. Because you can't just know that your client is going to do that and not tell the court and then let them go up on the stand anyway. So in that regard, regardless of what we're hearing today, back then, even on that Friday and then that Monday, even more so, Melnick probably saw it as a problem to continue his representation of Kenneth Copeland because it could have meant he was allowing a witness to go on the stand who wouldn't be telling the truth. And the judge was aware that that was a possibility and helped the state make sure they could secure quote-unquote truthful testimony as long as it wasn't a bold-faced whopper. So do with that as you will, but remember, an attorney is not supposed to produce a witness for the stand, put them on the stand, and know that they're going to lie. So, can he? I would say maybe, if he doesn't think that there's an ethics issue. But I would say because of him believing and having reason to believe that Woody was going to go up on the stand and either plead the fifth or not tell the truth, ethically, he's probably right in underscoring, I need to be discharged as his attorney. I need to withdraw. I can't represent a witness that's doing this. So, great question. I think the answer applies to a different context than what you may have been thinking of. And then, Mimi, thanks for the 2. That was so nice of you. And yeah, Marlena Mack. Here we go again with the truth. You're noticing all the truth here. He said he spoke to her. She knew. We got that out of Melnick earlier today. Melnick said he spoke to Love directly. And it's kind of futile to underscore that. Love keeps trying to bring up all these witnesses, and you guys are catching it in the chat. Sapphire Ridge News caught it. The state's trying to call up all these witnesses as if to say, well, other people in the DA's office may have been aware and may have been contacting Melnick. But I personally, Love, wasn't the one that made that contact, and I didn't explicitly direct anyone to make contact with Melnick in relation to Kenneth Copeland. So I still don't have an awareness. I didn't know. I didn't know that he was representing Kenneth Copeland. But I don't know if that will hold water. She's not stupid. She's in charge of difficult witnesses. That's her specialty as a chief deputy district attorney. And she's just trying to sow doubt, some doubt. And remember, what Judge Whitaker has to consider, this might be an extreme consideration, but technically it's a preponderance of the evidence standard. She might want to lean a little bit within the margin, a little bit more in favor of the state, because it is a very big ask to disqualify prosecutors. But at the same time, she doesn't need to have it in front of her that is proven beyond a reasonable doubt that Love didn't know. The reasonable expectation would be that Love would have known. And it doesn't matter if she ordered someone to directly contact Kenneth, or to not. It doesn't matter that she didn't make Peter Hurzog, send that correspondence or reach out to Melnick. But the fact is, she could have just looked on the record. She works in the same court where Copeland has had cases. She could have just looked. She didn't even inquire. Why not? Why not? And another great point from Ian that I had started earlier, brought it up on the screen, but Ian asks, then why was it important that Kayla Bumpus, really any attorney stand-in, replace Melnick if Melnick was not the attorney of record? Because remember, the state was flipping their lid that Melnick wouldn't be available on Monday. And they need somebody to stand in. So, suddenly it mattered who was going to be there to represent. Garrett's theory here is that Love is doing all of this, calling these witnesses to try to protect her bar card. Brady problem remains. ICIV. I wanted to get to this earlier. So ICIV, or maybe ICIV 54, says this case went from YSL on the stand to being about the conduct of the prosecution. Eerily a reminder of the Trump v. Georgia case. What is going on in Georgia? Now, if you guys remember, if you watch the disqualification hearing, you might think Abbate is a familiar face. Well, that's why, because he was sitting at the state's table most of those days. That's why he's a familiar face. So, what do you guys think about this kind of double look into two different cases? I saw some comparisons that Long's demeanor on the stand was similar to Terrence Bradley when Terrence Bradley had to take the witness stand in the disqualification hearings for Fani Willis. I mean, what do you think about this? We have two major RICO cases that, even if you look at them in a vacuum, outside the context of the case facts itself, where we've had attorneys on the stand being questioned, giving testimony, attorneys versus attorneys sparring on the courtroom floor, in two major RICO cases. They are becoming trials within a trial in a way. I would argue that the Fani Willis disqualification was formally that. It was formally that. A trial within a trial for the disqualification. This isn't an official disqualification hearing, but it's almost like we've spent all day teeing up to that and Love trying to prevent it from happening, just for Schardt to get up there and say, look, we need this remedy of disqualification. Like, what else could be the remedy? So think about that with these two. Trump v. Georgia, and then the state v. Georgia, v. YSL. Pretty interesting overlaps in terms of these. What did Whitaker call them? She didn't call them asides. She didn't call them parallel. She called it something. But these major RICO cases keep getting off track. And maybe that's strategic for the defense, right? To be fair, that's a strategy for the defense to pursue, right? One of the things we can do for our client, to try to advocate for our clients. Try to get the state disqualified. And maybe make them kick it back to the indictment stage. Who knows? But at the same time, we're all tuned in on this YSL trial specifically. Do you think there's merits to the defense wanting to disqualify at least Love and Hilton? Here, Schardt said the state. But in the previous motions, I'm thinking of the motion from Brian Steele, it really focused on Love and Hilton. It didn't really go after Atkins or the whole DA's office. It went after Love and Hilton. What do you think? What do you think? King Divine, thanks so much for the 5. DK was different because he took a plea deal and Woody didn't take a plea deal. At least not in this case. And it's interesting because at the same time, Woody didn't take a plea, but they were still trying to hold time over his head, right? Holding him in contempt for a significant amount of time. Something that would be similar to if you take a plea deal and maybe you need to do XYZ numbers of weeks, months, maybe a year. What he was facing because of the way they were threatening him with contempt and how long they said this trial and the trial for the remaining co-defendants would go on, almost looks like they were putting him up against a plea deal. Like you either get up there, or if you want to get out of having to go to trial. I'm putting that in quotes because he's the witness. He's not the party on trial. But they almost treated him like he was. You either do it, or you could face this time. Choose which one you want. So it's almost like they turned his plea deal, his contempt, possible contempt, into a strategic plea deal. So definitely a distinction, literally. But kind of interesting when you think of practically how they were positioning his options to him. So thank you so much. Black Butterfly, if you didn't get it, it's takeontrending@gmail.com. I haven't checked it today, sorry. But that is my email. I just put it in the chat so you can see how it's spelled rather than try to decipher how I'm saying it on the screen. But Black Butterfly is saying, similar to DK, I have one on Tick to send. Love was signaling to Tick to say no. So that'll be interesting to look at. I will pop that up, especially as we wind down. It looks like the court will probably go until 5:30 or 6 because they're going to try to get Abigail Potter up and out of there, get her statement through Zoom today. I had bookmarked this from Arbiko. Good to see you. You're one of like long time back in the day, it seems like, with the other cases here on this channel. So good to see you here. Tony Angel says, not sure if this is a good or bad day for Hilton to be missing. Eek. If I was Hilton, I would not want to be there, but at the same time, I don't know. I hopefully if I was Hilton this whole time, I wouldn't be in this position where this whole day would be happening. Do you guys think Hilton's enjoying her vacation? Kay Deloach, thanks so much. Kay Deloach says, Judge has now seen prosecutors in action. And I think she gave us a very pointed statement. We should all know about Brady. And also, while I'm still deciding on certain matters, like, you know, maybe their right to be present, the defendant's right to be present during critical stages, I think they have standing. I haven't ruled, but I think they have enough for sure. Felice Robinson, just a $10 support. Thank you so much. That's so nice of you. B. Irving, and this is a theory I see floated around. I don't write anything off. What do you guys think? B says, this case is because Big Nut was Fonny's boyfriend. There's some rumors and speculation. But that's all I've got. You know, I don't have it in a court filing. So I haven't read anything about it on the channel. But I've heard the speculation. So what do you guys think?
All right, were you able to get Ms. Potter?
So Judge, my request is that the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
We're missing some defendants.
Oh.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on. I should have looked. There are some empty chairs.
Oh, the defendants aren't in the room. Okay. Bryson Medlock for $10, thanks so much, says, didn't Love complain about Melnick cursing at her in an email? Yeah, and she read that today, but she said F you as like a censorship, to censor it while she read it in open court. So didn't Love complain about Melnick cursing at her in an email? What was the reason for that correspondence if he's not representing Woody? I guess Love is trying to say that she was obviously aware by Friday that Melnick was representing Woody, but that she didn't know as of Thursday night, Thursday evening, when that final consideration and that motion was being drafted to get this immunity order in place. She's saying that that's essentially when she became aware, because Melnick inserted himself on Thursday evening by emailing. And then on Friday, once Melnick had gotten wind that it was a use immunity type of deal, that may or may not, he wouldn't even know. And he was careful not to imply anything on the stand about his client, that he might not know. He hasn't had a chance to review everything. If use immunity would cover everything that Woody could be, you know, a perpetrator for, a suspect for, if people decide to investigate. So, that Friday email was definitely, Love was pretending that she only found out. And let me clarify. If she really didn't find out until that Thursday when Melnick inserted himself, my way of covering up for myself, if I really didn't know something, my reaction wouldn't be, oh, well, he inserted himself. My reaction would be like, oh, crap, I didn't know. I didn't know. Like, we'd looked, we didn't see a notice of appearance or something like that. My response wouldn't be,
everybody all right?
He injected himself. But thank you for the 10 there.
The state is asking if the court will allow us an opportunity to respond to the Ford case. Ford Motor Company case that we were provided today, and in making our final argument, and to allow us, if we decide the need to call ADA Potter, the main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail
The third
Potter,
time.
and had the three names.
Oh, okay. So you may not need her after all, then
You're not?
that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I have taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not.
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it, sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
How's the jury going
And
to come
thank
back on
you. So
Wednesday?
That's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
All of that just to say, never mind. We're not going to call them. And we don't know if we want to call somebody else. Why would you not know if you want to call somebody else that could be a witness? You already know who was present or who may have been in correspondence. Are you just trying to double check and think about what they would say?
The certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24-5-507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean. And if so, we can make a copy of it and you can do whatever you want with it from there.
Okay.
Is that it?
It is. It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
All right. And so what's their argument you wanted to make about that? Or just?
Just that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
All right.
Make the argument later.
Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument
still
there
wants
might
to be on
be
Wednesday.
as to either of those issues. What I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then just maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
He's looking for a remedy to
No,
fix the
that's
critical
not
stage
right.
presence.
In the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
It's directly in the way that he did on.
Okay. Okay. All right. But we need to make some progress into the, I mean, I am still considering and working through Mr. Schart's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done, that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame.
Drop your predictions in the
I want
chat.
us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, you know, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, you know, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And Your Honor, we did get last night, speaking
Yeah.
We got last night from Mr. Schardt, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us to address those. So, and I believe that Mr. Schardt, he can again correct me if I'm wrong, said that he could go through that was for I believe the August 2017 interview, a proffer from Mr. Zachary. And there's an earlier one that I think he said he's going to go through and. Okay, he said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday, where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And
He'll be ready.
if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So, Your Honor, just now, Your Honor referenced if Mr. Copeland chooses to do something different than what he chose to do last time. With respect to testify, I'm assuming the court means plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean.
That's what I understand.
Okay. All right, well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter, or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not, now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone.
I think
if somebody else thinks differently, y'all let me know that right now. Silence.
They're going to have
Mr.
arguments
Steele.
tomorrow. Here we go,
believe
Steele.
Anything before Mr. Weinstein filed the first motion to recuse, I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed, so I don't want to wipe out Mr. Copeland's testimony on
Okay.
the 10th,
All right.
11th, or part of the
All right, which is why I need y'all to get together on it and let's tackle that tomorrow. The nitty gritty of it, okay? All right, so that means y'all have to do that tonight if you haven't already done it. All right, anything else before we break for the evening? One more thing.
This is the thing. Every time the judge tries to address one issue, it ping-pongs. It renews another issue.
All right, so it's my understanding that other than the transcript of June 12th everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Miss Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forward it to you, or she'll forward it directly. So y'all should have that very shortly. All right, anything else before I bid y'all adieu for the day?
The closed captions are always so wrong.
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because
She doesn't know what she's deciding. She's really thinking about
we
it.
got things done today, but we didn't get any evidentiary, you know, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days, and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.
Are we though? Are we actually adjourned for the day? Are we adjourned? I think it would be more sensible, I get the delays, but just do it Monday then. But guys, we're going to leave this open because we're going to see if the screen comes back, because sometimes it does. And now we were going to have to refresh Law and Crime to see if a second stream becomes available. But I just feel like every time Whitaker tries to find a solution, okay, we can solve the critical stage, defendants being present for every critical stage by rewinding it all the way, starting over. If we need to reconsider this immunity order, we can have the defendants be present for it. But then that flips back to the other issue where, Harvey harped on this, Doug Weinstein's harped on this, Adams and Steele have harped on this. Well, you can't just tell the jury to forget everything, on one hand. And two, we're going to see these arguments tomorrow, I'm sure. We don't agree to strike all of his testimony from before June 12th. We want to use some of that stuff. It was good for us. So as soon as she tried to come up with one possible, I think she was quick on her feet to think of that type of solution, but it reopened the other can of worms again. It's like we're just putting worms over here, and we're putting them back over here, and the worms are crawling in the middle. It's just like cans of worms that can't be closed back up. You can't, it's just too many issues. How do you reconcile them? So I feel like we're going to see some motions. It's crazy the state and the defense didn't get together on that one, the detective jail calls. But who knows? I do want to say, so Anthony Dobson, do I think that DA Love will actually be disqualified? So Love has to respond. You heard her. I think that's what she was asking for, was a chance to respond. That might be what she has to do tonight, because it seems like Whitaker wants to... It seems like she wanted all the pieces in place to close out some of these motions, especially Schardt's. Weinstein still has one standing open. But this renewed request, okay, so nothing starting. We're going to close this down. And then I don't know if we need the transcript up. I'll keep this readily available in case you guys want to revisit anything in the transcript. But it seems like Love needs to respond to this disqualification issue. And of course, we'll read her response if she turns in something in writing. Do I think it'll actually get to that level? I don't know. Everything in my head is just like, I see why it could warrant disqualification, but will it? So thank you so much for the super chat. Fletch for 5 says, if I was a prosecutor, would you rather be personally disqualified on a case for misconduct or have your case dismissed with prejudice? Oh, dismissed with prejudice. Well, if the dismissal was with prejudice because of prosecutorial misconduct, I don't know. Maybe I'd rather be disqualified because of the appearance of an issue without a factual finding that there was an actual issue. I don't know. That's a gray area. It's a great question. But I think if you get your case dismissed with prejudice based on the grounds of prosecutorial misconduct, that's essentially a finding of prosecutorial misconduct, and you just took a big L for the case. But if you're personally disqualified, it could just be because of an appearance without the necessary factual finding that it rose to a level that this actually happened. So, I don't know. I think I'd rather the former option here. And again, hopefully I would like to think that I wouldn't find myself in this type of situation. And Garrett, hold on, Garrett saying Zoom work here in Mexico, asking for friend Hilton. Yeah, we think she went to where do you guys think she went to vacation? Now let's not play that because they're going to think we're trying to find her, and we're not. Cash Money Cass says, I'm a court sketch artist. That's really cool. And even I couldn't erase these mistakes. That's awesome. Oh my gosh. I would love, if you're open to it, to see some of your work if you wanted to share. I had starred this. Smilin', I've seen you in other chats. I think I've seen you in the chat maybe for Courtney Clenny stuff. So you've been around for a long time. And I saw this comment. I thought it was so sweet. I think I'd be overwhelmed by 100K followers because I have trouble keeping up with the chat as it is. And I really like to. I really like to be able to see what you guys are saying. I feel like I can't have a two-way conversation all the time anymore because it gets lost. But right now I think we're at a great point where I can see what you guys are saying and kind of get the consensus still. So it's so sweet of you to say that, but I think 100K would overwhelm me. I'd feel like out of touch with everybody. Miss B, the jury members are never coming back. So not Wednesday, not Thursday, not Monday. They're just never coming back. Tina Haskenhoff with the $4.99. Thanks so much. I love your picture. Is that your cat in a box? That's great. Robert with the 20. Thank you so much. Robert says, RICO trials are too complicated for the Fulton County prosecutors. They would be better served prosecuting individual indictments. High-powered defense lawyers are better prepared than these poorly trained in RICO prosecutors. Yeah, and I just, they're, from the perspective of the county, one of the key platforms for the district attorney's race was, getting the crime rate down, getting through this backlog of cases. Once we got Fani Willis into office, she was doing PowerPoint presentations for her budget to make sure she had the budget to prosecute certain cases like this. And then when you see how it's playing out, it's just kind of like, is this the way to do it? Is this the way to do it? Whereas if you pursue something on an individual level, sure, you might not be able to prosecute everybody you're trying to prosecute because that umbrella that charging under RICO gives you falls away. But for the people that have serious crimes that they're culpable for as individuals and not just, under some association with a gang or under the RICO charge, if you can prosecute those individuals individually for those crimes, you might have better investigative work, you might put your case together better, and you might get the correct outcome, the correct disposition for a case. A conviction, if you're able to prove that person guilty beyond a reasonable doubt, or maybe you don't get to that length because you find out along the way, maybe it wasn't this person, and a conviction shouldn't be your goal here. Considering that as a one-off consideration seems like less risk, less of an investment. Because what happens when people invest themselves into something? They start something. Psychologically, we don't want to scrap everything and go back to the drawing board. It's just not how the human brain is wired. So when you say you start on all of these things, cases for 26 co-defendants, and it's starting to fall off the rails, it's even harder to go back to the drawing board and start all over. So just from a efficiency on one hand, but also playing into how human nature works, human psychology, prosecutors might be in a better position to really follow through the path in pursuit of justice if they're only thinking about one project at a time rather than one major project that's really a bunch of projects lumped into one. Great food for thought. Always glad to see you, Robert. And then Bryson here says, so the state wanted to admit all of Woody's lies except for the one where he did it all. Just forget about it, right? The immunity deal, what is going on? And I'd be interested to see, I think what, you might have heard me comment there, I think Whitaker is setting the stage for the defense to argue about this immunity order tomorrow. She's letting them know I'm focusing on this paragraph 11. So if you guys want to challenge this, if you guys want to make your arguments tomorrow, she was just kind of opining. It was in dicta. She wasn't saying I'm not going to consider any of this stuff at all, or I'm fine with paragraph 11. She's saying, here's what I was thinking about it. And tomorrow you guys are going to make your arguments. So this is your time to think and decide what you want to argue tomorrow. Same thing with I don't think she was saying we're going to start back from the beginning with Kenneth Copeland's testimony. She was saying one possible solution. Here's how that could play out. So she's kind of setting the stage for the arguments that someone could levy against her solutions tomorrow. And so I really wouldn't have a accurate judgment until I see the counter arguments and how she responds to them. And the pleas, yeah, I think you're right, Sheila's Fantasy. Should revisit potential pleas, thinking the judge is trying hard to convince them to take it out of her hands. Yes, that way she doesn't feel like they're just locked up sitting there and that's a constitutional violation if they're out on bond. And then, hold on, wait, is Kayla, you guys are saying Kayla? Okay. And I think we're all caught up, so Kayla, last time I checked, you didn't have like a redirect setup or anything. So you need to turn that setting on. It's in like your YouTube channel settings under the community tab. Let me pull Kayla's channel, at least drop it in the chat. So that's Kayla's channel there. And then, so if you guys want to check that out. Okay, it's loading on my screen. I tried to share it. I'm getting the spinning circle of death and it's saying that it didn't send. So, okay, now it's showing in the chat, but it's saying I didn't send it. So, can you guys confirm if you saw the channel link dropped? So you guys can head over there, but I think we were all caught up, you guys. So, I'm going to keep an eye out for motions. Double check one last time. I mean, the attorneys have all been in the courtroom today. I don't think they were, we had Max Schardt run out of the office the other day and file that renewed motion midday on Friday. But I don't think we get that every day with significant motions. But I'll double check real quick and set the expectation that if filings come out, I'll hop on a live. So make sure you hit the notification bell if you want to get a notification to be able to join us live. And then nothing more, you guys. I'm just seeing, you know, the stuff on the screen here was orders that we already looked at last week. So nothing new. But yeah. And I'm blocking it, but it was really right here. So, all right, you guys. I want to say a big thank you to our mods, Jason, Ghost, Drea. You've been holding it down all day in the chat. You guys, throw a balloon, throw a party hat, the party popper in the chat. It's Drea's birthday this week. We're going to be celebrating all week. Thank you so much to the mods and the whole chat for everything all day. Might see you again later this evening. So I'm going to jump out of here and get some work done. Check my porch to see if the window is holding up because the screen fell out from the screen came detached, blowing in the wind. So I want to make sure that's still fixed. I don't want any bugs getting in my house. Not a fan. But yeah, thank you so much, you guys. Look at that. We're partying here for Drea. Drea, it's always a pleasure. I'm so glad that you've been here. Same to you, Jason. And if Casper Ghost, if you're still here, there you are. And thank you for putting the channel link. Thank you so much. And then, oh, one last one. So thank you, Mark Lyon. You're sneaking in here. Miss Bumpus says, you really need to shut up from this point forward about the case. Go into hiding, save what's left of your career, and protect yourself. And this might be a prompt to start. If she's going to go live soon, if she's still in the chat, this might be the prompt. We might hear her hash out, like, I'm going to decide to do this or I'm not. And here's my reasoning why. So you guys, I appreciate you so much for all of your insights all day. You guys have a great one. Take care.